Good morning, everybody. Nothing like a little tech glitching to start off a beautiful Wednesday. Oh, that's why we needed that extra hour. We had to be on our A game to get the problem sorted, but here we are, guys. No worries. Nothing that we can't just manage and get through. Well, we're busy watching that spinning fan this morning. To be honest, I didn't actually get the extra hour. Um, I had very high aspirations, as I think we often do, but, sometimes you just wake up when you wake up. And so it is what it is, but it did give me a chance to kind of go back through my notes from yesterday and start thinking a little bit about what we might be anticipating today once we get to cross-examination. Sometimes it's a little hard to take things in real time, particularly when you're dealing with just a degree of absurdity that is maybe a little bit hard to just register all of it. And so, you need to take some time sometimes and let things simmer a little bit. I have a really important question, and I don't know if Gray Space is in our chat yet. Haven't seen him yet, but maybe Gray Space is going to be able to answer this. If Gray Space shows up at some point today, guys, please yell at him that I need an answer to this question, because I've been trying to sort out how the infotainment and the text stream clocks are tied together. So I've gone back through everything to try to make as much sense out of what I'm being told as possible, where this information is coming from, how it's being put together and analyzed, and so forth. And so what I understand, we have these two separate systems. We have the text stream system and we have the infotainment system. Completely separate, not connected to each other. The infotainment system is just what's running your video screens and monitors and things like that. The text stream is collecting diagnostic data, for lack of a better way to put it. And so what happens, if I understand this correctly, you turn on your car. You turn on your car. The infotainment system, after about a 3-second lag or so on average, the infotainment system logs the time. And then text stream does not log the time, but it logs the key cycle. And then it starts this running clock that we've heard about, like a stopwatch. It just runs an internal clock from the time of the engine starting until the engine is turned back off. So with the text stream, you just identify where events occurred in the course of that key cycle, but we don't have an actual timestamp on the key cycle itself in text stream. The timestamp comes from the infotainment system. So my question is, how do they know what key cycle corresponds with the time being recorded on the infotainment system? How do they know that those things correspond? Do they? Do they know that? Or are they just matching it up and saying it kind of works? I'm really not clear on that. If y'all see Gray Space out there, please ask, because he seems to know a lot about this topic with the vehicle data and interpreting it and so forth. And I can't find anything that's been said so far, either by Welcher or by Burgess, that tells me how are these two systems connected to each other. How have they related to each other, so that we can infer that the running clock in text stream that identifies these trigger events is related to a specific timestamp from the infotainment system. Does the infotainment system track the trigger event? Like how? I don't know. I haven't been told. It seems like I should know this. I should have been told. So this really gets to what is, the core problem with this witness and this particular expert. It should be easy to understand. That's the whole point of bringing in an expert is to make something that is complicated and technical easy to understand. And there's just so many questions that I don't have answers to. It makes it difficult for me to anticipate where you're going to go with Cross because Alessi has access to the answers, right? Alessi has his whole expert crew that he gets to go confer with. He has the whole data set. He's done all the research. Alessi already knows this. So he already knows the answer to a lot of these questions that I have. That I'm just like, hey, I don't see how this has been communicated. I'm not really seeing how this isn't just a bit of a guess still, as opposed to some kind of systematic analysis. So, for example, Alessi and his experts, they have the entire body of the data from Karen's vehicle. And that could be very, very helpful. That could be something that we could hear about in cross-examination because these trigger events are supposed to be based on a pattern, right? We know Alessi loves himself some pattern recognition. It really is what humans are made to do. Brains are made to do that. Even where they don't exist, we'll find a way to perceive patterns. And if I recall correctly, there was a question to Shannon Burgess that Alessi had something about 30 trigger events over 9 months of the SUV's history, something like that. I could be off on the exact numbers, but it was something like that because it led him to ask that question about, would you say the Lexus SUV is trigger happy? Is it trigger happy? 30 trigger events in 9 months. So that means they have quite a few points of comparison for when it triggers, what causes it to trigger, why it triggers, and so forth. And that could be really important in this case because we would expect this particular event to be quite unusual, right? You don't back into a pedestrian at 24 miles an hour every single day. You don't register that trigger, repeatedly. It's going to be a very unique event that the Commonwealth is occurring. So you'd expect a pretty unique pattern of how that's picked up in the vehicle data system. So whether that is in fact the case might be interesting. I did find it noticeable that both of these trigger events on this key cycle, 1162-1, according to Dr. Welcher, it seems that they are both triggered by the same phenomenon. And the same phenomenon that's triggering both of them is the car being in reverse and then having the high accelerator ratio. The throttle is up. So I wonder if that's like a routine thing for the car to register. How many trigger events are based on being in reverse with a high throttle? I've been thinking about that a lot too. The being in reverse with the high throttle. Dr. Welcher says got up to 24 miles an hour, still accelerating at the end, throttle still at 74%. We're at like 3,600 RPMs. I screenshot his data from that, but it's not super visible. I got to go find it now because I had to shut everything down with our tech issue. Anyway, I'm not totally sure it's worth sharing, but it's got the data on it. Yeah, I don't have that piece of it. So anyway, I'm not going to share that. But yeah, it's up to like 3,000 RPMs or something like that, 24 miles an hour. Okay. I'm thinking about this because I'm thinking about the gearing. Thinking about the gearing of the car. And the thing is that reverse on a car, it's geared a lot like first. It's geared a lot like first because you are going through your initial acceleration. You need high torque to be able to take this 6,000-pound vehicle from being perfectly still to, running contrary to the laws of nature and gravity and being in movement. So getting from full stop into motion, heavy vehicle, high torque. So it's a lot like being in first. And when you're in first, I'm just thinking about this, how fast do you get and how high do your RPMs get? And I'm having a hard time seeing these things match up. 24 miles an hour in reverse, 3,500 RPMs. That to me, it doesn't seem right. That doesn't seem right. So my own car, granted, not a SUV, little light sports car, barely over 1,000 pounds. Love my little car. Fun to drive. Love a manual. Who doesn't want to drive the car yourself? I just, the car drives you. Like, no, I get myself a stick, and then you get to drive the car. But so you get your acceleration right off the bat. But even in my little sports car, I'm not hitting 24 miles an hour in first at 3,000 RPM. If I'm shifting at 3,000 RPM in my car, which I'm not, I'm shifting it more like probably 4,500, 5,000 RPM in first. But if I'm shifting at 3,000, I'm going maybe 10, 12. I'm not sure that I see this reverse maneuver really adding up, this data really adding up. So I don't know if that'll be a subject for Cross. When I looked at all that data, that chart that he produced, and a lot of it was blued up, with his own inserts into it. But even just the raw vehicle data, it's a lot of information. You've got the degree that the steering wheel is at, the percentage of the throttle that's open, a lot of those types of details. And I also remember looking at all this data and thinking, I find it very, very hard to believe that there isn't already one, if not multiple, accident reconstruction programs out there, software programs, where you can just plug this data in and it will show you what that shows the car doing. Surely that exists. Surely that exists. One of the reasons that I got thinking about that is because I was looking at the 3-point turn. I was looking at the data for the 3-point turn. And Dr. Welcher said, "Oh yeah, this looks just like a 3-point turn. It adds up. Everything works." I'm looking at this data, and what I see is it shows the car being switched into reverse, and then you have the steering angle shown. And I forget which, positive is right, negative is left, or the other way around. I forget which one is which, but you can just tell one is one direction and the other is the other direction because one is positive and one is negative. And so it shows the car going into reverse and the steering being in the negative position. But it doesn't show the car shifting back into a positive position while it's in reverse. It shows, okay, the car starts positive. Here's what happens. It shifts into reverse. Maybe I'll just share this. I don't know. It's I don't really want to. It's not very visible. That's okay. I'm going to get it up so you guys can see what I'm looking at here. Terrible, terrible view. Hey, okay. Still getting stuff sorted out here, but I think I got it to work. Terrible view here. Can't see things very well, but so what I'm looking at, I'm looking at the steering signal over here. And so what I'm seeing, remember, this is the 3-point turn. And so it shows the car getting shifted into reverse here, this number 2, and it's positive. And it stays positive for like 3 seconds before then it turns into the negative. And then it stays negative once it shifts back into drive before it goes positive again. And I'm thinking about this, and I'm thinking that's not at all like any 3-point turn I've ever done. Okay, so if I'm on Cedar Crest and I need to turn around and head back towards Fairview, I'm turning into this driveway. My car is in drive, and I'm turning it over to the left. So if this positive is to the left, okay, I'm doing that while I am going forward. And then when I shift it into reverse, I'm turning it the other way. I'm turning it to the right to bring my butt around. And then I'm going to looks like we're just about to get started in trial over here. And then I'm, gonna go straight, and I'm gonna bring in let me bring in the courtroom here. All right, they're getting started.
All right.
These things line up. It's a weird looking 3-point turn to me.
All right, so Dr. Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January 29th at 12:32 a.m. because he's a qualified expert and his opinion is based on reliable methodology appropriately applied.
Reliable.
In addition, Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus, because this opinion is based upon, among other things, his experimental work that came into evidence without objection as to scientific methodology and application.
No, it's not.
However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts, that's not a bar to admissibility. Rather, it is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So that's the ruling. All right, so the jurors are lining up. We should have them momentarily.
So consistent, but not that he actually caused it. I'm afraid Mr. Alessi very much did object to the methodology here.
Is Dr. Welcher
did they
right
not
around?
Request a Daubert hearing?
Why don't we bring him in if he's here before the jurors?
Over the blue paint, the experimentation. I kind of remember that happened. Who is still shaking their head over the fact that we dragged ARCA twice into this courtroom, made special trips? We dragged in ARCA, we dragged in Dr. Russell, we dragged in Richard Green, all to do voir dire. And this guy gets to show up with his Smurf finger paints.
We provided a copy to the defense.
And gets nothing?
With all the redactions.
Okay. Are you in agreement with this, Mr. Alessi?
I haven't gone through, but I have no reason to believe that I wouldn't be in agreement. So
okay.
Just always friendly.
There is one slide, so I'll admit it conditional to redactions that you didn't rule on, but I feel as though you probably will exclude, and that is in that version. I didn't want to pull it out with the court's order, but I'll talk to.
Do you know the number? You don't have to find it if you don't.
It's 131.
Oh, is this was it 1:30? Was it 1:31 yesterday too?
It was.
So at Sidebar, I said we could go back to that. And Mr. Alessi agreed that we could go back to that. So, and I know I thought we were starting there, and I think Dr. Welcher thought we were starting there, and then you went to 132. That was my understanding at Sidebar.
It is, but subject to me being able to object. I was basically, because we wanted the jury to come in, so I want to look at the slide.
Okay, so look at it again. That's not my understanding, Mr. Alessi. It was you were concerned just about the heading, and then I said we'd go back to both slides.
Oh, yeah, no, I'm okay with that.
Yeah.
That one, yes, your Honor's recollection is.
Yeah, and
the heading removed.
and we were going to start on that, but you thought because I struck it based on the objection, but then at Sidebar, I said we could go back to that. That's your understanding too.
Correct, Your Honor. And I'm sure that Dr. Welcher.
What does that even mean? Did you
I think
strike
he
it or
did,
not
but
then?
because I think he took off from 124 to 1.
I think you did as well.
I did.
Thank you very much.
Okay.
I would like your prediction to come true. Great.
Are they out there, Paul? Okay, thank you.
Once again, this could have all been dealt with 2 months ago when Mr. Alessi brought to your attention there are problems with these slides. And you were like, no, we'll just deal with it. We'll just deal with it when we get to it. And so here we are, and the jury's been out there waiting yet again, as they did yesterday. I mean, am I losing my mind? She's like, I said I struck it, but then I said we'd go back to it. So did you strike it or not, Judge? It might help if you made it clear what you're actually doing. Maybe that's not the party's fault if they get confused when you're like, I'm ruling, but I'm not.
Draw near, give your attendance, and you shall be heard. Let's say the Commonwealth of Massachusetts. Court is now open. You may be seated.
All right, good morning again, counsel. Good morning again, Ms. Reed. Good morning, Dr. Welcher.
Good morning, Your Honor.
And good morning, jurors. I have to ask you those same 3 questions. Was everyone able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instruction and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone.
You're wearing a new lipstick today.
Thank you very much. All right, Mr. Brennan.
Thank you, Your Honor.
We haven't even talked about Elizabeth Little's nice new bangs.
Morning, Dr.
I
Welcher.
really like the
Good
look
morning.
on her.
When we left off yesterday, I was asking you about some of your opinions. I'm going to ask you those questions again, but before we do, I'm going to ask you 2 other questions. The first is, I'd ask you to turn to your PowerPoint, slide 110.
You want me to display it?
Please. I'm going to ask you a question about a series of your slides regarding this effort. This is 110. Could you also follow through to 111, 12, 13, 14, 15?
You want me to play the videos?
You don't need to play the videos. I just want to acquaint you for the question.
111,
12,
112, 113, 114, 115.
how many times did you engage in testing where your arm and forearm touched the rear right of the exemplar Lexus?
3 times.
In any of those 3 times, did it ever leave any paint on the underside of your arm or forearm?
No.
If you could turn to slide 130, please. Could you go back one, please?
Yes, Hank thought he had a real winner with that blue paint.
Perhaps it's 131, Dr. Welcher. There we go. Could you explain the significance of this slide, please?
Your Honor, this is.
Oh, could you take that down, Dr. Welcher?
Thank you, Mr. Brennan.
We're going to move forward.
So one of the removed
Yesterday, when we
slides.
left off, I had asked you,
So we need to take this slide down.
Yeah, sorry.
Sorry,
you could take the PowerPoint down, please.
that was in a different spot on the slide. Hold on a second.
Right, that's better. Thank you.
Thank you. Sorry, I'd asked you yesterday about some of your opinions. I want to ask you about some of your opinions relative to that last effort that you made regarding testing between the Lexus and your arm.
Correct.
You had mentioned earlier on in your testimony that you reviewed a number of pieces of information and offered that you relied on some of those pieces for your opinion. Can you share with us, for this part of your analysis, what pieces of evidence or information did you rely on for the opinions I'm going to ask you?
Relative to the testing on the arm contact on the taillight.
Yes.
So it was the physical evidence at the scene, the photographs of Miss Reed's vehicle, to a certain extent, my analysis of the Ring doorbell and the One Meadows event, the nature and
Your Honor, pardon my interruption. I just want to know if you're reading from something or not reading.
Looks like he's counting on his fingers. He's reading from something.
No, I am counting on my fingers.
Okay, thank you.
So I am counting on my fingers. The Ring video doorbell, Mr. O'Keefe's height, the type of shoes he's wearing, because I need the same type of shoes, my exemplar
Yes.
inspection where I matched up the heights,
Can't forget the cosplay.
the locations of the lacerations, and then the tech stream data as well.
That information that you considered, in addition to the text stream data you considered, considering both those areas of information, do you have an opinion to a reasonable degree of engineering certainty in whether the damage to the defendant's Lexus is consistent with a collision with Mr. John O'Keefe on January 29th, 2022 at around 12:32 a.m.?
So there's been two potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it. The second one was an impact to the arm. If the impact is basically more than approximately 8 miles an hour, it will likely break the taillight lens.
And do you have an opinion whether, based on the data and based on the physical damage and your testing, whether that is consistent with a collision or a impact with Mr. John O'Keefe?
It is consistent with the collision as long as it's greater than approximately 8 miles an hour.
Do you have an opinion whether it's consistent with an impact or collision with Mr. John O'Keefe on January 29, 2022 at around 12:32 a.m.?
With that caveat, yes.
In your testing, did you consider, or do you have an opinion to a reasonable degree of engineering certainty, whether John O'Keefe's injuries on his arm, inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022?
Yes,
What's your opinion?
that it is. It is consistent with being struck by a Lexus and ultimately contacting a hard surface such as frozen ground.
Such as frozen
And does that
ground.
specifically pertain to January 29, 2022 around 12:30 a.m.?
Objection, Your Honor.
I'm going to allow that.
Yes, it does.
Frozen ground. Where was
To
the
finish, I'd like
methodology
to
for
ask you a
that
few
one,
more
Bev?
questions. You've written some papers on side swipe collisions or clipping. Can you describe for the jury and explain what a side swipe collision is or a clipping and how that may or may not differ from a direct hit on a pedestrian impact?
Sure. So what generally differentiates, say, side swipes or clipping contacts compared to, say, an inline impact or, say, a T-bone impact is what refers to that the object that you're hitting isn't accelerated up to the speed of the object that's coming in. So, for example, if I rear end a car, that car will be accelerated up as a result of the contact, and they reach what's called common velocity, and then they separate. And so in a glancing hit, you're going to have a glancing hit, and you don't have what's called complete momentum transfer, meaning the momentum from the car, because it's a glancing hit, doesn't completely transfer to the object being struck.
Describe what a glancing hit
For
is?
example, you can drive down the road at 100 miles an hour and clip the mirror of a parked car, and you'll break the mirror off, but you're not going to go from 100 to 0 instantaneously.
And what
You're
does
just going
that
to
have
keep
to do
going
with the center of
because
mass?
you don't have
sir?
all that momentum transfer. So when you have glancing contacts, you can have much higher speeds without a lot of damage to the car because you're only in momentary contact and it's a glancing type hit.
You mentioned about potential damage to a car. How about potential damage to the pedestrian?
It's the same thing. So when you have a glancing hit to a pedestrian, this is referred to as a fender vault. In this case, they call it a fender. Fenders on the front of cars because most pedestrian impacts involve the front of cars. In this case, it would be called a quarter panel vault, which means you're kind of vaulting off the corner of the car. Those are much more complicated because you don't have that common velocity that I referred to. So it's difficult to calculate the exact speeds at which the vehicle contacted without a whole bunch of information in that type of crash. If the impact has occurred in the center of the vehicle and we knew where the point of impact was and the point of rest, we'd have a much better chance of determining how fast the vehicle was going. But when you have just a corner clipping or glancing, it makes it more difficult to determine, even when you have an area of impact, which is where the person was when they got hit, and a point of rest where they landed, makes it more difficult for glancing contacts because you have that side swipe problem where they don't obtain what's called common velocity.
That's not the problem.
And what are some of the other difficulties in attaining specificity in a side swipe or being hit by a quarter panel as opposed to a fender?
So for a pedestrian, correct?
Yes.
So pedestrian impacts and how you move post-impact are very sensitive to your exact body position. For example, whether your right foot is on the ground or off the ground, whether your left foot is on the ground, off the ground, whether you jump up in response to the crash. Simply raising and lowering your arm changes the amount of rotation that's going to happen. Post-impact motion of the person. So cadavers, crash dummies don't have any muscle reaction. So the motion of a crash dummy is just going to be like you're hitting a dead body, to where people will step, try and regain their balance if possible, will do additional activities that alters where they come to rest.
In your studies of direct pedestrian collisions by front or back bumper, as opposed to side swipe or clipping with somebody, is there a similarity or difference in type of injuries that you see?
Yes.
And what is the difference?
So in direct centralized impacts, you tend to get much more severe injuries. Really what's occurring is you're getting that momentum transfer. So it's more, you're accelerating the person up to the vehicle. They can wrap onto the side in front of the vehicle at higher severities. Their head will hit the hood, their head will hit the rear of the vehicle. So when you have that direct contact, there's actually more momentum transferred to the actual occupant. There's more applied force to the occupant as well.
When you see direct impacts, is there ever the existence of lower body extremity injuries, broken bones in the legs?
So there can be both, depending, and again, it's very sensitive to where the foot is on the ground, whether the foot's on the ground, as well as the severity of the crash. In the presentation that I gave at the Accident Reconstruction Collision Safety Institute on pedestrian injuries, I went through all the literature on lower extremity injuries and looked at what parameters affected that. And so depending on how it was loaded, some at 15 miles an hour had no injuries. Some at 15 miles an hour had some fractures. It depended on how exactly the foot was loaded.
Is it uncommon in sideswipe pedestrian accidents to see no lower body broken bone?
No, it is not uncommon.
Have you had cases that you've studied or been involved with where you've studied the effect of a sideswipe or a clipping impact where there's an absence of broken bones in the lower body extremities?
Yes.
I'd ask you to turn to slide 139, please.
And how many of those people died in those impacts that you saw? How many fatal impacts without a broken bone?
Oh, sorry. I fixed those other two slides.
Okay. Could you share with the jury what this represents?
Sure. So this was a trial that I was involved with in downtown Los Angeles. I've redacted the name at the top, but this was an instance where we had, this is a image from the police report. Well,
It was going to show that because this one time this guy was hit and he didn't get hurt. How do you factor injury resistance among individual humans
so
into your analysis here?
in this diagram stands for area of impact. That's where the pedestrian was when they got hit. AOR is area of rest. And you can see we have information on exactly how far the pedestrian was thrown. Then on the right-hand side, we have photographs showing the impact to the pedestrian. This was determined by experts on both sides of this case to be between a 25 to 35 mile an hour impact. And then what you see is a close-up on the bottom slide of where there was DNA transfers, hair and tissue samples on the vehicle from the individual that was hit by the vehicle.
Next slide, please. And what does this represent?
So this is the decedent in the case, the person that was hit. He was killed at the scene. What you see on the left-hand image, oops. On the left-hand image is he
he's
had
got
a
an awful lot of internal injuries,
massive
doesn't he?
laceration to his right forearm, but it didn't break his arm. There was no broken bones in his arm.
Okay.
On the right-hand side of
Look
this
at how
image,
abraded
you
this
see the
guy
autopsy report. What you'll
Both of
notice
his
is he
lungs
had
collapsed.
red marks on his leg, the buttocks.
You think
But he
that
had no leg
helped?
fractures. And again, this individual was hit at between 25 to 35 miles an hour.
Can you expand that? I'm sorry.
Yes, yes,
Please,
sure.
do you want that expanded like other times?
There you go.
Thank you. I'm sorry to interrupt you.
Yeah, no, my pleasure, John. Thank you. So
Oh, shut up.
at the top, he had a severe brain injury, which again is the most common injury in pedestrian crashes. He did have fractures of the right 11th and 12th rib and a liver laceration. If you look at the extremities, it says right upper extremity. Again, that's from the shoulder to the end of the hand. Extremity wound with vascular injury. So no fractures. If you look where I was talking about the multiple abrasions, so when they're looking at the lower extremities, they're noting a number of red marks, but there was notably no fractures to the lower extremities.
Okay.
Thank you. You can take that
John
down,
had
please.
one tiny little bruise and a little abrasion, and you want to correlate those?
Dr. Welcher, regarding your analysis of the data and the evidence in this case, do you have an opinion to a reasonable degree of engineering certainty whether the absence of lower body breaks to Mr. O'Keefe is consistent with the defendant's Lexus impacting in a side swipe or a clipping Mr. O'Keefe.
Yes, you could definitely have this type of impact and not have anything beyond, say, red marks to the lower extremity.
Thank you, Dr. Welcher.
My
Your
pleasure.
Honor, I would move the evidence subject to redactions. Dr. Welcher's PowerPoint presentation.
That's by agreement, Mr. Wilson. with that
That is, Your
caveat.
Honor, thank you.
It's by agreement. That's the only reason it's coming in. Otherwise, it is hearsay.
Put in both the flash drive and the notebook.
On representation, it's consistent with the same set, I have no objection.
So let's put them both together now and decide later.
Thank you.
Okay.
Those two slides are incorrect on the flash drive.
Yeah,
Okay, so we'll switch that.
that was.
Thank you. Yes. What exhibit number is it? Oh. 206, thank you.
Exhibits 206A and B.
All right, Mr. Alessi, whenever you are ready.
Thank you, Your Honor, if I could have a moment to set up.
Sure.
Sure. Take as much time as you need. Oh, God. Just drink your coffee, Bev. Well, where shall we start? What pleasantries and vocabulary introduction?
Morning, Dr. Welcher.
Good morning.
What do we
haven't
have today?
been formally introduced. Your whole name?
Robert Alessi, sir.
Robert Lessie. Nice to meet you.
Nice to meet you. Dr. Welcher, the area in which you engage can also include, and I believe you used the term on direct, forensics, correct? Do you engage in any forensic activity in your profession?
Yes, the general umbrella of you basically coming in, giving scientific evidence in court applies to forensics. So my main job is accident reconstruction and biomechanics. And so that's what I do. Sometimes it doesn't involve court. When it goes to court, that's generally forensics.
Right. So you're here today. That is my question. You're here today, at least in part, with regard to forensics, correct? Because forensics is the Latin term for it is basically you're going to have some type of court or jury presentation. It's for law, correct? Would you agree with that? It's for law, forensics?
I mean, exactly the way you asked that, no. It's for engineering and it's for biomechanics. It's in the court of law, I think is what you're asking.
That's exactly it.
Okay, yes, certainly for the court of law,
It
yes.
ends up to a court of law, and forensics is a common term.
Yes, sir.
So it relates to, or it's used in, or it's suitable for a court of law, the analysis. You'd agree with that? It's a general principle?
Yes.
Not a trick question. Okay. And so in forensics, what you're doing, among other things, is you're applying the scientific method and principles in here in a criminal matter, correct?
Yeah, you try and apply as much as possible.
Right. And so the primary
Right.
goal of forensic science is to uncover the truth and to provide objective evidence that can be presented in court.
That is generally correct. Again, there are elements, for example, this analysis that are relying sort of on subjective evidence, like the testimonial, the witness statements. So it's not solely based, but ideally you'd want it as much as possible based on objective data.
So you would agree that truth and objective evidence is part of the presentation in terms of information for forensics in a court of law?
Certainly objective information. Truth sometimes, again, can be subjective.
Oh, so you don't believe truth? You believe sometimes truth applies and sometimes it doesn't?
If you know for a fact it is true, but if you take someone's deposition testimony, you have to look at it relative to the evidence, and it's either consistent with the evidence or not.
Okay, so now let's go to your direct examination that you just went through.
Please.
Hopefully this is fairly straightforward. You have testified to, and it's varied a bit, a reasonable degree of engineering certainty. Is that correct?
Correct.
You've also, have you used the word sometimes to a reasonable degree of scientific certainty?
I may have.
Right. So
I don't know.
Right.
in terms of your role as a biomechanical engineer and accident reconstructionist, is it important to engage in a critical analysis of the data?
Critical analysis, yeah, I think it's important to have a critical analysis. You want to try and look at it from all sides, consider all possibilities.
So it is therefore important to try to review the data as objectively as possible. You had mentioned sometimes subjectivity comes in, but I understand the goal is to try to look at it as objectively as possible, correct?
Correct.
Now, you stated with respect to your conclusions early on in your direct testimony and your analysis that you don't, and I think I've got it quoted, you don't have a dog in the fight. Is that what you said, sir?
I did.
And that you, quote, don't care, end quote, about the outcome. That's what you made a point of saying in the beginning,
That is
correct?
100% correct.
Now, you simply follow the data. Is that correct?
I try to do that.
You try to do that.
I'm not perfect, so
Okay.
I do my best. I believe I've done it here.
Okay, so in terms of you've agreed that you apply the scientific method, so I want to see if you're in agreement generally so the jury can understand what the scientific method is. Are you familiar with NIST, National Institute?
Yes.
Yeah, so would you agree with this definition of the scientific method? The systematic pursuit of knowledge involving the recognition and definition of a problem, the collection of data through observation and experimentation, analysis of the data, the formulation, evaluation, and testing of hypotheses, and where possible, the selection of a final hypothesis. Is that a general fair statement of the scientific method?
So for forensics, you'd have to add in the testimonial evidence aspect of it. So those are testimonial or things are in evidence. So frequently there's one or two versions and you're trying to match which version is most consistent with the evidence.
Okay, adding that to what
No.
I stated.
They could both be wrong.
Relative to NIST, you would agree that evaluation and testing of hypotheses and where possible the selection of a final hypothesis is the scientific method, correct?
Generally, yes.
Is it correct that a proper biomechanical injury analysis utilizes a sound scientific methodology that's been subjected to peer-reviewed and a publication that's been generally accepted in the engineering community?
Well, I can't. So this, I've done my analysis here, biomechanical analysis. I can't submit this analysis to peer review. I'm not allowed to give this to people outside the court. So there would be no way for me to submit my analysis for peer review. So this occurs forensics all the time. The forensic analysis in court generally never goes under a peer review process. the methodologies underneath it and looking at, like, for example, I think I referenced 25 papers
Why can't
in
you?
my report.
All
That
the large
goes to the
people
issue
do.
of trying to follow the science, 26.
So I think you may have misunderstood my question, sir. I was talking about your methodology, your biomechanical injury methodology. The methodology that you use and apply is to be subject to peer review and general acceptance in the engineering community. Is that correct?
So I have no way of publishing this analysis.
I'm sorry, sir,
to
to
get
interrupt
peer,
you.
I need to,
Go ahead and answer your question.
you're asked peer reviewed, like you said, means I give it to my peers. I send it out to somebody to review for the scientific method. That's what the peer review process is. So I will gladly send this out to peer review with the court's permission, but I haven't and cannot do that.
Sir, my question is not your analysis here in this case.
Oh.
My question regards the methodology that you use here. Is the methodology, you said 26 references, right? My question is simply, is the methodology that you used for your analysis in this matter, is the methodology for a proper biomechanical analysis, should that methodology be generally accepted in the engineering community?
I think with the forensic application, yes.
Okay, that was my question. Just
What even are these
methodology. Thank you.
qualifications?
You're welcome.
What does that even mean? It's still science. It's not junk just
Now,
because you're in
the
court.
scientific method
Guys, you may
that
think that.
you've used in this case, part of the use of scientific method, the purpose is to avoid what is called bias in the scientific method, right? Not cultural bias, but just bias in terms of the application of methodologies and principles. You would agree that's a pretty fundamental purpose of the scientific method is to avoid biases?
The purpose of the scientific method is to get the most logical and correct answer without bias.
Exactly. To do it apply the scientific method without bias being part of the application of the method, correct?
That's hopefully what you can do.
That's hopefully what you can do. That is the goal, right?
That is one of many goals, yes.
So are you familiar with the term confirmation bias?
Confirmation bias.
And that relates, confirmation bias is part of a larger term. Are you familiar with cognitive bias?
Generally, I'm not a human factors expert, though.
Pardon me?
I'm not a human factors expert.
All right, biases are, don't you agree that cognitive biases are not just for one category? You would agree it applies to medical analyses, it applies to doctors doing studies, engineers doing studies, and other scientists doing studies?
So I'm not a cognitive expert. I think I would generally agree with it, but I don't want to step out of my lane. I'm not an expert on cognitive. I can talk to you about confirmational bias, if you like.
Let's talk about confirmation bias. Now, confirmation bias is actually when someone selectively gathers and interprets evidence to confirm one or another's beliefs, as well as neglecting evidence that contradicts those beliefs. Is that a fair statement of confirmation bias?
That is a statement. Yeah, it could be broader, but sure.
But you would agree that that is generally correct, what
Generally, yes.
confirmation bias is. And an example of confirmation bias is not considering alternative hypotheses once an initial hypothesis has been selected, even though data and information might contradict the initial hypothesis. Is that an example of confirmation bias?
That could be yes.
And confirmation bias is antithetical. It's against the scientific method. It's to be avoided, correct?
You would like to avoid it, yes.
Are you familiar with the term failure analysis?
Generally, you might need to define how you're using it for me.
Sure. So is failure analysis the enablement of a scientific examination of an alleged incident by beginning at the undesired consequences? Is that a fair use of that phrase?
I was thinking something different, like a piece of metal failing. I guess it could fall into that category.
Okay. And would you agree that the first question, or one of the first questions that are to be asked by a biomechanical engineer when conducting an analysis of, say, an injury is, how did this happen? Is that one of the first few questions that you ask?
No, that's usually the last question.
Oh, so for you.
So hold on a second.
Okay, I'm sorry.
Generally, what you want to do is gather data. You want to know what injuries there are, what evidence there is, like, for example, on the vehicles. And then the very last thing you want to know or define is, given all that information, how did it happen? So that's the end.
Well, you haven't asked
I
a
think you may
question
have
yet.
misunderstood my question.
You just gathered stuff.
I wasn't talking about the method or the process. I was talking about when you get to answering questions, whenever that is in the process. Isn't one of the questions, and maybe one of the first questions, how did this happen?
No, that's not one of the first questions. And one of the first questions is, where's the damage? What are the injuries? What's the evidence? What black box or tech stream data do we have? What physical evidence was at the scene? So that is certainly not one. It is a question, but that question is at or near the end.
Isn't every one of the questions that you just mentioned part of the data gathering?
Correct. But,
Okay.
but when you're gathering data, you're always asking yourself questions along the way.
So,
Like, what is
move
this? Where
past-
did it come from?
You've done
But you would agree
collecting the data.
that
You've
for
got all
you
the
at least
data.
some point, it's how did this happen, correct?
Yes.
And don't you ask that question to come up with hypotheses?
I generally have many working hypotheses as I'm working on the case. And then as the evidence comes in, I'm applying that to my hypotheses and either accepting or rejecting the hypotheses based upon the factual information.
Sir, how then is
So
it
you
just
don't
a
collect
matter
all
of
the data
logic or facility?
to evaluate your hypotheses?
If you don't ask the question, how did this happen until the end, how do you then not get your hypotheses up front when under the scientific method, you should be having different hypotheses up front? How is it that you ask the how did it happen at the end and not go through hypotheses in the beginning? Can you help me with that logic?
Sure, I guess I misunderstood. Like, I was trying to give you an answer to how it happened. So when you're answering how it happened, or you want to be able to answer that question, you want to make sure you've looked at the totality of the data, accepted, rejected, things as they came along, to be able to answer that final question, how did it happen? But along the way, like, for example, a right eye laceration, you want to know how that happened. So you look for the evidence of how that may have happened.
So you would agree then that questions of how it happened, formulating and identifying hypotheses, does and can happen toward the beginning of the analysis. It doesn't happen at the end all the time. Would you agree with that?
So the ultimate question of how did it happen happens at the end. The questions about the elements of what occurred to make it happen, those occur at the beginning, middle, all along the way.
You would agree that creating hypotheses occurs more toward the beginning than toward the end of the analysis. Is that correct?
There are probably more hypotheses in the beginning, but I am continually forming, looking at hypotheses, either accepting or rejecting them upon the evidence.
So you would agree that the creation of hypotheses
Before
does
the evidence even
occur
comes
more
in,
toward
you
the
said.
beginning of the analysis.
You're
You would agree
evaluating
with
them.
There are more towards the beginning. The process occurs throughout the whole investigation.
Right. I'm asking about the hypotheses, sir. You would agree that the hypotheses occur more toward the beginning than the end? Just a hypothesis.
So I don't know if you and I are saying different things. More hypotheses in the beginning because you have more questions in the beginning. You continue to form hypotheses as the data presents itself. So you don't stop the formation of hypotheses. It's just as you get more evidence, you window down the number of questions.
Maybe I can just this last question and make it clearer for you, sir. You would agree, not analysis, which you added, as I heard it to the last part, just hypotheses. You would agree that even though hypotheses can be created and changed perhaps all the way up to the end, you would agree that it's important in the analysis to create at least some hypotheses, plural, in the beginning, correct?
Yes.
Is that so hard?
And once
Not feeling so
You
cool around
create-
here today, are you?
these hypotheses, would you agree that those hypotheses should be tested?
So if you take the word testing to mean testing compared to testimony, compared to physical evidence, yes.
And when you test those hypotheses, isn't it often the case that particularly in your line of work, the one that most consistently produces the same injury will emerge as the mechanism of injury?
I guess it depends on the scientific evidence behind it. Again, sometimes we get very unique injuries.
So my question, sir, is this. Isn't it the case that when you have multiple hypotheses,
Well, hypotheses.
the one that
writing it
most,
down.
out of all of them, it's a relative thing, the one that most consistently produces the same injury emerges as the mechanism of injury? Is that a fair statement?
He's writing it down.
I think generally, again, it's on a case-by-case basis. You have to look at the science and the facts of what you're basing it upon. I think as a general premise, what you're saying is accurate,
Okay,
but there's exceptions.
fair enough. But it's a general principle
Sure.
with some exceptions. That's a fair statement, correct?
Yes, sir.
We're going to have several topics, sir, and what I'm going to try to do to make it a little clear is I'm going to say when I'm switching topics.
Oh, good.
So
Oh, good.
what I'd like to do now is switch topics.
Okay.
You're aware that the Massachusetts State Police has troopers who specialize in accident reconstruction, correct?
Yes.
And there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section whose sole responsibility is to engage in accident reconstruction. Do you know that?
I do not know that.
Do you know that there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section who engage in accident reconstruction?
Just based on what I've seen in this case.
Right, based upon what you've seen in the case,
That's
that's a
enough.
fair statement.
And I just know that those people are doing it.
Are you familiar with a Massachusetts state trooper named Joseph Paul, P-A-U-L?
Yes.
And you
Well,
know,
I'm familiar
There
with
you
his
go.
reports. I don't know the man.
okay, familiar with Trooper Paul through his reports in this case, correct?
Correct.
And are you aware that he was assigned by lead investigator, former Trooper Michael Proctor, to be a reconstructionist in this case on January 29th of 2022, as evidenced by that report or those reports of Trooper Paul? Do you know that?
Well, you put a lot of things in there. I know he issued a reconstruction report. I don't know who told him to do it. So the first party question, I don't know, but I did see a reconstruction report from him.
You were retained, and so do you recall, is it the date, January 29th of 2022? 2022, is that a rough time period of him being assigned, or you don't know when he was assigned?
Don't know. That might have been in his report, but I wouldn't have paid attention to when he received an assignment.
Do you know when the date of the first report of Trooper Joseph Paul in this case?
I can pull it up. I do not know off the top of my head.
You know that the date of the incident in question is January 29th, 2022, correct?
Correct.
Yet your firm and you were retained for this case by the Commonwealth 2.5 years after the incident in question. You were retained, your firm, on September 23rd, 2024. Is that correct, sir?
No, I believe we were retained a couple days before that.
A couple days. Okay.
Right.
So
Actually,
days
I might be
before
able
he
to find
shows
out
up.
if you'd like me to look at the documents.
it's not all that important. You would say it's within a week of September 23rd, 2000. It was in September of 2024.
I believe it was in September, yes.
Right,
I would
so-
want to double check.
That's 2.5 years from the date of the incident in question, if I did the math right, correct?
No, never
Quibble
thought
with
about
it. Why don't you quibble with it?
Yeah, approximately.
And as we just discussed, and you stated
Approximately.
on your direct examination, you have no dog in this fight, correct?
Correct.
On November 5th of 2024, your firm Aperture was paid $44,500 by the Norfolk County District Attorney's Office to conduct work that was at least similar to the work of Trooper Paul, correct?
I have no idea. I don't get the billing or the statements.
Do you
Convenient.
recall whether Aperture has, well, do you believe Aperture is working for free in this matter?
Oh, no, I don't believe that. No,
So you
we're an
would,
engineering company. We bill for our time. So
you know that Aperture is getting paid for its work in this case, correct?
we are billing for our analysis work.
Well, you're not just billing, you're billing and getting paid, correct?
So I have not seen any of the payments. I would assume that we're getting paid, but I don't know that.
Sir, you are a senior vice president of Aperture, are you not?
I am.
You would know, wouldn't you, if your firm was not getting paid for work since September 23rd of 2024, wouldn't you?
No, probably not. Usually it takes, 9, 10, 12 months of not getting paid before the accounting department reaches out to me.
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting
No, he's
paid,
been on it
you
for
would
less
have
than a
been
year,
notified by
Alessi.
that by now, correct?
He's been on it for less than a year.
According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's what, less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that discussion and just
Okay.
go right to the bill. You, as you sit here today, do not have a recollection of whether Aperture has been paid. Is that your testimony?
It has nothing to do with recollection. I'm not part of that process. We have an accounting department. I don't have any involvement in that.
Are you, so is your testimony you have no knowledge about any contractual relationship between Aperture and the Commonwealth?
Oh, no. I was sent a contract by the Commonwealth to sign, so I'm aware of the contractual agreement, but the day-to-day or month-to-month invoicing and billing, I'm not involved in that.
Okay, so you're aware there's a contract between Aperture and the Commonwealth,
I signed it.
and you signed it. And wasn't that contract obligating the Commonwealth to pay for the services of Aperture? Isn't that the purpose of the contract, in part?
In part, sure.
Yeah, it's a legal obligation of the Commonwealth. Your firm does work and the Commonwealth pays for it, correct?
That's the idea.
Right. And so you know about that contract because you signed it.
Correct.
What rate? Tell us the rates, Alessi.
Also, you testified on direct that there was a purchase of a Lexus exemplar for your testing.
Correct.
Who pays for that Lexus exemplar?
Aperture.
And is that then cost passed on to the Commonwealth?
No.
So you pay for the Lexus, you don't pass that cost on, correct?
So what we're doing is we paid for the Lexus. We're keeping it till the trial's over. We're selling it and charging the Commonwealth the difference in the price.
Exactly. That was where I was going, sir. So,
But they're only paying the difference. So, and in theory, if we sell it for more in California, then we'll reduce the bill.
okay, I don't want to speculate. I just wanted to see what the obligation was. So
The
if-
obligation is the difference.
Exactly. So the obligation is the difference. Are you aware that on April 5th, 2025, the Norfolk County District Attorney's Office amended your contract? Are you aware of that, sir?
I am.
And isn't it the case that that amendment authorized the amount of $325,000 to be paid to Aperture? Isn't that what that amendment contract states?
I believe that's correct.
So the Commonwealth is obligated to pay at least
On top of $40,000 they already
$325,000.
paid.
And is that correct?
That is you're asking me a legal opinion now about a contract. That is my understanding of how contracts work, but I'm certainly not an attorney.
And on top of that, are you aware that Aperture has been already paid $44,510 for its work? Are you aware of that?
The second time you asked me, no, I'm not aware of anything we've been paid.
And as you stated yourself, those amounts reflect, as you say, less than 6 months worth of work?
That's not what I said.
Well, no, my question is, you've been on the case, you said, since September of 2024, when we were talking
8
about
months.
dates, you said that was about 6 months that your firm's been retained. Did I have your answer correct about how long you've been on it?
I guess it's closer to 8 months.
All right, so 8 months. So for 8 months of work,
$350,000. And that's not even
about
including his trial time,
$400,000. Is that correct?
is it?
So there's 3 offices working on the case. There's the Boston office, there's Mr. Burgess's
didn't ask you to
office, and there's
justify
my
the bill.
office in Long Beach. I only know about the billing from my office.
But you signed the contract on behalf of all of Aperture, not just your office, correct?
That I don't know,
I thought you
but I
didn't know the
definitely
billing
did
for
sign
your
a
office.
contract.
Would it refresh your recollection as to who you signed the contract on behalf of, whether it's all of Aperture and all offices, if I showed you the contract?
Sure.
May I put you on?
Yes.
Oh, you gonna learn, boy. You gonna learn about being refreshed.
Yeah, could you direct me so we're not wasting time?
Well, what I'd like to do, with the witness, Your Honor, is just ask the witness a question with regard to it.
Why don't you just take a look at that, Dr. Burgess?
Thank you.
And then when he's done, Mr. Alessi, you can take it back to the podium.
Yes, Your Honor, thank you.
There you go.
I have a few more questions before I do that, Your Honor, for foundation purposes, if I want to do more than refresh.
All right,
Would you like me to start with
So-
refresh?
go ahead and start with refresh. Go back to the podium, please.
Sure.
Thank you.
Thank you, Your Honor.
Look at her. Her
Dr.
little
Welcher, does that
imperial direction.
refresh your recollection as to the contract you signed on behalf of Aperture with the Commonwealth?
So it lists the legal address as my office. So for my office, yes.
So are you saying that therefore, and did you see the amount that was in the contract? Did that refresh your recollection?
Oh, no, I didn't even look at that.
Do you recall the amount that of obligation that the contract relates to in this document? Do you recall that?
You just asked me that earlier, and I'm taking what you said to be true. So I was like $325,000. I have no reason to disbelieve that.
And is there also a total, do you recall the total maximum obligation for the contract that's listed in the contract? Do you
No.
recall it? May I approach your honor?
Okay.
And Dr. Welcher, I am now going to, you asked me last time, I hope this is helpful. You said, please point to the applicable part so we can do it faster. I am now pointing to that part and see if you can just look at that and see whether this refreshes your recollection on the maximum obligation of the contract pursuant to this contract. Without saying what it is, just does it refresh your recollection?
No, but I don't have any reason to believe it's not correct. And that is my signature on it.
Right.
Okay.
And we got started on this conversation tying it to, well, we got started on this conversation with regard to a statement you made earlier in your direct that you didn't have any dog in the hunt. You recall that statement in the beginning of your direct testimony.
You misquoted me. I don't have any dog in the fight.
You don't have any dog in the fight.
Correct.
Thank you. Now, switching topics.
Okay.
Going Michael Vick more than Prince Harry.
You submitted
dog in the fight, dog in the
an
hunt.
updated PowerPoint presentation, the one that you went over on your direct examination. You created that presentation quite recently, correct, sir?
The updated one was where I had redacted or taken out slides. So in terms of taking out slides, I did add one alternative path a couple weeks ago.
Okay, my question, sir, is this. The updated presentation, we'll get to the changes later, but the updated presentation, you created just how many days ago?
I'm going to say weeks ago.
Weeks, 2 weeks?
I don't actually know without looking at the documents.
Well, was it more than 3 weeks ago that you created it?
I still don't know without looking at the documents.
Do you know when the trial started in this matter, sir?
I do not.
Assume the trial started approximately April 22nd of 2024.
Okay.
Did you create your updated presentation before or after April 22nd of 2024?
I don't know.
What would you need to look at to refresh the recollection?
Do you know when?
Hold on one second. Dr. Welcher, I'd ask that you not do.
Not look at,
anything.
okay, I was going to try and answer his question. My apologies. I will shut it down.
Thank you.
You're welcome.
Shut up.
If I may, Your Honor.
Yeah,
say
You're
it.
welcome. That's pissing Bev off. She's like, this is my court, bitch.
Are you able to determine when you created the updated presentation?
I think so. That's what I was attempting to
Your
do.
Honor, may he do that?
Yes, I'm going to see counsel at Sidebar while you pull that up,
Thank you, Your
please.
Oh man, what is this guy even arguing about? What even are some of these arguments? You misquoted me. I said no dog in the fight, not no dog in the hunt. Oh, well, you really got him on that one. That makes you sound so much better. But that's what you said? Oh my Lord. He doesn't know anything about the billing, but then he only knows about the billing for his office. Do you know about the billing or not? And I guess he really didn't want us to hear the total maximum obligation. Don't get to hear the total maximum obligation at this point because it didn't refresh him. He doesn't remember. He doesn't know how much Aperture can potentially be paid out of all of this. $325,000, and we're still in trial. We're still dealing with whatever that hourly rate is for trial testimony. $350,000 they've thrown at this. I mean, more than that, close to 375, 370, somewhere in that ballpark. That the Norfolk County District Attorney's Office has thrown at this to replace Trooper Paul after that supplemental report that they made him write. Apparently just didn't meet their needs. Didn't meet their needs. Why not? Boy, we don't know. Sure don't know. Nothing to do with confirmation bias, of course. So it must simply be that he was unqualified, that his opinions were trash and unfounded. Do tell us more. Do tell us more about the bad science that Trooper Paul did that necessitated shit canning him and hiring.
Mr. Welcher, what I'm going to ask you to do is get whatever information you need for Mr. Alessi's last question. Mr. Alessi, I need you over there. So,
Yep.
and once you get that answer, I'm going to ask you to shut your computer down, or at least put down the cover.
How about it?
Thank you. All right, so you can answer Mr. Alessi's question.
Thank you, Your Honor.
Could you give me the question again, please?
Yes. When did you create the updated presentation that you reviewed in your direct testimony?
So that's addition I made was taken out. It wasn't in my direct
Sir,
testimony.
If you can just hear my question, it's
Just
this.
listen.
The
just listen.
version of the presentation that you put on the screen, when did you create that version? I'm just looking for a date.
So to answer your question about the version on the screen, I created that yesterday when the judge asked me to take off some of the headers. So yesterday.
Okay, good. Now, the version before that you created yesterday, when did you create that version?
The day before.
And then the version before that one, when did you create that?
I mean, I save it every day.
Understood.
So every day.
So you've changed the presentation every day since when?
No, I don't think I've changed the presentation every day.
That's my question.
Well, you
My
said you
question
did.
is, how many times have you changed it within the last 2 weeks, your presentation?
Let me try and cut to the chase here.
Sure.
That slide was added on May 13th, and then it was taken out before I presented it here. So it was not in my presentation here.
Right. So thank you for that answer. So
You're
here's
welcome.
the question.
You're welcome.
Your first version, as I understand it, of the slide presentation was January 30th, 2025. Is that correct?
Correct.
When was the next time after January 30th, 2025 that you changed that presentation?
May 13th.
Assuming the trial started April 22nd of 2025, you changed your PowerPoint presentation during this trial, correct?
Correct.
And how many times did you change your presentation after April 22nd of 2025?
Well, the last time I changed it was like 10 minutes ago. So in response to various discussions, I've been making continuous changes to it.
I want to make sure you finish your answer, so I didn't
No,
interrupt you.
I'm not sure how much granularity you want to that answer.
Right, so you created on January 30th, 2025, you made your,
13th.
pardon me?
Oh, the original one. Sorry,
Yeah.
January 30th, modified May 13th.
Right, if I could finish my question, I might be able to shortcut this, thank you. So you created the original one on January 30th, 2025, you made your first amendment May 13th of 2025, and then before you sat for your testimony, which was yesterday, correct? That was the first time you sat for your testimony.
That is correct. I was here yesterday.
Days get foggy when we're in a courtroom, but it was yesterday. How many times had you changed your presentation from January 30th, 2025 until when you first walked in the courthouse yesterday?
Do you mind if I count?
Not at all.
So there was the May 13th change. Half of that was in response to objections from the defense. I had to add all the paths to where everything was. Then when I got out here, Mr. Brennan asked me to take out references to evidence about statements that I was not allowed to present. So that would have been within the last 3 days. And then I've modified it a couple times today based on rulings from the judge.
Okay, let's
Today,
break that
before
down.
you got on the stand, sir, you're not good at this listening to the
You
question,
said
are you?
half of the changes you made on May 13th related to what? Because I want to know about the other half. that
Sure,
you
there was
didn't
two
say.
changes. I added the extra path of 138. And then I was told that the defense was having problems with my PowerPoint. So I had to go in and add the paths to every single slide about where the evidence came from, because they were saying I didn't provide everything, and I had provided everything.
All right, so
That was the second half.
got it. I want to go to the first half, sir.
Sure.
And I'm going to try to shortcut this. And
Please.
if I'm not clear, you just let me know. I want to talk about the first half. You called it, I didn't hear it. It was like, did you say path?
Path.
P-A-T-H?
Correct. The path Miss Reed was driving.
Right. The way you made the change for May 13th, that first half, that wasn't something that was triggered by the defense. That was something irrespective of the defense, correct?
It was based upon her statements. Is she part of the defense?
All right, so that's what I wanted to get to. You changed the first half based upon statements you allege that Ms. Reed made. Is that correct?
I changed one slide. There was 130 slides originally, or something like that. So half of the changes
He's
on that
getting
day,
hot,
which was
losing
one
his
slide,
temper. Look how
I
red he
added
is.
one line to the bottom of the previous slide.
Did you
Getting
consider
hot,
that
snarky.
change significant?
No,
Well, then why did you make it in the middle of trial if it wasn't significant? Why didn't you just leave it off and then discuss it in terms of testimony?
so A, it ultimately was left off. B, because it was insignificant and I didn't need to have it. So the way it got presented was exactly the way it was before May 13th. So it didn't change anything.
But it was significant enough for you to make a change to your presentation, correct?
So my goal is to be as accurate as possible. So when I saw the path that I gave, the way she could drive, I gave the possible paths. That was one of the possible paths that hadn't originally been included. So in striving to be as accurate as possible, including as much information as I could, I wanted to make sure I included that.
So you were striving. The clip that you used to make the change, you say you made the change based upon a clip you observed with regard to Ms. Reed. Is that correct?
I believe that, yes, that is correct.
Do you know that clip has been in existence for months?
I don't believe I got it until April.
So a clip that has been, assume the clip's been in existence for months. You just got the clip.
Dr. Welcher, I have to ask you
Oh, I'm
not to
sorry.
refer to
I'm
that.
trying to be helpful.
Close your
Yeah,
computer.
let me close it. Sorry. I was trying to answer his question.
So I'm going to ask
So
you to
performative.
close the top.
Yeah, that's probably a good idea.
Just flat.
Shut up.
Thank you, Your Honor.
Do what you're told.
So assume the clip that you said was the basis for changing your PowerPoint on May 13th after the trial started had been in existence for months. You just got that clip, you say, in April?
I believe so, yes.
What was tell me the circumstances by which you got the clip. Did you ask for it?
I was told there was a new interview
Okay. Who initiated the conversation about the new interview?
I don't know if it was Mr. Brennan.
It was someone associated with the prosecution?
Yes, I wouldn't have known about it.
Exactly. So somebody affirmatively communicated with you when about this flip?
I need to look, but I remember it being about mid-April,
Mid-April.
if I'm thinking of the correct clip.
What were you asked to do, if anything, with regard to that flip?
When I got the clip, I wasn't asked to do anything.
What did you do with the clip once you got it?
So they then indicated there was this suggestion of an alternative route. So then I looked at the alternative route description and added the alternative route.
So it was suggested to you by the prosecution that you look at the clip and they pointed out that there was an alternative route they wanted you to look at?
So I took it to be, we have additional evidence. Please look at the additional evidence and add it to your analysis.
On the topic of additional analysis by Aperture, while this trial is going on, are you aware of Mr. Burgess submitting a report dated May 8th of 2025 in this case?
Yes, I received that report on May 8th.
Right, and so you were aware of the creation of that report on May 8th because you got a copy of it, right?
Correct.
Were you aware that Mr. Burgess was intending to submit that May 8th report to the Commonwealth?
Yes, we'd had a discussion before that he had found new information that changed the timing.
Oh, he had found new information. What is your basis for saying he found new information as opposed to the information always existed? It's just it was pointed out to him that that should be looked at. What's the basis of your understanding that he found new information?
Objections to the question.
I'm going to allow the question.
Yeah,
but you
he
have to ask
testified to it.
differently, Ms.
I will, Your Honor. Thank you. What is the basis for the statement you made that Mr. Burgess found new information?
I guess it was his meeting in our discussions. He indicated that he had found new information.
Did you ask him, what do you mean by new?
Thought they
No, I
barely
took it
talked.
at what he said.
So do you, as you sit here today, have any basis to say that that information is new as opposed to it's always been in existence?
Yes,
What is that?
what he told me.
Oh, so you relied upon the representation of Mr. Burgess. You didn't have any independent document to determine whether in fact it was new.
I don't quite frankly care whether it's new or not. I just care what's in the data. Whether it's new, old, I don't care. It's not relevant to what I'm doing. I don't say this is new data, this is old data. I just care what the data is.
Sir, have you ever?
We didn't ask you if you cared.
Has Aperture ever submitted a report, a changed report in the middle of a trial to your knowledge?
I have no idea.
Do you know whether Aperture has ever submitted an amended report in the middle of a trial? You said you testified in federal and state courts. Can you recall one instance where Aperture has submitted an amended report in the middle of a trial?
So Aperture is like 290 people. I can only speak for myself. I have certainly done amended analysis. Only certain courts and certain legal systems require reports. But for example, rebuttal, analyzing testimony that comes up in court, getting trial transcripts. I very frequently have come up with new analysis during the trial.
Sir, my question is, as you sit here now, can you state one court case where you or Aperture has submitted an amended report in the middle of a trial?
I cannot speak for Aperture. I can only speak for myself.
Can you answer, speak for yourself, sir? Can you then for yourself recall any instance where you submitted an amended report in the middle of a trial?
Amended reports? No. Amended analysis? Yes.
Thank you.
You're welcome.
Mr. Alessi,
Shut
is this
up.
a good time for a break or 5 more minutes?
It's a good time, Your Honor.
Okay. All right, folks, why don't we take 5 more minutes recess?
His little "you're welcome" is like the "I'll allow it." So imperial, trying to jab with "you're welcome." I had a vision, guys, and I'm gonna have to share it with you because when he was counting on his fingers and he was called out for counting on his fingers, and he was like, "Yes, I am counting on my fingers." I heard it in a voice and I just saw it, and you have to see, you know, what that what that looked like to me. That's what I saw. I am counting on my fingers. Oh, for heaven's sakes. Well, this is messy, isn't it? He thinks if he qualifies everything and he answers, you know, different questions, it's fairly typical for kind of what we've gotten to see now for these experts, these opposing experts. And then throw in the professional witnesses like Buchanan and folks like that as well. Everything is clear and helpful on direct, but then you get to cross and suddenly you forget everything and everything depends and you know, and everything is qualified. Well, you know, we'll quibble over the scientific method and how to define that. And I mean, it's like somehow they think they come out of that looking good. You fight with the most reasonable propositions ever, then it really takes away the weight of when you fight on the less reasonable stuff. Well, yikes. What do we have so far? When we finish the direct, he did that paint test, guys, 3 times. Okay. That's, you know, if you think $325,000 sounds like a lot, I mean, he had to do that paint test 3 times and not a single time did he get any paint on the underside of his arm. What did that prove? You know, this reminds me of Ian Whiffin's experiment, where Ian Whiffin proved that he could write a program that would show Apple data doing different things. Like that's what his program proved. He proved that he could write a program that would show, it would allow you to do something on an Apple phone and the program would present it in a certain way. He was able to do that. This experiment, this paint experiment, shows me that he can make his arm sit at the height of the tail light more than once. The outside of his arm. He can create a way for there to be contact between his right arm and the tail light while he stands there. That's what his experiment proved, is that he was able to do that. Okay. I was really waiting, and maybe we'll get there. I suspect we're going to spend a lot of time on this cross-examination with Dr. Welcher. So maybe we'll get to the scientific method and the construction of the experiment, the experimental design, and how you go about doing that to test your hypothesis, and perhaps compare that to this testing that he did with the blue paint. Anyway, I'm getting a little ahead of myself. And so he says he considered these 2 alternatives. One, that the glass was thrown at the vehicle and shattered it. And the second was that his arm hit the taillight and broke it. He determined Not sure how or why. What his basis is that at a speed of greater than 8 miles an hour, it would probably break the lens. That's what he said. Now, it's not clear to me he meant the arm, right? Doesn't the hardness of the item that you're running into or the mass of the item that you're running into have some kind of relationship to how fast you would need to go to break it? You know, if you back at 8 miles an hour into styrofoam peanuts, it's probably not going to break your tail light. But if you back into, you know, a concrete foundation, perhaps it would break. Perhaps it would break it. So I don't know where this, you know, if the speed was greater than 8 miles an hour, it would probably break it. Is that based on an arm? You're telling me the tail light's going to break if it hits an arm at anything greater than 8 miles an hour? What is going to happen to the arm? We'd all love to know. What's going to happen to the arm in that scenario? Of course, he snuck in that, yes, it's consistent with being struck by an SUV and making contact with the hard frozen ground, that rock hard frozen ground in that lawn. Oh, brother. But you can't make it up. You can't make it up. Almost $500,000 these guys have been paid to blame it on frozen grass. So then he has this distinction between side swipes and clipping being different from a direct hit. And he has this very long, wordy explanation for what the distinction is that is really technically quite unclear. But it comes down to basically saying, well, there's no momentum transfer because it's a glancing type of hit. What does that mean? Why is there no momentum transfer? Why would there be no momentum transfer? Because you're not hitting the contact point is not at the center of mass. If you hit it at the center of mass, you're going to have a full transfer of the motion of this mass into this other mass. But if you're not at the center of mass, it's not going to be a full transfer. It'll be a full transfer, but not into your full mass, into just your you know, the part of you that's been hit. So not then we're talking about like vaulting on the car. I don't know what that was about. I really don't. I mean, you're getting into center of mass stuff again now, but the vaulting I sort of thought was based on are we hitting you above your center of mass or below it? If it hits you below your center of mass, you're going up on the hood and over the car. You're going to be lifted from that transfer. But if it hits you above your center of mass, you're going to go down and you're probably going to go under the wheels. That's just how accidents work. And so it's this very technical, but at the same time, not very good or very clear description of why a clipping would be different from a direct hit. It has to do with the center of mass. Okay, guys, I'm not an accident reconstructionist, but this is common sense. This is common sense. And so the problem that I see in this scenario where John is hit on the side of the knee by the bumper of the car, he's hit on the elbow by the tail light, and he is hit on the eyelid by the spoiler. Okay, so 3 parts of his body, low, middle, and high, all hit contact with this car. Tell me, if you can, what kind of posture John is going to be in for his center of mass, which is for a man going to be about his belly button, just above his hips, for that not to be in line with the back of the car. What kind of posture is he going to have to be in for this to be a side swipe that does not project his entire center of mass? He's going to have to be like sticking his butt out, kind of, isn't he? You can like picture that. He's going to have to squat so that his knee gets hit, his elbow gets hit, and his eyebrow gets hit, but not his center of mass. But then as soon as he squats, you're not lined up with the tail light anymore, are you? Really hard to make all this fit. Really hard to make all these moving pieces fit. And maybe that's why we haven't seen any kind of a reconstruction, any kind of a demo. Just one way is all I ask. You don't even have to pretend. You don't have to represent that it's a reconstruction. You don't have to say this is what happened. It can literally just be one possible way that things could have ended up as we found them. Just model that one possibility, and I'd be satisfied. This is a conceivable theory. Of course, you have a little more of a burden of proof as the Commonwealth than just this theory is conceivable. But can we at least clear that bar? You've got a theory that works in the real world. It explains where John ended up. It explains the injuries that he had. It explains the damage to the car, damage to the taillight. Explains the death, all of it. Explains where his hat and his shoe ended up. How did we go from he was hit so far, he was knocked out of so hard he was knocked out of his shoes, to he just had a glancing side swipe hit? Just one. Just show me one. Just show me one. Just one. I feel like there's a reason why I haven't seen not a single one, not a single recreation of how this could have gone down, consistent with what he's testifying to. We're not seeing it because it's inadmissible, because we already saw him do the recreation that isn't really a recreation with the blue paint. It's just showing this is possible. So go ahead and model. Go ahead and model for me where John gets abraded on the side of his knee and his elbow and his eyelid with these contact points with the car, but it's still a side swipe because the center of mass is not behind the car. It's not in line with the movement of the car. So his butt's kind of sticking out some, but he's still tall enough to hit all these points. And by the way, Karen has backed more than 50 feet, 20 feet beyond where she started, which as far as we know is still at the flagpole. And we have no data that shows John walking towards the neighbor's house. So where exactly did she hit John to cause him to end up over there by the flagpole and the fire hydrant? Just show me one. Just show me one scenario that fits all this data. I feel like there's a reason why I haven't seen that. So yeah, we get into this the side swiping, and the direct impact is more severe because of the momentum transfer. Okay. Depends on how the foot is loaded, whether you get lower body extremity injuries. Okay. Then model it for me both ways. What feet are bearing weight and how? If the explanation here is that he's hit and it caused him to roll back, right? Roll off the car, do that sideways turn thing like he did when he totally did not lean into it and then make himself roll. That kind of movement like we saw in his video. We can see some things with our eyeballs and again with our common sense about the kinematics of that. Okay? If you're taking the step backwards, you're doing that with your rear foot. Okay? You were doing that with your left foot in that scenario. You're stepping back. If your weight is already on your left foot and you're getting hit on your right side, it's going to push you over. You don't have that free foot to be able to step aside and get out of the way. So we can already answer some of these questions based on kind of how you're positing this happened. If you're saying he rolled off and stepped away, and that's how we ended up by the flagpole, then we can infer his weight was loaded on his right foot because his left foot, his rear foot, had to be able to step, to take the step so that he could start that path. If his weight is on his left foot, when he gets hit, he's just going over straight right there. So we can already make that inference. But it's not uncommon to see no broken bones. And then they use this other case, this random other case. Okay, a random other case. A guy was thrown 38 feet 11 inches at a 25 to 35 mile an hour impact. There was hair, DNA, and tissue transfer onto the vehicle. He was killed. He had multiple abrasions all over his legs. He had his ribs broken, his lungs collapsed. He had multiple internal injuries and a severe brain injury. How do you think this helps you when John had absolutely nothing like that going on? Absolutely nothing like that. A small abrasion on the outside of his knee, a cut on his eyelid, and then a chewed up right arm. And you think the absence of broken bones makes that a good comparison? Dude, it was not a good comparison. I don't know why you would use that. It just highlighted all of the things wrong with this guy that were not wrong with John. So, the fact that there was no lower body breaks, not a problem. It's consistent with the side swipe injury. You see that with nothing besides red marks on the person's legs. You like what red marks on John's legs? Like what red marks on John's legs? Oh, the little 1/4 inch abrasion? That. So then we moved into cross, and this guy, he really likes to think he's in control of that witness stand, doesn't he? That's his attitude. That's what shows up in that posture, that lounge posture that he adopted yesterday during his direct examination. Looked to me like the guy laying back, you get the pool lounger with the armrest and the drink, and you got your shades on and maybe a cigar. That's like the kind of pose this guy is taking in the courtroom. The little "you're welcome." It's not up to you, motherfucker. You're the witness here. You are here to do what you were told. You are not running the show. Nobody gives a shit if you like what you're doing or not. We don't care. You're welcome. It is not by your grace that these questions are being answered. The questions are being answered so that you are not held in contempt. We clear about that. We clear about your role here. I'm not sure that you fully get it. But I think he keeps pulling this "you're welcome" stuff with the judge. She's not going to like you pissing on her fence there, okay? That's her turf. This is her courtroom. She is the only imperial queen in this courtroom. She's welcome. Imagine thinking that her thanking you is anything other than just a symbolic formality, a thing that people do because it sounds good. Imagine thinking she actually meant it. Imagine, "You're welcome." He's going to piss her right off. He keeps that up with her. So, okay, yes, we started off with some introductions. He's going to jump up. You forget your role is here. Your role here is to answer questions. You're not here to volunteer, introduce yourself, whatever, but you're going to do that. Introduce yourself. "We haven't had the pleasure, Mr. Alessi. What's your name?" Why? You're not going to be using his full name in this courtroom. But do you think that's going to put him off balance? You think you're showing him who's boss by doing that? Challenge accepted. Challenge accepted. So then we go through a lot of quibbling about how do we define the scientific method and various aspects of it, and when do you form hypothesis? And he's coming up with all of these problems with the questions that I'm really not sure exist. The I can't submit my analysis for peer review. Everybody in the lab does. They talked about that. They have a review built into their process. And they rely on, methodologies that have been established, evaluated in peer-reviewed literature. So, for example, they get a new piece of equipment. We get a new piece of equipment in the lab. It's the, I don't know, it's the blood spatter Magnifico 500. Okay. And we're going to start doing some testing on our brand new blood spatter Magnifico 500. So what do? We look at the freaking testing. We look at the studies. We look at the ways that other people have used this machine to produce valid results. And we use it that way. So these are not difficult questions, but he is choosing to make them difficult. And on a certain points, he's trying to be helpful. He's trying to say more rather than say less, which is, it's not a good idea as a witness. Don't volunteer. But he's trying to present himself as being very forthcoming and open. Just trying to be fully accurate here. But then he will stumble because he says too much. He's not comfortable with just answering and letting it sit in silence. He feels like he's got to explain everything. His explanations get him in trouble. So, you don't have a dog in the fight. You don't care. Well, I try. Oh, Alessi is jumping right on that when he stumbles. Oh, so you just try. You just try to be impartial. Well, I'm not perfect. I do my best. Oh. Well, that's good that you try to review the data as objectively as possible. But why would we tell the jury we're not perfect about that? I would think as a scientist you would be saying it's non-negotiable. That is non-negotiable. If I allow bias to seep into my analysis, that undermines the very foundations of the project that I am undertaking here. So we'll see if that continues. He's got to explain and over-explain. And does he continue to dig himself holes by doing that? Confirmation bias, he's familiar with, but cognitive bias, well, I'm not a human factor expert. I'm not an expert on cognitive. I don't want to step out of my lane on that. Well, you can talk about what you do know, what you do understand. It's not a completely foreign concept to you, I'm sure. So then lots of arguing about alternative hypotheses, how that fits into the scientific method. How does this happen? No, we're going to argue like forever about the timing of that question. It's your fundamental question, dude. It's literally why you were hired. It's why you were hired. How did this happen? And then we get these explanations after we've just established the scientific method is a process of coming up with hypotheses that we are then able to test and evaluate against the evidence. But his explanation is he has a ton of hypotheses that he's evaluating even before the evidence comes in. Where is the damage? What are the injuries? What black box evidence we have? Those are not hypotheses. What evidence do we have is not a hypothesis. It's a question. It's a question. I guess if we want to turn that into a hypothesis, it would be, I hypothesize that there may be injuries. If this was a fatal car accident, I suppose that would be your hypothesis, but you don't actually have to hypothesize that because you're provided with the data first. So this round and around and around, being argumentative, No, you don't ask, how did this happen? It's literally why you were hired, dude. Of course you ask that. That was the entire purpose of the Commonwealth paying you over close to $400,000, as far as we know. So you have lots of hypotheses in the beginning, but you're continually evaluating them as the data comes in. And as a general principle, the one that most consistently produces the same injury will emerge as the mechanism of injury. Now, of course, it depends. Everything is case by case. And so in this particular case, you know, if it was the rarest incident that we decided is the mechanism of injury, maybe the needs of this case called for it. I mean, did anybody understand that qualification? I didn't understand this qualification. It depends. It's case by case. I would think, as a matter of logic, if you have one explanation that continually emerges as consistent with the evidence you have, yeah, that's probably the most likely one. I don't know why we would argue with that. Getting ready to come back, so I can finish my recap of this so far. But then we turn to Trooper Paul. Yeah, we are going to get into Trooper Paul.
You be seated, court is in session.
Let's get back to Trooper Paul, Alessi, because that was fun.
All right, whenever
about
you're ready,
more of that.
Mr. Alessi.
Thank you, Your Honor, and if I could please address an administrative matter that I wish I didn't have to address. Dr. Welcher was just using, at least my observation, his computer. He still has monitors on his desk. Could we have all that removed, Your Honor?
Closed, yes.
Would he open?
So it's just, did you just turn it on?
No, but I will. I close it. You want the computer all the way off or just everything?
Is he going to need to turn his computer back on?
I do not see a need for the computer to be turned on. Do we have the ability to put the presentation and documents from our
So I'm
sub?
going to see counsel at Sidebar,
Sure.
please.
Doesn't want that chit chat happening in front of the jury. Oh yeah, he's trying to be helpful, but you're looking at all the stuff that you're not supposed to look at. This ain't your first time in court, dude. This is not your first time in court. You know the game. You know the game. So you're gonna sit there and flip through your papers and look at your screen to try to find your answers in there. But then the problem is you're not listening to the question when you do that. You're already busy hunting at the screen, paying attention to that instead. Well, so we got into Trooper Paul and how Trooper Paul was on the case for 2.5 years, and then they were retained a couple of days before September the 23rd, paid $44,500 in November. He doesn't know that, so that's not technically in evidence.
During the lunch break, I'll ask you to remove those monitors, okay?
I'm sorry?
During the lunch break, I know it takes you a while to set up in the
Yeah.
morning. I'm going to ask you to take all that down during the lunch break,
Thank
okay? Thank you.
Take it all down during the lunch break. Get comfortable because they'll be coming back after lunch.
May I, Your Honor?
Yes.
Thank you. Dr. Welcher, we left talking about the amendments you made to your PowerPoint presentation. And in terms of the amendments, are you aware that the defense counsel received your amended PowerPoint presentation at 3 p.m. on Memorial Day? Are you aware of that?
No.
And you began testifying the day after yesterday, correct, sir? Day after Memorial Day?
I testified yesterday.
Yes.
And yesterday was the day after Memorial Day.
Are you aware of any activity in this trial of any kind before you testified yesterday?
Again, as I mentioned, I've been getting random emails, and then I've been seeing it pop up on my news feeds as well. But once I was aware of the reclusion, I made sure to not review any of that. But as recently as last night, I got an email that said biomechanical engineering job, or like applying for a job. And I opened it up and it was some internet troll.
Sure. I'm asking about emails from the prosecution.
Oh, no, there's been no emails about what's been going. I mean, there's been scheduling, when am I going to come, things like that.
How then was it determined that you were going to be able to amend your power presentation if you weren't communicating with the prosecution?
I mean, they asked me about the witness statement of 138 right around May 13th.
How did they ask you about that, sir?
I don't recall if it was a Zoom meeting, a phone call.
So there was a communication with the prosecution, might have been by Zoom, might have been by another method, but there were communications while this trial is going on relative to you amending your PowerPoint that ended up with an amended PowerPoint on May 13th. Do I have that correct?
I believe so.
I'm going to switch topics.
Okay.
One of the goals of
Sure, let's
Aperture's
there.
analysis and reconstruction was to determine the location and timing of certain text stream events, correct?
Correct.
EDR data.
I'm sorry, my role.
Your role, yes. EDR, and just for clarification, EDR is Event Data Recorder, correct?
Correct.
So I'm going to refer to that, as you have before, as EDR, Event Data Recorder.
Sounds good.
EDR data does not show the location associated with a text stream event, correct?
In this particular vehicle, it does not.
And the EDR data for this particular vehicle, namely the Lexus SUV, also does not provide the time associated with a text stream event, correct?
Not at the time of this event.
So the answer is no, correct?
That is not correct.
So let me ask the question a slightly different way. The
Gonna argue about nothing
EDR
again?
data does not provide the time. The EDR data for the Lexus SUV that you've been talking about does not provide the time associated with a text stream event, correct?
That is correct.
Instead, every text stream event is associated with a particular key cycle on the vehicle, right?
Correct.
There can be multiple text stream events in a single key cycle, right?
Correct.
And every time you start the car, this one you push the button, that's a new key cycle, right?
That will cause a key cycle.
And the EDR data indicates the number of seconds into the key cycle that the particular event occurred, correct?
The EDR data, no.
So EDR data gives you no information about the number of seconds into the key cycle that a particular event occurred.
You're confusing EDR data and text stream.
I'm not, sir, I'm just
Are you not?
asking a question.
So
If it's yes or no, I'm fine with that.
EDR data will, depending on the vehicle, sometimes it has information about GPS date and time. Sometimes it has ignition cycles, which are a little bit different than key
You don't
cycles,
care about other vehicles.
which is why you frequently have different ignition cycles versus key cycles in EDRs compared to text stream.
So let me ask it a different way.
Okay.
The text stream data indicates the number of seconds into the key cycle that a particular event occurs.
Yes.
Is that correct?
That is correct.
In order to properly determine the location and the timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle, correct?
I think I'm going to say yes, that text stream tells you the trip.
I'm just asking if it's important that you correctly identify the trip associated with a particular key cycle. And do so by determining, in order to properly determine the location and timing of a text stream event.
So the text stream tells you the trigger event and it tells you the key cycle. So I'm not determining that, I'm reading that from the text stream data.
Okay, so in order to properly read, to use your verb, the location and timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle. Is that a fair statement?
I think that's a fair statement.
If you associate the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will be wrong, correct?
It can. I mean, you need to take the totality of the evidence in the text
Totality
stream,
of the evidence
with
now
the
is a disclaimer.
mileage, the overall timing into account.
So are you saying, sir, that if you have the wrong trip with the wrong key cycle, you can get the correct text stream event?
No, not necessarily. Again, you have to take the totality of the data.
This guy is now saying nothing.
My
He's saying
question
nothing at all.
is with regard to if you have the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will also be wrong. Isn't that just a matter of logic, sir?
Mm-hmm.
So again, the text stream event tells you the trip and it tells you the time. If you're saying I'm
Where does the text stream event
associating
tell
that
you
with the
you're on
wrong
Cedar Crest?
infotainment information or vice versa, then that would be wrong. But the text stream data tells you how much time is associated with each trip. There's no difference there.
If you associate the wrong trip with the wrong key cycle, then your estimate of where the text stream event occurred will be wrong. Is that correct?
You can't associate the wrong event with the wrong key cycle because it keys in the key cycle with the event.
He's arguing over the wrong words. Nobody's arguing about the event and
Let
the
me
key
try
cycle.
it a different way. Your analysis or anyone's
Weaponized
analysis
stupidity right here.
in conclusions regarding the timing and the location of the text stream data are only as good as your ability to correctly associate a key cycle with a particular event. Is that an accurate statement?
No. Again, you need to take the totality of the data. So that is one element. You need to look, for example, at the mileage. You need to look at the timing of the events. So this is considered a tool in the analysis process. You need to look at the totality of data to see how it matches up with the physical evidence.
So are you saying that you can have an incorrect key cycle with a particular trip, but you can still get accurate timing and location of text stream data?
So again, you don't get incorrect key cycle with the trip. The trip and the key cycle are coded in by the text stream. If you are attributing an event to the wrong trip, which has a fixed key cycle, that could be a problem.
Exactly. So if we could go, if Your Honor, if we could publish a slide, please, that is in evidence.
Okay.
Thank you.
What are we looking at?
Pardon me?
What slide number?
I've got slide 9. Mr. Wolk, yes, I've got the correct one. Thank you, Your Honor. So I'm going to use the acronym VCH that you've used on your, do you recall using the acronym VCH on your direct testimony?
Yes, sir.
And VCH stands for Vehicle Control History, correct?
Correct.
You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
You viewed the vehicle control history on September 23rd, 2024. Yes?
That is yes.
You took photographs of the vehicle control history, including key cycle 1167.
Correct.
And in this screenshot, we can see 4 text stream events that
Actually,
are,
can you zoom in on the key cycle?
oh, sure.
Sure. Why, yes, we can.
Because I think when I got to, no, scroll. So when I got to it, you can see it was at key cycle 1264. The blue highlight was the last file that was written on key cycle 1167.
Right.
So to answer your question, I got
There's
it at
been 100
1264.
key cycles.
So we can go back so we can see the 4 text stream events. I just want to reestablish the foundation here. In this screenshot, we can see 4 text stream events that are associated with key cycle 1167, correct?
Correct.
But isn't it true, Dr. Welcher, that there were actually 10 text stream events associated with just that one key cycle 1167?
Correct. I gave you the original files.
Right. So you are aware that the Commonwealth had maintained up into your firm's engagement that.
Are you saying there's no basis for the question? All right, I'm going to allow the question and I'll hear it.
You are aware that the Commonwealth has maintained up until your engagement in September of 2024 that all text stream events associated with key cycles 1164, 1165, and 1167 occurred while the Lexus was in the custody of the Massachusetts State Police at the Canton Police Department.
Okay.
So the objection sustained. You need a foundation, Mr. Alessi.
You read
Sir,
Trooper Paul's
as
report?
part of your work in your review of the many
What's the staring at
documents
there?
that you referenced on your direct examination,
What you staring
did
at there?
you review the text stream events associated with the Lexus SUV?
I reviewed the one I downloaded.
Pardon me?
I reviewed the one I downloaded.
Right, and did that, what you download, include key cycles 1164? Did it include that?
It did.
Did it include 1165?
It did.
And did it include 1167?
It did. It did not include 1166.
I didn't mention 1166, sir. I only mentioned 1164, 1165, and 1167. I purposefully skipped because I didn't understand you had reviewed it. So here's my question. You therefore, based upon the fact that you reviewed them, and you said it's important to understand timing, et cetera. That's very important in your forensic analysis, correct?
Yes, sir.
So let's go to the timing question and you understand where the Lexus has been at various points in time. You testified to that in direct, whether it was at the Canton Police Department, whether it was being towed, correct?
In addition to having Mr. Burgess analysis in the data.
In addition to Mr. Burgess analysis, so in that analysis contained locations of where the Lexus had been.
It contained where it had been and also include date and time, when it was turned on, when it was turned off.
Exactly. So not only did you have all the locations, you had dates and times associated with the location where the SUV, the Lexus SUV had been, correct?
Correct.
Now to the question. Based upon that review, that knowledge, that understanding, those bases, you're aware, and you've reviewed, by the way, Trooper Paul's reports, correct?
I have.
There were 2 reports of Trooper Paul. There was his original CARS report and then a supplemental report that were listed in the documents you reviewed. Do you recall that?
I don't recall that, but I'll take your word for it.
I don't want you to have to take my word. Do you recall, sir,
No, I
that there
don't.
were do you recall that there was a report of Trooper Paul?
Yes,
Okay, and you read that report, I assume, sir?
I did.
And it would be important for you to read that report and read it carefully because it addressed the subject matter that you were addressing, correct?
No, I did my own independent analysis. As a matter of fact, it'd probably be more important that I don't do that to avoid confirmational bias.
But you did read Trooper Paul's report.
Of course.
So you therefore are aware that the Commonwealth has maintained up into your engagement.
Objection.
Yeah, I'm going to see a sidebar on this.
That seems like pretty good foundation to me, because it's in Tr Paul's report, isn't it? It's in Tr Paul's report. No, it's not at all important to read it carefully. No. Can you believe this guy? So the list of all of the things that you were provided to review, to which of those items did you apply this subjective determination that it would be better not to review that? How many of those long list of items that you reviewed did you subjectively determine you shouldn't review them carefully because they might contribute to confirmation bias? Karen reads clips? No, it seems those were important to review carefully. It's so important that you changed your slides at the 11th hour based on a clip of Karen Reed saying something. Those are very important. Not problems with respect to confirmation bias. But reading Tr Paul's report, you absolutely would not do that carefully. I mean, I don't even know what we're supposed to make of this guy at this point. I pictured Ralph Wiggum helping before. Now I'm picturing the Ralph Wiggum eating the paste. I mean, my goodness, this is just a mess. I like Alessi is cracking the whip a little bit. I didn't ask you about 1166. He's going to go ahead and volunteer this stuff. He's going to try to talk around the question. I didn't ask you about that. So once again, he's redirecting him to what he's actually asking. Pay attention to what I'm asking. Don't think you know what I'm asking. Just answer what I'm asking. So, I mean, that is my recollection from the first trial, right? 1164, I thought was Tr Paul's test, his acceleration test. Thought that's what he testified to. So everything after that, yes, would have been while the car was in his possession. So this is kind of so far reading like a recap from trial 1 of you got the wrong key cycle. You didn't count back because contrary to saying the trip and the event are recorded in text stream, see how he's being very careful with words when he wants to quibble, but then not careful with words when he wants to explain or make a point or something. He wants to try to avoid the question. What do you mean by trip? What do you mean by trip? The trip is, for example, Karen went to the grocery store and then she stopped and got gas on the way home. That's a trip. Okay. And that trip happened on a certain day at a certain time. And if during that trip, she hit the gas a little bit too hard and caused a trigger event, how do you know which key cycle contains that trigger event? This is what's going back to what we were talking about when I was like begging Grayscale, please help me out. Please. Grayspace, help me figure this out. What's did I say Grayskull? Did I like totally He-Man you? Grayspace. Help us out with, is there some kind of connection between the infotainment timestamps and the text stream data? Because it seems like this is also just being done kind of by inference. It's like, well, the timing fits. She was in the car. It was running for about this long at about these times. So we think it's probably that. Or is there something actually objectively in the data that's like the key cycle is linked to the infotainment system, like the infotainment system records the key cycle, or the text stream data, has a date or an associated something from the, like, how are these two things tied together? And it doesn't sound like it's in the data. It sounds like this is just part of the process of analysis that they're doing, where they've looked at this text stream data and they've seen, okay, these events occurred within these time frames, these many seconds after the car was started. And we can look at infotainment history for the night in question, the January 29th, and we can see the car was powered on and powered off. And those text stream events occur within a window that is like large enough. Okay, the trip was long enough that these two events that happened 10 minutes in and 8 minutes later, roughly, it means it was at least a 20-minute trip, right? Or thereabouts, at least an 18-minute trip, because we had room for two text stream events. But otherwise, we're just kind of matching, clock availability is really what it's starting to sound like. So did they line up the right infotainment running clock with the date and the right text stream events? And I think that's what's getting us back to trial 1 now, where we didn't have any of this time or date data at all, kind of muddying the waters a little bit. We just had the key cycles, and we had to identify how many times the car has been turned on and off to be able to count back. And so we already knew it was not 1162, because if Trooper Paul did his reverse testing at 1164, that means 1163 was taking it off the tow truck into the Canton Police Department, Sallyport, and 1162 was loading it on the tow truck. 1162 would have been loading it on the tow truck. 1161 would have been the drive to Dighton. 1160 would have been the drive, around that morning, ultimately going to Jen's and ending up at John's. And 1159 would have been the trip the night before. So you have like 5 key cycles in between those events. So the math didn't math. And it seems like that's kind of what we're coming back to here. It was on key cycle. This still blows my mind. It was on key cycle 1264 when he got there. They have turned this car on and off 100 times. Got into law enforcement custody. 100 times? What are you turning it on and off for? Just explain that to me.
May I, Your Honor?
Yes.
Thank you. Are you aware that over the course of the Commonwealth's and your investigation into this case, that the theorized time of the alleged contact of the SUV?
So there's 2 words, just strike theorized.
Okay. Thank you, Your Honor. Are you aware that over the course of the Commonwealth's investigation and your...
Hold on, Mr. Alessi, the court reporter can't hear you.
Thank you. I will.
Hello, Siren.
I'll object again to the question that's coming.
You don't object before the question is out.
Can I
Go
begin
ahead
my
and
question?
ask a It's an appropriate question, Mr.
Ask an appropriate question. Totally fine for the jury to hear that.
Do you have knowledge whether there is one time or more than one time for the Commonwealth's position, as you know it from reading documents that you said you've reviewed, that there are different times alleged for the incident to have occurred at 34 Fairview?
Objection.
Sustained. You can ask the question, remove part of it.
I'm sorry, Your Honor?
You have to remove part of that sentence.
Okay, understood, Your Honor. Do you know whether there is more than one time that has been proposed by the Commonwealth for the impact alleged to have occurred at 34 Fairview?
Objection.
Sustained.
Doesn't want him to say alleged by the Commonwealth.
I'm not giving the instruction now.
Dr. Welcher,
What instruction?
in terms of the analyses that you have reviewed in this case, is there one time that you understand there to be for a hypothesis for the time of the impact at 34 Fairview?
Objection.
I'm going to see you again, folks. I'm sorry about that.
I don't know what the problem is here. What's the problem, Bev? Is it the alleged by the Commonwealth thing? This is not a problem. I'm not quite sure why this is a problem, pointing out that the prosecution has changed their theory. 2.5 years, they had a theory with Trooper Paul, and now 8 months later, $300,000 later, they have a new theory. This is appropriate cross-examination. Remember, she was going to allow Mr. Alessi a robust cross-examination. Like, he doesn't have the right to do that already. He has the right to do that. So this whole, nitpicking around the edges of the question, she wants it to be done a very specific and certain way. Really unclear what the so-called impropriety is. And very improper. Hank objects to the question that's coming. Okay, you don't do that. The question, you ask the question, and then you can object to it. You don't pre-object because you don't know what he's going to ask. And what does she say? Ask an appropriate question, Mr. Alessi. So what does that mean? It means when she sustains the objection, she's communicating to the jury that's not an appropriate question. It's not an appropriate question. What's inappropriate about it? Perhaps the jury should know that too. What's inappropriate about it? Nothing inappropriate about it that I see. She wouldn't let him say the theorized time. Strike that. The theorized time of the impact. Strike theorized. She's got some beef. She's got some beef with him. I don't know. Attributing this position to the Commonwealth, I guess. But I don't see why that's a problem, because it was, in fact, the theory of the case for 2.5 years leading up to the first trial, until the time that they went ahead and hired these guys. If Karen goes to the grocery store and then stops to get gas on the way home, and during that trip, she hits the gas pedal very hard, causes a trigger event, and we go back then and we looked at the vehicle control history data, and we see that over the last 9 months, we got her car sometime after the fact, and so we get the last 9 months worth of VCH data, and it shows us the triggering events for when she hit the accelerator they hit the accelerator pedal too hard. How do we know how to sync these two things? Like, you synced the clock because you found the simultaneous event. So you really need the simultaneous event, something similar, to be able to sync the text stream data with the infotainment data, the time frames. I'm forgetting to mute that again, so sorry if my sound is being real bad. I keep forgetting to mute the live stream because I want to hear them when they come back. You have to have a way to sync them, and so I haven't heard of anything that they did to sync them. We just know that, okay, the window of time recorded by the infotainment system on this date is large enough that it could include these two events from this key cycle. Okay, it was at least, I guess, 20 minutes that the car was on and off. Is it the only time in the vehicle infotainment history that could have fit those two trigger events? If it's the only time, then I could see that as maybe being a basis for that thing to fit. But I find it hard to believe that Karen has only turned her car on and off over a 20-minute period, one time. One time. So I don't think we still have any particularly good insight into how and why these things align. They're just telling us that they're the same, but that part of the analysis is just vanished. We don't know why, other than just the fact that, well, they can make it work. If they can make this one work to make it look like these key cycles, these triggering events on this key cycle are associated with the time frame of when Karen Reed's car was at 34 Fairview, then we can make it look like there was an accident. But I don't know why there's anything like inherent in this key cycle or these triggering events that would tell us necessarily it happened at this, when the infotainment system turned on at this time and at this date. So we can't ask about what's theorized. What was this? I'm not giving the instruction now. What instruction? What instruction? There is some crazy micromanagement going on at Sidebar, it sounds like to me. I mean, they're getting real deep in the weeds on what he's allowed to get into and how he's allowed to ask it, and now some kind of instruction. You're going to get some kind of instruction at some point. I don't know. What instruction? I mean, is it an instruction that I don't know. I can't even imagine. The Commonwealth's Commonwealth is a party to the case. I have no idea. I really don't. I'm really struggling to come up with what do we need to instruct the jury on to get through this testimony to this point that he's changing the Commonwealth's theory from what it was with Trooper Paul. And we're trying to establish that in a very specific context. We need to look at what was retained and what was discarded. And it seems that what was retained was the key cycle 1162. They're hanging on to that from Trooper Paul. But if they're hanging on to that with Trooper Paul, then that means they're getting all of the downsides of that well, which is that the math doesn't match with the number of trips.
Excuse me. What number is it? 37. Yeah, Your Honor?
Yes.
Thank you. I'm going to move to, for the moment, we'll come back to the other topic a little bit later. As we discussed earlier, you've got on various documents, you're a biomechanical engineer, but I've also heard you make reference to biomedical. Can you just tell me what you consider yourself, sir? Is it is biomechanical engineer something you consider yourself to be?
Sure. My degrees are in biomedical engineering. The discipline within biomedical engineering that I practice is biomechanics.
Right. And so is it accurate to say that you are a biomechanical engineer?
Yes.
And you say that much in your report, correct?
And the CV and resume I gave you.
Right. Now, in your report, and Your Honor, I have no issue if he refers to the page of his report.
Do you have a paper copy or do you need your?
Oh, better believe he's got a paper copy. He's been over there
Turn to page
squinting
9
at it
of your report.
throughout all of this.
Okay.
And on page 9, you state, as a biomechanical engineer, I have no opinion on any aspect of, and I think you're referring to Mr. O'Keefe's medical treatment or medical diagnoses. I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. Did I read that correctly?
You did?
In that statement, I assume, given you wrote it, is a fair representation of your professional role in this case?
Yes.
And you go on to add on page 9, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. Did I read that correct?
You did?
And on your direct examination, is it correct that you stated as a civil engineer, you made an analogy, you assessed the cables and beams of a bridge as you would assess the cables and beams of a bridge, you assess the human anatomy. You made that analogy, correct?
The analogy that bones are my bridge elements, cables are muscles and ligaments.
Right. And you stated that it's the job of a biomechanical engineer to quantify the force acting upon a person to determine the cause of their injuries, correct?
That is part of what we do.
It's part of, but it is therefore something that a biomechanical engineer does, correct?
Given sufficient data, yes.
So you know do you know what a force calculation is, sir, when I refer to that term?
I believe so.
What do you believe it to be?
Well, force is usually a physical measurement, but you can also use Newton's second law, which is force equals mass times acceleration.
That's exactly what I wanted to
F
say.
equals
Newton's
MA.
second law
Okay.
is, and sometimes referred to as the second law of motion. And in the second law is force equals mass times acceleration, correct?
Correct.
And just sort of like simple algebra, sometimes you have one or more of those, but I'm focusing on when you're trying to determine, sir, you're pulling something out.
Calculator. I thought you were going to ask me numbers, do calculations.
All right, we're going to do that, we need to do it with the court's permission.
Sorry.
If you feel you need to do that, just let me
You
know.
can just leave it right
All
here.
right.
So I just want to get the principles down first. So Newton's second law, force equals mass times acceleration, and force is oftentimes what you're trying to calculate in a force calculation, correct?
Calculate or measure, yes.
Yeah. And Newton's first law is the law of generally inertia. An object at rest tends to stay at rest. Object in motion tends to stay in motion. We're not talking about that in force. We're talking about Newton's just second law, correct?
You asked me two questions. Newton's first law is generally, as you said, it could be at rest or at constant velocity, but yes.
Okay.
That's what he said.
And that
What's
Newton's
the third
second
law?
law is generally just a mathematical calculation, correct?
Yes.
What's the third
So
law?
what I'd like to do is to turn to page
Are we going to get to talk about
11
the third
of your report.
after we do some force calculations?
And on page 11, you discuss the force calculation in conjunction with the part of your report where you discuss your experiment where you dropped a test dummy backwards, correct?
Correct?
You determined that a fall of 69 inches, at that fall, Mr. O'Keefe's head would have accelerated with 458 G's of force?
That's what we actually measured
Right.
in the
And
test.
can you tell the jury what is meant by G's?
So G's is a measure of acceleration. If you usually acceleration is measured in feet per second squared. If you divide it by 1G, which is 32.174 feet per second squared, that gives it to you in G's. People often heard about fighter pilots losing consciousness at 6 or 7 G's. It's because your blood's getting sucked away from your head, not because you're being impacted. But G forces, or G's as they're more properly called, is a measure of the acceleration. It's just whatever the acceleration is divided by what we all feel when we're standing here, which is 1G of gravity.
And you estimated Mr. O'Keefe's head weight of approximately 15.7 pounds. You used a percentage. Is 15.7 about right for the mass of
Yes.
the head? So if we apply Newton's second law, we keep F force open as the unknown. We take and apply the mass, which is 15.7, multiply it by the acceleration. You end up with a force acting upon Mr. O'Keefe's head of 7,200 pounds. Do I have that right? That's right out of your report.
So that math is all correct. Falling backwards onto a hard surface from his standing height will give you approximately 7,200 pounds of force.
In that 7,200 pounds is the previous unknown F in the Newton's second law equation, correct?
Correct.
So now we have an answer for F, 7,200 pounds. Now you then go on to note that the applicable scientific literature states that a fracture to the occipital bone, and just to review, the occipital bone is the back of the head right here, right?
Correct.
So you then, as I understand it, you go to the scientific literature and you concluded that a fracture to the occipital bone can occur with an average force of 1,634 pounds from a fall distance of 40 inches, correct? I'm sorry.
How many inches?
40. That's in your report?
Well, you mixed two things together. There was stuff that reported force data. You had those numbers correct. A range of between 1,150 and 2,150, a mean of 1,634 pounds. And then it says, and a drop distance as low as 40 inches.
Right. And is the number 634 pounds a proper number for an average force?
Did you say 1,634 pounds?
1,634.
Yes.
Okay. So what I want to do is see if this is correct. So if you can get a fracture of the occipital bone in an average force of 634 pounds.
No. 1,634.
I thought that's what I said. If I did, I missed.
Oh, I'm sorry. I just heard 634.
No, 1,634.
My apologies.
And
You're welcome.
compare that to the 7,200 pounds of force that you calculated. Surely you're going to have a fracture of the occipital bones through that calculation in that comparison, correct?
Correct. Falling on a hard surface can definitely fracture
Right.
your skull.
So I'm not getting at the manner. I'm just applying the Newton's second law. Newton's second law doesn't look at manner, does it? It just looks at force equals mass times acceleration. Newton's second law doesn't look at the surface, does it?
So it's a function of the surface. The A value is a function of the surface you hit.
So you're saying acceleration depends upon the surface?
Yes, of course.
Okay, all right.
For an impact, it does.
Now, let's go to the study you cited. Injuries to pedestrians in real accidents in their relation to collision and car characteristics. That's in your report, correct?
What reference number?
May I, Your Honor, grab the report?
Yes.
Thank you.
I mean, I
So
don't
even
quite
if it's in
understand
your
that,
report,
other
so you
than
can
if
find
there's
out
give
who's
in an
allowed.
object, right? That's the falling backward into the styrofoam peanuts versus falling backward onto the concrete. There's more give in the styrofoam peanuts, so I'm going to like decelerate before I come to a stop. Is that what he's getting at?
Number 25,
That's the one I think it is. I just want to check your report.
would you like me to actually pull up the paper?
No,
Okay.
just want to get to the,
Well, I accept
that's
this
it, number
answer as
25.
definitive.
We're talking about the same one. Now, isn't it true that this study states that head injuries are the most common injury type for motor vehicle collisions, constituting more than 61% of all injuries sustained from motor vehicle collisions?
Or can the witness see the document that's being referred
Do
to?
you have your report in front of you?
I have my report, but reference 25 is not in the section he's referring to.
Why don't you show it to him, Mr. Alessi?
I do not have with me a copy of the report he cites in his reference. He did, can I ask another question? Your Honor?
Yes.
Thank you. Dr. Welcher, on your direct testimony, did you not discuss the percentage of pedestrian injuries
It's in a chart in his PowerPoint.
and relate it to heads? Did you not, on your direct, talk about percentages of injuries that are head injuries in impacts of pedestrians with cars?
Yes, I did.
Okay, so you came up with a number. What I'm trying to do is to compare that number to the number in the study that you cite. If you don't remember, that's okay. We'll just move to the next
Can I
question.
go to my slide?
Whatever you can use to determine what was the percentage that's in the study that you cite in footnote 25 of your report.
Sure. That was also from my presentation that I gave. It's 61.5 for all injuries, 12.7 for fatal injuries.
Thank you. So I'll repeat my question and then we'll get it in logic. So that study states that head injuries are the most common injury type from motor vehicle collisions, constituting slightly more than 61% of all injuries sustained from motor vehicle collisions, correct?
That number is correct. You're quoting a sentence. I would want to pull the paper up, but the number is correct.
Okay, so doesn't this article also state that of all head injuries sustained by motor vehicle collisions, only 12.7 of them are fatal?
That does, yes.
Did you mention that only 12.7 are fatal on your direct examination?
It's circled with a red box on my slide.
Did you mention that on your testimony
I
on direct?
thought I did.
This article was published back in 1979, correct?
I believe that's correct.
It's 46 years old, therefore, if I did the math correct, right?
That sounds correct.
Are you aware that given advancements in science since 1979, advancements in medicine, advancements in technology, the currently understood most common injuries as a result of pedestrian motor vehicle collisions are injuries to the lower extremities?
I'd have to see the study. That wouldn't surprise me. Car technology,
Oh, really?
especially, for example, with pedestrian safety systems, has caused autonomous braking. So you're getting fewer higher severity crashes, which results in a higher propensity for lower extremity injuries. It's the higher extremity crash that causes the head to either slap into the hood or the window and or off, to where if you get the lower severity crashes, you can still maintain a standing posture. So it wouldn't surprise me if that's accurate.
So you would agree
I don't know what he just said.
that as of January 2022,
You think cars are smaller
the
now?
most common injury as a result of a pedestrian motor vehicle collision is one to lower extremities?
No, I wouldn't necessarily agree with that date. And again, you have to look at frontals versus rears.
So you can test that the Most commonly understood injury as a result of a pedestrian motor vehicle collision is injuries to lower extremities.
Hey, that's about a source.
I'll allow the question.
So I'd want to see the data. Again, most cars, for example, this Lexus has a pre-collision system in it that will start to apply the brakes if it senses a pedestrian at the front of the car. And so for frontal collisions, it's transitioning, taking what were head injuries, because they're more severe, higher speed crashes, making them lower speed crashes and shifting the injuries to the lower extremities. Just like airbags shifted the head injuries away from the severe ones, and we started getting more or higher ankle and lower leg injuries. So the change in the technology, but for backing, that may not be the case because you have different geometry on the vehicles and you have different safety systems.
I'll try it a different way.
Mm-hmm.
Do you have knowledge, as you sit here today, whether the most common injury from a motor vehicle accident is to the lower extremities?
I'd have to look at the literature. I have the article I gave you.
So the answer is you don't know the answer to that question. Is that correct, sir?
I don't know it off the top of my head.
All right. The Newton's second law analysis that we went through, force equals mass times acceleration, where we came up with the 7,200 number. You didn't discuss that calculation on your direct examination, did you?
I don't think so. We didn't discuss a whole bunch of those things that were that wasn't necessarily an opinion, that was a sub-opinion or basis for my opinion.
You didn't discuss
He's so defensive
that
about it.
Newton law calculation on
Why
your
so
direct
defensive?
examination,
Didn't discuss
did
it.
you,
So
sir?
what?
So in a way I did, because I said my drop testing shows that you can do this. So I didn't quote that number, but we are going through the specific numbers now. But I absolutely did say, as a matter of fact, I showed a video of my drop testing and talked about how falling onto a rigid surface, a hard surface, can cause a skull fracture.
Did you discuss on your direct examination applying 15.7 of the head weight to 458 Gs and come up with a number of 7,200? Did you do that on your direct examination?
Those specific numbers, no.
Thank
the general
you.
concept of the drop testing and what it showed, yes.
So instead of that calculation, you referred to a flow chart comparing injury characteristics of flaws versus blows. Do you recall doing that on your direct?
So you asked me two questions. You said instead of, so that's no, it's not instead of. They're two completely different topics. So no, I didn't do that instead of.
Okay.
I looked at a force analysis, then I looked at 3 peer-reviewed publications that were attempting to differentiate whether an injury is associated with a fall or a blow, an assault, and they came up with a metric for doing that. Those things are completely separate.
Let's ask it this way. Did you, on your slide presentation that you presented to this jury, did you put the inputs into F equals M times A in your slide presentation with the numbers we talked about of 15.7 for the M and 458 for the G to come up with 7,200? Was that anywhere on your slide presentation?
So the slide presentation showed the 458 Gs. The rest of it was not on there.
Thank you.
You're welcome.
You're welcome.
You
You're not
also
doing yourself any
indicated
favors, dude.
that the laceration above Mr. O'Keefe's right eye is consistent with the shape and height of the fin on the top of the Lexus SUV. Do you recall that?
Correct. It's actually properly called a spoiler.
And
Oh, you figured that
so
out
you would
now?
call
Did
it a
you go
spoiler
online?
instead of a fin?
Correct.
Fair enough. We'll call it a spoiler. You visited
Called
the
it a
scene at
wing
34
yesterday.
Fairview, correct?
I did.
You stated that you like to visit the scene while you're working as an accident reconstructionist so you can get a better understanding of the data?
I don't know if I'd use the word like, but we want to go to the scene to see the scene.
When you visited 34 Fairview, did you go into the garage at 34 Fairview?
No, I actually didn't set foot on the property.
You didn't set foot on the property?
No, I stayed in the street. It's my understanding there were new owners.
Did you consider the scene limited to the road?
So the access I had was to the road. The laser scanners and the photographs will extend further, but I didn't have access to the interior of the house.
Oh, so you didn't access the entire scene, correct?
In my opinion, I did access the entire scene. I didn't physically step 7 feet onto the grass to the point of rest, but I stood and photographed where that was. I didn't want to trespass.
Where did you understand the body of Mr. O'Keefe was located?
I know it was 7 feet in from the grass. I've seen cruiser cameras showing people around a body. It's slightly north and slightly south and a little bit west of the flagpole.
But you didn't access that part of the scene that you just described, correct?
I absolutely did. I took photographs of it. I didn't trespass and stand at that exact location, but I stood right there. We scanned the whole thing. The scanner uses a laser beam that goes out, 150, 200, 300 feet. So we scanned all that stuff.
Did your scan topography?
Yes.
Then you know that there is a berm raised above street level, correct? If you did the scan.
Correct.
Do you know the height of that berm?
I believe it's 4 inches.
Nowhere in your report, when you're comparing the height of Mr. O'Keefe to the spoiler, do you account for that 4 inches of the berm, do you?
So yes and no. As I indicated, we don't know exactly where the point of impact is, whether he was completely in the road or up on the berm. But for example, where the tire spins on the Lexus, that could be where she's driving up on the curb. And so then that tire will be at the height of the curb. So if he's standing on the higher part and the right rear tire of the Lexus goes up there and spins, then that would be at the same height. We don't know the exact point of impact. So I don't know whether he was on the road or in the street. Excuse me, on the street or on the side of the road.
Exactly, but when you did your depiction on your slide,
You assumed he's on the road.
You measured the height. You did
Absolutely.
that.
Yep,
Where was it? Was it you in that slide?
it was
Where were
Dressed
your
in the
feet?
clothes?
on the ground.
Not on the berm, correct?
Correct.
Okay, so you chose the measurement, which was the ground, to the top toward the spoiler, and you took a measurement. And you said that approximates the height of Mr. O'Keefe, correct?
Of the laceration of Mr. O'Keefe.
Exactly, because what you were doing was you were trying to determine and present testimony on whether or not that laceration could be caused by the spoiler, and to do so, you had to take measurements, correct?
Correct.
So, you chose to place Mr. O'Keefe in your simulation on the ground. You didn't choose to put him on a berm that would be 4 inches higher, did you?
Nor did I put the Lexus 4 inches higher. I didn't do
Correct.
either one of those.
So, the point is,
You
it's certainly possible that if there's 4 to 5 more inches, that would take that eye out of the ability to be hit by the spoiler. Isn't that correct?
No, because if it's 4 to 5 inches higher and he leans his head down or reacts to it, again, we don't know the exact position of his head.
Did you, in your slide yesterday, describe the possibility that his head could be down? As I understand it, you're positioned in that photo just like this. You're not positioned like that in any photo you presented to the jury.
We can literally
I'm
gun
trying
be
to make
drawn
it
into
clear, we
whatever
don't know
position we
his
want.
exact body position at the point of impact, nor do we know the exact position on the ground. So, which is part of the reason why I haven't tried to exactly simulate this, because we don't have enough parameters to do that. So I don't have that information.
One
I'm showing
possibility
the
of how this
geometry
happened.
relative to someone of Mr. O'Keefe's height.
So you don't have the information to do that properly, so therefore you can't conclude that he had a laceration to the eye from the spoiler by your own answer that you just gave, correct?
So it was done properly. We don't have absolute information to say where exactly he was. I'm pointing out that the physical evidence, the height, matches the height of the laceration. That is one data point of many data points.
So you would have to at least concede that the level of his eye could be non-contacting that fin because you don't have information as you just described.
Sure, it could be from contacting the ground.
Pardon me?
It could be
A
from
fist?
contacting the ground. It could be from other things.
But you don't have the information necessary to conclude with any certainty that Mr. O'Keefe at the time of impact had a level of his head in an upright such that it hit that spoiler. You don't have that information, correct?
We don't have that level of certainty. We have that the height and geometry matches.
And you didn't take into consideration the berm, and you didn't mention the berm at all when you were discussing this measurement with a jury yesterday, correct?
That is not correct. You asked me two questions. I absolutely considered the berm. And the second question, when I presented to the jury, I mentioned the berm when we showed the picture of the shoe in the snow, but that was it.
That's my question. I'll ask it a different way. When we were talking not about finding a shoe in the snow, and you mentioned a berm, I'm talking about when you did the measurement of whether or not the laceration could be caused by the spoiler. You didn't mention accounting for berm height when you discussed that measurement with the
correct.
jury, did you?
That is correct.
How hard was that?
Likewise,
Likewise.
you didn't present any Newton's second law analysis regarding the front of Mr. O'Keefe's head with respect to whether his head was contacted by that spoiler, did you?
Correct. Again, it was a glancing hit. We wouldn't be able to do that.
Oh, so it's a glancing hit to the front of the head is your hypothesis?
This whole pedestrian impact is a glancing hit.
So you can have your arm to the side like this, with the back of the vehicle coming like this, and you could glance the right eye with the arm out. Is that what you're saying?
That's what my picture shows when I'm standing next to the car.
Where did your eye get hit on the car? Where's the blue paint on your eye?
I could probably find the slide for you.
So you didn't do a force analysis to determine how much force would be applied assuming a contact with the right eye, did you?
That's correct.
And force analysis is what biomechanists do, correct? That's what a biomechanist does?
That is part of what
Part of what they do.
So I lined up his anthropometry relative to the known height of the vehicle.
You attempted to line it up. That's one
Ooh,
method.
fancy
But
word.
another method is to apply Newton's second law like you did to the back of the head when he fell, correct?
Correct. If we had more information.
Mr. Alessi,
You
why
can
don't we break
assume.
him?
Thank you, Your Honor.
Can't you? You can assume
Jurors, your lunch is here.
possibilities.
Please rise for the jury.
Goodbye.
We didn't have the information, so run a series. Isn't that what developing a hypothesis and testing it is? You don't know exactly. So you hypothesize one, and then you test it, and then you see if it worked. This would be called like running simulations. Run some different simulations and give me even just one where any of this works. Give me even just one. We'll add it to the list of extraordinary coincidences that all had to coincide for this event to have gone down the way that the Commonwealth says that it did. Okay, the series of rare and unlikely events, we can just add it to that. If you could show me just one, I'm not sure if they're doing anything. Just show me one way, one simulation. We'll ignore about the number, the very large number of times it doesn't work. We'll go ahead and not even focus on that. Establish exactly how extraordinary it would have to be for this event to go down the way that he's explained it, with an abrasion to the knee, a completely chewed up, gashed, solid blow to the right arm, a contusion, a laceration to the eyebrow, just a little cut, and no other injuries at all. Oh, the bruise to the back of the right hand. Little bruise to the back of the right hand. No bruise on the ribs, no broken bones, nothing. How this all fits with the height, the anthropometry. Got to throw in the sciencey word to make sure that it sounds extra sciencey. We on mute over there? Yeah, we are. Oh man, this guy is he's quite a ride, isn't he? This is a whole experience getting through this. We might have him for more than a day, guys. We might have him back tomorrow too. It's just making this cross-examination extremely painful. So if the A is a factor of the surface as well, which I can kind of understand. Okay, you have a soft surface, the contact is going to be less because you're going to decelerate before you land, right? You go through the styrofoam peanuts, it's going to slow you down before you reach the bottom and come to a stop, as opposed to if you fall on the concrete. What surface, remind me again, did he drop this dummy on? What surface did he drop this dummy on? Did he drop this dummy on a hard frozen lawn to get the 458 Gs? No, because it was the middle of summer, wasn't it? Out there in that sunshine and that t-shirt and that whole costume, that whole John costume that you bought to wear, except for the sweatshirt, which, would have been what contacted the taillight and all that. Oh my Lord, what a mess. I want to do more math. I really want to do more math. I hope Alessi lets us do more math, because we've spent all this time getting comfortable with Newton's second law. And I'd like to run Newton's second law on some more things. I'd like to run it on the force of this impact, because we know he's already told us the vehicle is 6,000 pounds. John is 216 pounds. And we can, even if we don't know the exact speed, we can run it at the low end of 13 miles an hour in the key cycle or the trigger event, or the high end of like 23 and a half, whatever it was, 24 miles an hour. We can run it at both. Let's do the FMA calculation there. And then let's contemplate Newton's third law, shall we? I feel like at some point Newton's third law should enter this cross-examination while we're talking about force calculations. Newton's third law: for every action, there is an equal and opposite reaction. So you stare into the abyss stares back into you. That, of course, is not physical contact. That's a little bit more metaphysical, but it's the same idea. Okay. The gravity, you stand on the earth. The force that you were exerting on the earth is the same as the force that the earth is exerting onto you. So let's do our F equals ma calculation to see what the forces are here in this actual collision, this actual circumstance that we're concerned about in this case, not the hypothetical ones, not some one that happened down in LA where a guy had massive internal injuries and died. This exact one. Let's go ahead and run that, because that will tell us this is the amount of force that acted not only on the vehicle but also on John. And so what exactly is that? What kinds of forces are we talking about? I feel like that should enter the chat. You can't do it. You can't do it because it's at an angle. It's a glancing blow. You can't do it. You've never heard of trigonometry? You've never heard about angles? You don't know how to figure that out? Anything less than a perfectly direct square hit, complete transfer of momentum, and you're just lost as an accident reconstructionist. That doesn't make you sound like a very good accident reconstructionist if an angle is going to cause you a massive amount of heartburn. You can't incorporate that into your force analysis. You can't figure out how that is going to factor in when we turn to Newton's third law now. What sort of forces would be acting on John with this type of impact? Enough to crack the polycarbonate is also the same force that is acting on John's arm, and by extension, anything his arm is in contact with. His arm comes in contact with your body, guys. When you move, your arms come in contact with your body. Pro tip, when you're boxing with your guard, you got to keep it tight. Okay, you got to keep it tight, because if you don't keep it tight and you have your hands out here, they hit you, you're going to be punching yourself in the face. You got to keep it tight. You got to keep it in contact. Holding your glass out at the arm, bent at the arm, out at the side. I don't think you can hold your arm like stiff and strong and braced enough to overcome the force transfer when a 6,000-pound vehicle backs into you at somewhere between 13 and 24 miles an hour. Don't think that is something that you will have the ability to muscularly resist. What's that even doing? It's like one of the rotators in your shoulder. It's like your rear delt, maybe. Your rear delt's gonna be able to keep your arm in a stable position so it doesn't. Actually, maybe it's more on the front side. Maybe it's more of your pectoral. I don't know. It's both of those. Both of those are acting to stabilize your shoulder. You think you're going to have enough strength to, not have your arm just completely follow Newton's laws once this car hits it? Carry it into your body. The object in motion tends to stay in motion. Oh, what a mess. Well, so I left off our recap when we were just starting to talk about Trooper Paul. It looks like we're going to have to come back to Trooper Paul. So, but we got some financial numbers thrown out there that at a bare minimum, we know there was a good faith basis to ask about Aperture being paid $44,500 less than 2 months. Little more than 1 month after they were hired. $44,500 they made in that first month. If they were retained in, a couple days before September the 23rd, they went out and did all of that work on September the 23rd. I don't know if they would bill that in their September or their October billing cycle, but it got paid, fairly quickly. $44,500 they spent so he could re-download the same data and go out and do a 3D scan of the scene that anybody could tell you, we're never going to see this map again. It's not going to be useful at all because you don't have anything to map onto it. You don't have any data from the scene that was preserved with the kind of accuracy that you would need to plot anything on this very detailed digital scan that you spent money to go in and take. $44,500 a month. Not bad, not bad. Now he doesn't know anything because he doesn't get the billing or the statements, and billing, they have an accounting department that's completely separate from him. He doesn't know anything about it. But when it comes to the contracting and the 3 offices working on the case, he only knows about the billing for his office. Do you know about billing or not? Because you've contradicted yourself there. Assumes that we're getting paid, but doesn't know. Just because he's a senior vice president doesn't mean he would necessarily know that if they weren't getting paid. Doesn't necessarily know that. He's just the one that signed the contract. And we got that answer about the Lexus, how that's being paid for. So they bought it. They did what to it exactly? Did you tear the boards out of this one too and mess around with them, or no? Or no? Your testing, how intrusive was your testing? I don't know. Just thinking about what might devalue a car for purposes of resale. I'm kind of thinking that tearing apart the motherboard that runs the safety systems might be, but I don't know if they did that with this one, because we don't have any idea what they did when they say testing. They just say it's testing because that sounds like science, but they haven't told us. What did you actually do with this exemplar? What did you actually do? They've never told us. So then the amended contract as of June, right before trial, calls for $325,000 to be paid to Aperture for 8 months of work. $325,000. And what's the total max obligation? He doesn't know. We didn't get that number. So there's a cap. They're getting paid $325,000 up to a cap. We don't know what the cap is. So then we got into the PowerPoint changes. He's very defensive about that. Very argument. Oh, I've changed it. I changed it minutes ago. I've edited it repeatedly. You're welcome. You're welcome. So we finally established January 30th was his first version. He didn't change it then until May the 13th during the trial. And he's made it several times, several changes. And just very, very snarky. Well, the change, it was based on, because he's saying half of it was due to the defense objections. Well, half of it was based on Karen Reed's statements. Is she part of the defense? Is that a defense objection? Karen Reed giving an interview? Is that your familiarity with the legal process, that you think Karen Reed giving an interview is a defense objection? It's trying to be combative, getting a little snarky, but it's not really on point, is it? You talked about they were due to defense objections. Karen giving an interview is not a defense objection, is it? No. So then we go in and establish you were chit-chatting with somebody who shall be unnamed, but don't know if it was Hank Brennan. Don't know if it was Hank. But somebody communicated with him in about mid-April and suggested there was an alternative route. So he added it in. And during this whole process, he's looking through his paper, he's staring at his laptop, he's reaching for stuff, he's squinting with the mouth breathing thing that he does. He's like got his mouth, mouth breathing. I noticed the mouth breathing. It makes you look a little slack-jawed yokel, while we're on the Simpsons themes here. He's been giving a lot of Ralph Wiggum. But when he does that mouth breathing thing, it's much more Cletus, the slack-jawed yokel. So he certainly doesn't know if it was Hank, but yeah, Hank told him we have more stuff. Go ahead and change that. Go ahead and add that into your analysis. Yes, he received Burgess's May 8th report, incorporated that. He has never submitted an amended report during the trial, but he's amended his analysis. So you've listened to testimony and you've provided rebuttal. But when you change your report, that's changing your direct, isn't it? That's changing your direct. That's not responding to somebody else's testimony. That's not offering rebuttal. That is changing your direct testimony about what your opinion is. So your examples that you've provided this is not an apples to apples distinction here. Your amended analysis that you've described is done as part of rebuttal. It's not revising your initial opinion during the middle of trial. So he'll be busy removing his screens now during the lunch because we had to have that special admonition. He just can't not look. He can't not look. It's his safety blanket up there, having his laptop. The question starts to come and he's already like squinting at it, digging for that calculator. God, he's got all this stuff up there. These little like stress toys or something to help him cope. He was all ready to reach for that hat yesterday. Your Honor, I have this hat that I brought. Can I put my hat on? No, you cannot. No, you cannot put your hat on. This is not your courtroom. You are not running things here. You are here to do what you were told and answer the question that you were asked. So yeah, after the break, we had to point out that you need to not be looking at those screens. So it's all going to be taken down at lunch. Of course, he's still got his paper up there that he is still using as his comfort blanket. We learned that the defense counsel received his amended PowerPoint presentation at 3 p.m. on Memorial Day. That does sound like something the Commonwealth would do, doesn't it? And then he testified yesterday, the day after Memorial Day. So he's working on this until right up at the very last second, day before Memorial Day, hours before he's going to get on the stand. He's got it finalized. And he's getting emails from internet trolls. But then how is it determined that he could amend the PowerPoint if he's not communicating? Well, because they asked him. Because they asked him. Obviously, there's communication. There had to be communication about what you're allowed to put in and not in. So then we moved on to starting to talk about the data, what the event data recorder picks up, and how the cycles work and stuff. The EDR doesn't give you a date. We're starting to hammer down how these things correlate or don't. And well, depending on the car, we're talking about this fucking car, dude. You know what car we're talking about. We're not talking about any car. Nobody cares about any other car but Karen Reed's 2021 Lexus LX 570. That's the car we're talking about. So maybe let's focus on that. Maybe it doesn't matter at all what other cars do. Jesus, dude. Oh, unbearable. What this car actually does is has a text stream data, and it tells you the number of seconds into the key cycle that the event occurs. And so then we had this big fight over to determine the location and the timing of that trigger event. You would need to identify the trip that's associated with the key cycle. Does trip have some term of art? Is it some term of art for this guy? Where he's like, no, the trip is in the text stream data. It's not. It's not. You don't know if the text stream data recorded when she went to the grocery store and stopped for gas on the way home, or if it recorded when she, parked outside of 34 Fairview. You don't know because there's no date or timestamp on the text stream event. You're just inferring that that's when it was because you have the ignition information, the key cycle, and then the length of time that the car was on. As far as I can tell, still, that's the only association between these two things. And then he argues about if you associate the wrong trigger event with the infotainment data, you'd have wrong timing. Yeah, you would, because there's no date for the text stream data itself. So if you say the text stream data, this key cycle was when the infotainment system was turned on April the 30th, when in fact, in reality, the key cycle, the trigger event occurred during the ignition when the infotainment system was powered on in January, you'd have the wrong date and time. Real basic proposition, real easy to understand. If you said this trigger event took place during this infotainment measurement of when the car went on and off in January, you'd be right. But if you said it was this one in April, you'd be wrong. Really, really simple question. Seems like a pretty easy point to follow. And what's this guy's answer? No, you'd have to take the totality of the data. So just because the actual event happened months earlier than you attributed it to, doesn't necessarily mean your dates are wrong. What even is the matter with this guy? You need to take the totality of the data. Did he learn that from Buchanan? The totality of the investigation? If you just look at the totality, by which we mean the carefully curated things that we chose to look at, isolated from those problematic things that we chose not to consider, that totality, then you get to where you want to be. But we can't say that out loud because that is confirmation bias. Very classic. Oh, when he saw the car on September 23rd of 2024, it was at key cycle 1264, and my mind is blown. 100 times they've been out doing what? Are they joyriding in this car? Like what? How many times did you need to move this thing? I'm just baffled. And so we got caught in this sort of morass because Bev doesn't want Alessi, to be able to ask about the Commonwealth's prior theory involving key cycles 1164, 1165, and 1167. Because they relate to the count, the key cycle count that we did in the first trial. There was a problem with the key cycle count. But he didn't really carefully review Trooper Paul's report. It's you wouldn't do that. You would just casually review it, look at it and throw it aside. Why would you look at it at all if it's not important? If that could introduce confirmation bias, wouldn't you maybe even say, hey, just so you know, guys, Commonwealth that's hiring me, this type of information, it's not appropriate for me to review it. My analysis needs to be objective. This is not the type of thing that you should provide to me. Just so you know, I'm going to go ahead and discard it now. So when you see that I didn't consider it in my report, you'll understand that's why. Wouldn't you do something like that? If somebody is providing you with data that you shouldn't rely on, it would be bad. Somebody's passing on to you somebody else's opinion. But just not important to read carefully. Just a little bias, not a lot, just a little, just enough to get the hint. That's all he did. So then we had that struggle session at the sidebar, and they're not gonna let him ask it. So we'll come back to that, says Alessi. I don't know what the problem is. Hopefully it gets sorted out. So his degree is in biomedical engineering, but a sub-discipline of that is biomechanics. I find this hard to believe. It seems to me like it would be the other way around. Biomechanics would be the parent, and biomedical engineering would be a sub-discipline of biomechanics. Am I wrong? Am I way off base with that? But biomechanics seems to be the far more general field relative to biomedical engineering. Biomedical engineering would be applying principles of biomechanics to medical interventions. It is accurate to say he's a biomechanical engineer. I'm wondering if we're going to come back to that. If we're just leaving it. He is a biomechanical engineer, and it's okay for him to say that. He's got whatever qualification you need. I would assume you got to have a license. Most engineers, don't you have to have a license? You got to pass a test and stuff. You don't get to just be like, hey, I went to college and now I'm an engineer. So, I mean, if we don't come back to it, yeah, we'll assume he's got that qualification. And so based on that, yeah, he knows how to do force calculations. He knows about Newton's second law. He's a big upgrade on Tr Paul in that regard. So, boy, he was digging away for that calculator, wasn't he? Digging away for the calculator. He needed a safety blanket, and he can't actually suck his thumb up there on the stand, so he's reaching for that calculator, sit and stroke it and make himself feel a little better. Fall of 69 inches. And we had the rate of acceleration, 458 Gs. We get a G by taking the feet per second squared and dividing it by 32.174. Today I learned 32.174. I'm gonna file that away along with, like, pi and stuff like that. 15.7 pounds assumed to be his head, so we can do the math and get 7,200 pounds of force when you drop it on concrete. Yeah, when you drop it on concrete, I buy it. Like where you dropped that dummy on the concrete floor. Yeah, I buy that. Now do the frozen ground. Now do the lawn. Now do the frozen lawn. And see how many G's we get from that. Then we turned into the head injuries. He relied on 1979 data. It is, in fact, 46 years old because it is only slightly younger than me. that had the majority of 61% of injuries in a pedestrian vehicle collision are head injuries. But if you look at the modern, he doesn't know any sort of modern analysis. He would want to see the data before he agreed that today we understand that the most common injuries are to the lower extremities. And he has a long explanation. It's because of autonomous braking and then lower high severity crashes, and because you have a pre-collision system that applies you at the front of the car. And so you have lower speed impacts. But backing might be different because you got different vehicle geometry and different safety systems. I'd be willing to bet that they did backwards autonomous bracing before braking, before they did forward autonomous braking. I would bet that for that reason that was pointed out in the chat yesterday, backing over the kids in the driveway. This is a problem. This is a problem. The kids are low. The kids are small to the ground. The kids are in the blind spot. You can't see around all the spots in the car. So it's not that difficult to back over a kid in the driveway. And nobody wants that. It's not a good state of affairs. It's very, very concerning. It's also hard to mitigate just by, driver attentiveness and so forth. The car is blind. It is what it is. You can't see through the car. The kid is just low. That is how it is. So you kind of have to come up with alternative systems to be able to produce, a safer driving. I would almost be willing to bet. Haven't done the research. Maybe I'll look into that. Did we get pre-collision safety systems for backing the vehicle before we got them for moving the vehicle forward? Seems far more likely to me. But that's just me, trying to apply what seems like common sense to me. But you'd have to look at the literature to know if today there's a different medical understanding. Dude, why did you not do that before you wrote your report? Did you not think it was important to verify that information before you wrote your report to see if your 1979 study still held up? If I'm going into court and I'm citing a case that was decided in 1979, there's a process that you have to do if you're being ethical as a lawyer, where it's called shepherdizing, where you basically check the validity of this case because it's old enough. Things can happen. Cases can get overturned. There can be new laws. Reasoning can be superseded for one reason or another. A lot of reason why law goes bad, gets stale. So you got to check your 1979 case before you rely on it to make sure it's still good law. And that's a pretty basic, legal research 101 thing that you learn how to do. They make it very easy now with the digital research. You just, you have a certain tab that you go into or button that you click or whatever, gives you the history of the case. Old school, you had to do it by the books. That's why it's called shepherdizing. It was the Shepherd Citations was a series that was produced and just helps you track the history when a case has been cited by subsequent cases. And then you go in and you read all of those other cases, and then you see what they said about your case. And based on that, you determine if it's still good law. I'm old enough that I learned how to do it the old school way with the books. Probably they don't teach that in law school anymore. How did you not verify that your 1979 medical information was still valid? Don't know. Then we got into the laceration over the right eye being consistent with the height of the spoiler, but we didn't account for that curb, did we? It only fits under a certain set of assumptions. That's what I'd like to see this cross kind of narrowing down on. It's not that he's unwilling to make assumptions. You don't know. You said you don't know. Yeah, we know you don't know. You don't know where the collision was. You don't know what position John's body was in, et cetera, et cetera. You don't know exactly what the angle was of the contact. We get all that. But you can entertain hypotheticals because that's what you did when you did your little paint test. And you assumed for purposes of your paint test that John and the car are on the same level. And that means John is in the street. It does not mean Karen went up the curb. Where's the track? Where's the rut? Where's any of that? He talked just yesterday about how when you have a point of impact on a road, you'll have like a almost like a divot. There's like a physical point where you can mark where the point of impact was. It's like a gouge. It's like a gouge kind of in the asphalt, and they can spot that. None of that here. None of that here. So, yeah, you have to, if just one wheel is up on the curb, that's going to change your angles, isn't it? Now we've got to totally change John's body position for his eyelid, elbow, and knee to all be in contact. It's such a mess. This whole thing is such a mess. So he chose, yes, he did. He chose how to do the demonstration. He chose which one to present to the jury. He did not demonstrate any of the many numbers of ways where it would not work. That's what stands out about all this. Going to great lengths to emphasize how much you don't know, and therefore you couldn't model and couldn't assume. So you only modeled and assumed the things that possibly could work. You didn't model all the ways it doesn't work. And even this model you have given is this tiny part of the entire sequence of events that gets to this data, facts, science, and data show that there was a collision. Because we still got to get John in the right location. We got to get the point of impact at the right place. We got to get the distance that the car traveled to line up. We got to reconcile that with John's health and location data. We got to get his body position in a way. We're going to have all three of those points of contact, but not the center of mass behind like in the path of travel, because that would be a direct hit and not a glancing one. So it's still got to be a glancing one. So he's got to be in a little bit of a squat there for any of this to work. Didn't model that stuff. And yeah, the height matches. It's one data point of many. Under this set of assumptions, it's one data point of many that you did not look at. It's one data point that you chose to go out and gather while ignoring the hundreds, if not thousands, of other data points that you could get if you looked at how this would not be possible. But it's not confirmation bias. Totally not that. And he can't do a second law analysis, F equals MA calculation to the front of his head coming into contact with the spoiler, because it's just a glancing blow. Just a glancing blow. Well, I would think you could work backwards from the injury. You could work backwards from the injury, couldn't you? Surely we know at least an average, a range of human eyelid tolerances to blunt impact injury. How much force on an eyelid to create a laceration? How much? I bet we know that somewhere. Somebody studied that. So just work backwards. Start from the injury. How much force does it take to create this injury? And then we already know, in a direct hit scenario, we can calculate what the force would be between the 6,000-pound SUV and John's 216-pound body at the 13 to 24 mile an hour speed that this trigger event took place in. So we can calculate what the direct force would be, and then perhaps we can discount that. We can compare that to the force it would take to cut, lacerate an eyelid, and see how much would that have to be discounted in order to get this type of injury. Perhaps that would give us insight into the angle that would be needed to, change the transfer of the force from being the direct to being the angular, Maybe we could do that backwards. Seems awfully hard to believe that if an accident happens at an angle, guys, the accident reconstructionists are lost. They can't deal with that. They can't deal with side swipes. That seems pretty hard to believe. In fact, I find it very hard to believe that you don't have a software program probably on that computer that you can't keep your eyes out of. Probably right there in that computer. You've got a software program that will model all of that. Surely. Because we're just talking about basic math now. F equals MA, this is arithmetic. This is simple arithmetic. And so, yeah, it might get complicated if you have to change angles and change speeds and, run all of these different assumptions. But that's why we have computers now. They can do that. They can run thousands, tens of thousands, hundreds of thousands of assumptions in seconds. Find it very hard to believe there's not a nice software program that would make that super easy, no problem at all. Oh, well, guys, I think we got about 20 minutes of the lunch break left. That's what I got for a recap for you for now. This is rather painful to go through. Visions of Ralph Wiggum are really what's keeping me happy here while I watch this happening. I'm helping. But it's like pulling teeth. I don't think we're going to be done today. I'm just going to tell you that right now. I don't think we're going to be done today. I think we're coming back with this guy for more of this tomorrow. We'll see, but not optimistic that at this rate he's going to be able to answer questions in a fashion that allows them to get through what they need to get through. It is what it is. So I am going to go ahead and pause now. Appreciate you guys hanging tight. Let me do my my rounds real quick and get back. And if we have a minute before they get back into court, we'll look at some of your guys' comments and questions. See what you've been thinking about all this. So with that, hang tight. Appreciate you. And I will be right back. All right, guys. Welcome back. Thank you for hanging out. I'm going to turn to your comments and questions now while we wait for the court to come back. But before I do that, got an interesting little piece of information here in my private chat that I'm going to share. I'm just going to go ahead and read it out loud. Biomedical engineer. Biomedical engineering is broader in scope. It encompasses the application of engineering principles to design, develop, and maintain systems and devices for healthcare, including medical imaging, prosthetics, etc. Biomechanical engineering is a specialized subfield of biomedical engineering and sometimes mechanical engineering. It focuses specifically on the mechanics of biological systems, such as how forces interact with the human body, tissues, or organs. Both require a bachelor's degree. However, biomechanical engineering may demand more specialized training in mechanics and computational modeling, which can be more intensive in those areas. A professional engineer license is usually not required unless directly impacting public safety or health, for example, designing medical equipment used in hospitals or consulting on public infrastructure. Today I learned. So apparently biomedical is the broader category, but biomechanical may require some more specialized training in mechanics and computational modeling. Tell me more. Tell me more about computational modeling in biomechanical engineering. Sounds like the kind of thing that might be helpful in a case such as this. Well, guys, what have you been up to this morning? Mike from Providence, call Aperture to help you out with your technical needs. Is that going to be on the back of the bus in Texas and Long Beach? Where else did they have some offices? Texas and Long Beach. Let us get you out of a jam. Lawn Lumber, Rob was here this morning. Alessi, so Dr. Welcher, would you say you're an expert on everything? Is there any opinion you don't feel confident giving? Oh, he didn't want to step out of his lane when it came to cognitive bias. No, he doesn't know. He doesn't know cognition. You're not supposed to say that part out loud, dude. Show, don't tell. Deep state thrombosis. This guy lied about his degree also. Said he's a biomechanical engineer, but he's actually a biomedical engineer. Hope Alessi caught it. Big difference. It seems like a significant difference to me. I buy that they are related. I even buy that the biomedical engineer is broader than the biomechanical engineering. It doesn't make intuitive sense to me, but I'll buy it. Biomechanical engineer is a subset of biomedical engineer, but because of that, yeah, it's more specialized. So we'll take that for what it's worth. Lawn Lumber, but the real question, are we going to try another Dress Like John O'Keefe Day? Oh, Lord, teachers, don't pick this one for Spirit Week. Let's not have Dress Like John O'Keefe Day for Spirit Week. Odds on another boneheaded improper request today. Well, I mean, I don't know. The calculator wasn't quite as bad as going for the hat. He didn't get slapped down quite as hard, but the whole, you're going to be needing to take down all of your screens that you can't keep your nose out of them. While you're in the middle of your testimony, you're going to have to take all those down during lunch. That's probably not the kind of correction he was looking for. You're welcome, Judge. Oh, you better watch. You better watch where you step. AP, reverse is always the tallest gear in the transmission. It has the most torque in the gear train, so it doesn't need much pedal to move the car. Yeah, this makes sense. This is going back to what I was saying, where it seems like at the least it's going to be geared similarly to first, because you need high torque. You're starting from a full stop. You need to move the 6,000 pound vehicle, and that just initial overcoming the inertia to get the thing in motion requires a fair amount of torque. Once it's already in motion, making it go marginally faster isn't that much more difficult. So that makes sense. Tallest gear in the transmission, because you want it to be reactive, but not, not without, you don't want to have to slam on the gas, to be able to go in reverse. You want it to just be like fine movements that it reacts to. Not sure how we get to 24 miles an hour at 3,000, maybe 3,500 RPMs with a real tall gear like that. We'll see if that gets explored. Auto Doctor 911, Burgess. The only thing relating 1162 to 1212 power on is the fact that a 3-point turn happened, and it happened to be 11 minutes after a start. What if later 3-point turn also occurred 11 minutes after a power on? Yeah, this is the problem with tying these events together and trying to sync them up with an event, because a 3-point turn is not a unique event. We have multiple 3-point turns on video in this trial within, 24 to 48 hour period. Backing out of the driveway, getting loaded onto the tow truck. We already know about the cedar crest. Like a 3-point turn is not unique. So the fact that there might be 3-point turns that can be identified, it's not just that too. That's not even the part necessarily that I mean, this is a problem, don't get me wrong. But it's them identifying this trigger event as a 3-point turn. It doesn't trigger because there's a 3-point turn. It triggered because the accelerator was open. So they just looked at this data and said, that looks like a 3-point turn, even though to me, it looks like the turning is happening weird. Maybe I'm just really judgy about how to do a 3-point turn. Would it be the only thing I'm kind of judgy about with driving? I don't claim to be the best driver in the world or anything like that. My Lord, I've already talked about backing into my husband's truck, but I have opinions about driving. My poor husband will vouch for how I can be a little critical with how other people choose to do it. So maybe it just looks funny to me, and it's a perfectly routine 3-point turn, but it's like, to me, you go forward at one angle, you back up, you go in the other angle, you shift, you go forward, you turn at the other angle. Like, we're not. That's how you need to get it to move the car. If I have the wheel like this and I go forward, I'm going back like that. So no, I need to go down here. I need to turn it the other way. It did not make sense to me. Looking at that data does not scream, oh, this is a 3-point turn. So it isn't even that they picked a 3-point turn and said, let's sync up 3-point turns. It's that they picked some data that said, this looks like a 3-point turn. So let's call it a 3-point turn and then say it's this 3-point turn. That seems to be what it is. And it fits within the clock. How did it take them 10 minutes to get from the waterfall to Cedar Crest? I don't know. I don't know why we're sitting in the car for 10 minutes on the way to Cedar Crest. Cassandra Durkin, I am pretty sure you cannot shift into reverse without applying the brake first. So how could she have the RPMs at 3,600 and slam it into reverse without applying the brake? Good observation. I don't know about this one. I haven't driven an automatic car in so long. I have to think about it. I did drive one down there in Chile. Oh, by the way, guys, while we have a break, send some thoughts and prayers down to Puerto Varas, if you wouldn't mind. They had a tornado yesterday. A tornado went through Puerto Varas. It destroyed like 250 homes or something like that. This is a beautiful, beautiful part of Chile. It's at the kind of bottom end of the Lakes District at the top of Patagonia. It was the jumping off point for Cochamo, which is like the closest thing to heaven on earth. I've been a lot of places, a lot of magnificent places. Nowhere quite like that. So anyway, while I'm thinking about Chile, do give some thought to the folks in Puerto Varas. It was a wonderful place. Loved spending that time there. Anyway, so I drove an automatic down there for a little bit, Yeah, I think you do. You have to. I mean, I remember you got to put it in park to put it in reverse, or put the brake on to put it in reverse. What would happen if you did it without hitting the brake? I don't know. Will it just not move? Will it move, but you haven't? See, I don't know enough about how the automatic transmission works with the engine. If I'm shifting it, it's going to have to. It affects the engine compression. That's why you have a clutch in your car. I don't know what would happen. Would it grind? Would it scream? Would it just not move? I don't know. Don't know. Definitely don't know how it would apply to a Lexus. If only someone had an exemplar that they spent like 70 grand on, that they could do testing on to see what happens if you're reversing at 3,600 RPM and then or you're going at forward at 3,600 RPM and then slam it into reverse. I don't know. If only there were a way to test that. Justin Wright, these days it would not require specialized software to reconstruct. The gaming industry has realistic crash physics engines built into basic realism modules. See, this doesn't really surprise me at all. I'm imagining like, the early days. God, how long ago was it when the simulation games? What was that one with it's like real life or something like that? I don't even remember now. I can't remember what it was called. I'm sure in my mind I have it like mixed up with the real world, MTV's The Real World, which of course was revolutionary for its day as well. But it was like that first big sim game that everybody was into, and that was old school. So we looks like back in court. To be able to handle this kind of thing. It doesn't seem that complicated to be able to run.
Go ahead, Mr. Alessi, whenever you're ready.
Just take a moment, Your Honor, to reorient. I'll be right.
Was not Sim City, chat. I know. I remember Sim City. It wasn't Sim City. It was like Life or something. I can't remember.
Dr. Welcher.
Good afternoon. Nice to see you again.
Same. We had left off talking about some examples of Newton's second law and the application of it in the parlance of force equals mass times acceleration. And I now want to continue on with that discussion.
Yes, let's.
It is correct that you can conduct a force analysis on any part of the body, correct?
It's more difficult on internal with live people. Like if you wanted like my appendix, I really necessarily couldn't.
Let's talk about the musculoskeletal system, the outside bones. You can conduct a force analysis
So your
on any
bones are
bone.
on the inside.
Don't interrupt.
Sir, if I could finish my question, please.
Okay.
You can conduct a force analysis on any bone in the body, correct?
More or less, yes.
So the force analysis I use as a synonym with Newton's second law is not exclusive to the head, correct? You can do it on other bones in the body, correct?
Correct.
On direct examination, your direct examination here, you did not present a force calculation representing what you allege to be contact between the vehicle and Mr. O'Keefe's right arm, did you?
Correct.
Mm-hmm.
And nowhere in your report do you present a force calculation for Mr. O'Keefe's right arm, do you?
Correct. We didn't have enough information to do it.
We're going to get to that.
We're going
Now-
to get to that.
Given that you stated that, quote, determining the effects of physical forces on the human anatomy, end quote, is the job of a biomechanical engineer, you must have conducted several force calculations related to accidents involving humans in your career, correct?
Hundreds.
Hundreds. Now, you didn't present a force calculation in your materials, as you've stated on direct, with regard to the arm, and I'll include in the right arm going from the shoulder all the way to the tip of the hand, okay? So that's my definition of a right arm. You didn't present any force calculation on that part of the body of Mr. O'Keefe, did you?
Correct.
Assume, and we're going to apply Newton's second law. Assume Mr. O'Keefe's hand weighed 7 pounds. So that's the M in the F equals MA.
That's not a good assumption.
Well, what number would you like to apply for an M for the hand of Mr. O'Keefe? I'll take any number you got.
Just the hand?
Just the hand.
Oh, the whole arm of Mr. O'Keefe weighs approximately 12 pounds.
Okay, fair enough. So the whole arm is from the shoulder down to the tip of the fingers is about 12 pounds, right?
Correct.
Okay. So assume that the Lexus SUV was traveling at 20 miles an hour. All right? Under your theory going backwards, 20 miles an hour. And the third variable I'd like to give you is to assume an impact window of 10 milliseconds.
Okay.
Can you calculate the G's of force from that data?
You need more information.
Well, let me ask you this. What more information would you need?
The mass of the
So
car?
we talked about the glancing impact.
I'm talking about a force calculation of an impact, not as to whether it's glancing or not.
So you want a direct head-on impact in the arm, not a glancing hit to where the Lexus comes in, hits the arm, and they continue off together?
I'd like to start with that, but just so we can hopefully expedite it for the jury.
Okay.
I'm going to want to get to what you have depicted in your diagram of holding the arm out. And that's not a glancing impact. Is that, sir, with the right arm in parallel with the back of the Lexus?
That's pretty direct.
Yes, it is. So really I'm sorry, let me finish, please. What you're concerned about is where the center of mass is. With the center of mass out towards the corner of the car, that becomes a glancing contact. So you don't have a center of mass contact.
Now you
have a
start
glancing
talking about center of mass.
Okay, fair enough. Well, so let's start the first force calculation.
I need my calculator.
I'm going to let him use his calculator.
Sure.
You let him have his
Tell me what it
blankie.
is.
Go ahead.
So let's take a scenario where it's a center of impact,
Center of mass.
center of mass impact, right?
Okay.
Impact to the right arm.
Okay.
Let's start with that one.
Okay. And you want me to use like a 10 millisecond?
Yeah, be conservative. Yeah, let's use a 10 millisecond for the impact window.
He can't count in his fingers for this. I'm counting on my fingers. That's not a very good Ralph Wiggum. taking them a long time to do arithmetic. Of course, I don't know how the impact window fits into this. This is a little more than just F equals MA. Thank you, Kesden. Exactly what I was thinking.
Okay, question?
What do you get for F of force in the F equals M times A calculation?
About 2,188 pounds. I made a triangular crash pulse assumption.
Right, and if you took the milliseconds in half, become less conservative, would you end up doubling the 2188 number?
If you cut it in half, you would double, yes.
Exactly, through a simple mathematical semi-algebraic application of the numbers, correct? You divide.
We'll do a little
Semi-algebraic.
simplification in terms of the crash
Yeah.
pulse shape, but generally, yes.
Right. So, but let's take the conservative number, the lower number, 2188 that you came up with. Do you know from the literature, as you did with the head, you went to the literature and said, this is how much pounds of force, if you would get to have to cause a break of the occipital bone. Do you know from the literature how much force it would take to break an arm bone?
I have an idea, yes.
What is your idea?
So for a distributed load, such as this, not a concentrated load, you're going to need somewhere between, I've seen, and this is for cadaver tests, a low of like 2,500, maybe a little lower, to a high of 7,000.
Sir, you have switched, haven't you? We're talking about center mass impact. Did you in your calculation just switch to a side swipe impact to
No.
do your calculation?
No.
I'm asking about a center of mass impact. How much force would you need? Let's start with the hand. Maybe it's a simpler one. Do you know how much force it takes to break, any of the hand bones, you know what I'm referring to, the phalangeals?
Yes.
And metacarpals, and the carpals?
Correct.
How much pounds of force do you need to break any one of those bones?
Actually, I didn't find any distributed loading on the amount of force. I don't know.
Well, no, I understand, but I'm asking, do you know from the literature, not a calculation? Doesn't the literature tell you? Can't you go to the literature like you did with the head and you say, okay, to break the occipital bone, the literature says you need a minimum amount of force of this. I'm asking you the same question for the hand. If you don't know, it's okay, but do you know what the literature says for how much force is needed to break a bone in the hand?
So for a distributed load across the hand, there are distributed load tests that show you need over 300 Gs on the arm to do that. So it would depend on the mass of the hand.
What is the range of force that you would need to break a bone in the hand? Do you know from the literature? If you don't, that's okay.
I could probably figure it out.
How long would it take
Figure
you
it
to
out
figure it out? Do you
from
know
the
from the literature what that number is?
Not off the top of my head, no.
Is 300 to 400 pounds of force sound right from the literature that it would take to break a bone in the hand?
For a distributed load,
Yes.
such as the taillight, no.
No, not a distributed load. A load from a motor vehicle going backwards.
Right, that's a distributed load.
Right. So you're saying 300 to 400 pounds of force would not be enough to break any bone in the hand. Is that your answer?
So for a flat distributed load, like hitting the taillight, you're gonna need higher.
How about another part of the
How is
back
that
of
a
the vehicle?
distributed load if it's hitting his hand?
I guess if you hit
We're hitting him on the elbow.
on the very corner and it wasn't a distributed impact, like if you had a more concentrated impact,
Yes.
that could increase or decrease the amount of force required.
How much would it decrease it from the number you gave?
Depends on what you're hitting, what it's made out of.
The
Contact
Lexus
area.
SUV, let's assume, I'm sorry,
Can you repeat the question, please?
absolutely, thank you. Let's assume we're talking about this Lexus SUV.
Yes,
Mhm.
let's assume that.
But let me back up. You don't know where exactly, under your theory, that there was contact. You don't know, you testified to on direct, you don't know exactly where that point of contact is.
Correct.
You don't know.
Except it's on the taillight.
Well, you're saying it's on the taillight, but you didn't observe any impact yourself personally, right?
Did I see Miss Reed's Lexus?
You didn't see the impact, right?
That is correct.
So, and there is no firsthand witness that saw, under your view, that a collision occurred. There's no witness to say where the arm was, correct?
There's no person that saw it.
Right. And you have chosen a point of contact, okay? You chose that for your analysis, correct?
Correct.
And you picked that location, but it's also possible that under your theory that a collision occurred, that that arm could have been impacted any part of the back of the vehicle. That's possible, isn't it?
That's not probable, no.
I'm asking is it possible?
Anything is possible. I don't deal in possibilities, I deal in probabilities. It's not probable.
So, but you don't know exactly where the point of impact was. correct?
So within the range of the light and the exact angle of the hand, no, I don't. What I do know is at the rear tail light area.
So your assumption is that it had, that because there's a tail light that is altered, it must have been by Mr. O'Keefe's arm.
Mhm.
That's your conclusion, correct?
My conclusion is there are tail light fragments, a broken glass, lacerations to his arm, and his DNA on the back of the vehicle in the area of the taillight.
That's not an assumption.
And you're, I'm going to move to strike the DNA part of that answer for obvious reasons.
I'm not going to strike it.
Okay, so you're making assumptions. You're taking what you view to be certain data, and you're coming to a conclusion, but that is based upon circumstantial information, correct? Is that fair?
Are you calling like pieces of the taillight at the scene around his body circumstantial information?
Yes.
Sir, let me go to the force and
Yes.
go back to the force
It is
analysis. Let's go back
circumstantial.
to the numbers. I want to stay on, if we can, just the calculation. So let's go back to the minimum amount of force you understand from the literature that it takes to break any bone in the arm from the finger up. Let's start with a hand. What's the minimum amount of force that can be applied to break a bone in the hand?
So it depends on the loading. So I don't actually know. In terms of the forearm, I can tell you there's data that shows up to 300 Gs of loading, you will not get fractures. There's one up to 750 Gs showing no fractures for a male of similar height and weight of Mr. O'Keefe.
Thank you.
You're welcome.
So let's take those numbers,
Okay.
okay? You said 300 and 750. Did I hear it correctly?
You did?
Okay, that's the numbers you gave that would break a bone, correct?
So the 300 actually didn't break any bones, I believe. The 750, the one example, didn't break a bone, but as you got above 350, you started to break bones.
So
300.
you got above 350,
300.
above 300, yeah, because that's what I thought you said the first time. You got above 300, you start to get breaking bones, correct?
Correct.
And so if you take that 300 number and compare it to the 2,188 pounds of force, You have 7 times the amount of force necessary to break the bone,
No, 'cause-
correct, in the force
Geez.
analysis?
No. If you take 300 Gs times a 12-pound arm, you get 3,600 pounds. The calculation you asked me to run earlier gave you 2,188 pounds.
Right.
So you are 1,412 pounds above the force required. Like the tolerance is 1,412 pounds above the force you would say get in a 20-mile-an-hour impact in terms of the fracture forces.
Let's do it this way.
I'm sorry?
Let's do it this way.
Okay.
The force that you calculated from my hypothetical of this Lexus SUV going backwards, you came up with the F number of 2,188, correct?
I'm sorry, I didn't, what was the, you said?
2,180.
Dyslexic? Or did you say Lexus? I didn't understand what you said.
The Lexus
My apologies.
SUV that you've been talking about.
Gotcha.
Okay?
I didn't hear
You
it.
came up with a number for F for force of 2,188. Are you changing that number?
Nope.
Okay,
absolutely
so
not.
let's go with your number of force from this vehicle of 2,188. I'm just simply asking, how much force does it take to break a bone in the right arm of a human being? How much force, not acceleration, how much force does it take to break a
use
bone
your acceleration.
in the right arm?
Sure. So somewhere between 2,500, the one cadaver tested the distributed load of someone of similar size and weight, and actually close in age to Mr. O'Keefe, showed about 7,000 pounds of force to break it.
Let's go to the hand. Do you disagree that the literature shows it only takes 300 to 400 pounds of force to break a bone in the hand? Do you disagree with that?
Your question's too general. I can't answer your question. It depends on the loading. If I take my pencil, which has a very fine point, and jam it through my hand, I can jam it right through my hand because it's a very small point. But if I distribute the load and a broader load, such as hitting a taillight, it takes much more force because the load's distributed across it. It's like if I sit on the corner of my bed. I might sink in this far when I sit on the corner of my bed, but what happens when I spread my load out, when I lay on my bed like this? I don't sink in as far. Has my weight changed? And weight is basically force. No, but I've distributed it over a larger area, so for a given force, you get less sinking into the mattress. So if you hit a broad surface like a taillight or a wall like this, it takes much more force than if I were to take a singular small round object and jam it into the hand. That hurts. This does not.
Okay, if you can hear my question, if it's unclear, you tell me. For not a pen, not your bed, but for a Lexus SUV of 6,000 pounds, is there any part of the back of the Lexus in any manner where you can get a break to the hand from 300 to 400 pounds of force?
Any part on the back of the Lexus?
Yes.
Probably.
Okay, so probably, your words, you can get a break to the hand from just between 300 to 400 pounds of force. That's what you just said, correct?
So you're taking the totality of the back of it? Like if you got it stuck in the bumper, potentially, yeah. But from a taillight or a broad flat surface, no.
Not asking about a taillight. Any part of the back of an SUV, you agree that it is probable that you can get a break of the hand bones from just 300 to 400 pounds of force.
Your question is incomplete, right? You said any part of the back, but then you wanted me to not include taillights or not include the rear body panel. If you hit a very narrow
rear body panel
part of the car, like say the edge of the tailpipe, that creates much more of a narrow contact. So force divided by area is pressure. So if you have a very tiny area, you have very high contact pressures. And so, but if you distribute the load over a larger area, the number on the bottom of that fraction is much bigger, so your contact pressure drops. So hitting the edge of the exhaust pipe is going to have a much higher likelihood of causing a fracture than hitting flat against the tail light.
Okay, what we're going to do to make this more efficient, excuse me, sorry. Mr. Wolf, can you pull up a slide from Mr. Wolf's or Dr. Welcher's presentation for the back of the Lexus, please? The back hatch, and Your Honor, may we publish that?
Sure. Do you know what number though, Mr. Alessi? So
Mr. Wolf does, and
And
I
then
know
he'll
you
tell
need it, so
us.
he'll tell me before I publish, and then we'll give you the number.
Your Honor, may I look here?
Yes, I'm going to let Dr. Welcher look at his slide
Oh, sure.
here instead of just up there.
The back hatch, yes. Do you have one of just the rear gate? The one measuring the height, maybe? There we go. Thank you. Okay, this is your slide presentation. Is there any part of the back of the Lexus SUV that has that more concentrated area where if the hand hit it, 300 to 400 pounds of force could break it? Is there
Wiper?
any part, for example, the edge of the license plates, above the license plates, the L symbol that sticks out that would be concentrated? Anything you see there, could 300 to 400 pounds of force contacting at any of those points cause a fracture of any of the bones of the hand?
So, I don't know how to show this because in the middle photograph, right where the 2 is on the license plate,
Yes.
there's a vertical edge. That area is recessed in. So if you hit right on that vertical edge, that could potentially do it.
That could do it. How about the L for the Lexus symbol if the hand is there?
No, it's not deep enough. The compliance of the hand is just going to sink into the car.
Is there any other part other than the license plate that the force applied, you would only need 300 to 400 pounds of force to break the hand?
Maybe the exhaust pipe, and potentially if you hand your hand up near the spoiler.
Right, so now let's go from 300 to 400. Let's go to the 2188, which is your number. Use 2188. Is there any place where in 2188 force you could have a fracture of the hand on that back gate?
Just to be clear, 2188 is the number I calculated for you. It's not, quote, my number.
I understand, but we did, we did the calculation. Is there anywhere on the back of the vehicle where 2188 could cause a fracture of the hand?
So that was a forearm fracture tolerance I thought we were talking about, because we used the weight of the whole arm for that.
We did. And my question is there anywhere in the back of the vehicle, in your opinion, that could cause a fracture with that?
I'm sorry, what, to the hand? Just the hand or the whole arm?
I'll take any part of the right arm. You call it the hand, the forearm. Is there any part that could cause a fracture?
So probably similarly, if you got your forearm down near that transition, like, I don't know if you can see the little dot. I'm talking about this area.
Yes.
Right here.
Yep.
So that transition between the 2 body panels.
Yes.
That could potentially do it. That's back where the reverse lights are. I'd have to look at whether, that would take it before breaking the plastic. And then, again, maybe if you hit the exhaust pipe as well, it's a much more narrow loading condition.
How about the corner of the tail lamp?
The corner of the tail lamp. I suppose if you had just your hand on the very, very corner, potentially.
Potentially.
But you didn't deal in possibilities.
Any of that force analysis for this case, did you?
For the hand, no.
But you did it for the head, correct?
Correct. Because that I'm able to quantify.
Mr. Alessi, that was slide 108. I just want to
I'm
keep.
sorry, Your Honor. Yes, Mr. Wolf. Yes,
All right, thank you.
thank you. You are aware, Dr. Welcher, that Mr. O'Keefe suffered no fractures of any kind in his hand, correct?
So there were no fractures noted in the autopsy report, but they didn't actually x-ray from the records I've seen either
no
his
kidding.
hand or his arm. So there was, at least according to the autopsy report, no overt fractures, but the x-rays I saw, none of them were the arm. And the autopsy report said no sternum, spine, I think it said torso. They didn't say that there were no
So they don't
fractures
actually
there.
know there's no
Was
boxer's
there any
fracture.
evidence in the medical records that you reviewed of any indication whatsoever of a fracture in Mr. O'Keefe's hand?
No,
Was there any indication whatsoever in any of the medical records you reviewed that there was a fracture of any bone in the right arm of Mr. O'Keefe?
not that I saw. Again, it wasn't x-rayed.
Was there any indication in the medical records in the autopsy that you say you reviewed of any fracture of any bone anywhere in the body of Mr. O'Keefe,
Yes.
other than the occipital bone or the skull?
There's a couple bones in the skull that were fractured, but other than the skull, no.
Correct. So, are you aware that the medical examiner for the state of Massachusetts, Dr. Shorty Bello, performed an autopsy on Mr. O'Keefe? Are you aware of that?
Yes.
And you're aware of it because you read the autopsy report, correct?
Correct.
Are you implying, it's a question, that Dr. Shorty Bello missed a fracture or didn't look properly for a fracture on Mr. O'Keefe?
No, I'm simply indicating that, for example, a hairline fracture, I didn't see any evidence that they actually x-rayed the structure, so there'd be no overt evidence of that.
There were wounds on the right arm of Mr. O'Keefe, correct?
Correct.
And you are saying that the medical examiner should have x-rayed that to determine whether there was a hairline fracture? Is that your testimony?
No, you're asking me about evidence and proof of absence of fracture. So I would look for an x-ray to see if that was the case. I haven't seen any evidence of an x-ray of the arms.
So it's your position that on every autopsy, there should be an x-ray of every bone in the body, and that the clinical judgment of the medical examiner should not be accepted, and there should be an x-ray of every bone before a conclusion can be drawn that there's no fracture to a bone in the body of the deceased. Is that your testimony?
Absolutely not. Like, I'm an engineer. You're asking me about proof. And so proof is somebody looked at it,
I thought
somebody
words
took an
were good.
x-ray, somebody palpated it and found
I
a
thought listening
comminuted
to people's
fracture.
words was good
So
with you,
we're
but
talking
not
about
Sporty
proof.
Bellows.
Sir, I didn't use proof in my question.
You asked me about the opinion of a medical examiner. I'm not a
Hold
medical.
on. Only one person at a time. Mr. Alessi, let him finish, and then you can ask the question.
Your Honor, I hadn't finished my question.
Okay, then finish your question, Dr. Welcher. Wait for the question. Then let Dr. Welcher respond. It's a nightmare for medical
I
reporting.
understand, and I think I've been doing that, but I'll redouble my efforts. Dr. Welcher, I didn't use proof in my question. I'm going to repeat the question. Is there any indication in any medical record, autopsy report of the deceased of any fracture of any bone in the body?
That was not your original question, but to answer your question, no. Except for the skull.
Except for the skull.
Correct.
Do you understand whether the absence of any fractures other than the skull of Mr. O'Keefe was of significance to the medical examiner, Dr. Scorty Bello, in the conclusion she reached in the autopsy report that you read?
System.
Did you read the conclusions of Dr. Scorty Bello in the autopsy?
I believe so.
Are you aware of whether Dr. Scorty Bello has analyzed whether the injuries to Mr. O'Keefe are inconsistent or consistent with a motor vehicle impact? Are you aware of any analysis to that effect?
So I'm going to see you on this one.
Gotta have that at sidebar. Why? Is it not right there in her report? Is that not clear from undetermined? You notice how this guy likes to comment on the question rather than answering the question? He likes to comment on the question. No admonishment there. No admonishment there. You don't have to editorialize and tell us your opinion about the question, Dr. Welcher. That won't be necessary. You can just answer the question. No admonishment for that. Oh, to answer your question, Mr. Casatelli, this is not the worst expert I've ever seen. No, they're quite often aggravating, irritating, obstructive, difficult, annoying, pompous, arrogant, all of those things. Quite often. Quite often. Really not that uncommon. This guy in particular, he's been doing this for 20 some years, right? Had his own company, sold it to Aperture. He's been billing $40,000, $45,000 for months worth of work for a lot of years. So yeah. Aggravating, isn't it? Do you think the jury feels like he's being helpful right now? Made a real point of, when he kept getting caught with his computer, I'm trying to be helpful. Does it seem like you're being really helpful when you're arguing with the questions and you're changing the terms and you're shifting from, G's to pounds, even though they're not the same thing? And it depends on the loading and how it's distributed. Where exactly? I would love to know. Anybody in the chat can tell me, is there like a definition for when a load is distributed versus when a load is concentrated? At what point? Because I can take this down to the atom. Is it only concentrated if it's like atom to atom contact, and anything beyond that is distributed? Because any load is going to be distributed. Any load takes place over a certain area, a surface area of the body. So every load is technically distributed. It's just like, how distributed is it? Is that the issue here? Because when I look at a collision to an elbow, to me, that seems pretty concentrated. That doesn't seem all that distributed. Distributed would be like my whole body came into contact with the back of the car. Is that just me? But, the semantic arguments are a way to bog this down and, not cooperate, not be helpful with the questions that are being asked. Am I wrong about this? Any collision is going to be a distributed load because it is taking place on a human body, which has surface area. It's not occurring on an atom to atom level. So they're all distributed loads. So you want to argue about how distributed they are or aren't. If you wanted to be helpful, great. Show me in the literature where that matters. Show me where it matters and how it matters. But it's throwing up these like semantic distinctions and then confusing terms and conflating, well, G's and pounds, and this whole thing is just a mess. Not coming across as helpful. For all that you're trying to disclaim how helpful you're trying to be, we can see what you're doing. Okay? And talk is cheap. That's why we show, we don't tell. What you are showing with your helpfulness is a very, very different story than what you are trying to tell with your words. Cadaver testing. He's going to pull out cadaver testing. Are cadaver bones the same as living bones? Are the impacts the same? Is that a valid apples to apples comparison? How much force does it take to break a cadaver's arm versus a living person's arm? I'm not sure that they are. I'm not sure that they're not. But I'm not sure that they are. I definitely know intuitively that a dead person is not the same as a living person. So at least on this technical level, we're definitely not apples to apples there. But I don't know if there's a material distinction between being dead and being alive that affects how much force it takes to break your arm. How dead are you? Does that matter? How are we breaking the arm? You know, are we having the arm lying flat on the ground and then we're dropping progressively heavier things onto it, for example? Is that how we're breaking the arm, or are we putting the arm in like a like a vise kind of thing, you know, and then like bending it, applying force at like the extremity at the hand, like say we lock the elbow in a vise and then we take the wrist and we start pushing on it with more and more and more force. Is that how we're breaking it? Does it matter? Is a cadaver an apples to apples comparison here? Don't know. And then suddenly he brings up center mass. Huh. How intriguing. Suddenly you notice that center mass matters. Because when you have a line down your body, your eyelid, your elbow, and your knee, it really does imply you're right behind that car, doesn't it? Center of mass. Unless you're maybe sticking your butt out a little bit. But if you're sticking your butt out a little bit, then you're not as tall. You're not as tall as you were when you were standing up straight. So he can, in fact, consider hypotheticals. He will fight them tooth and nail, but we can, in fact, go ahead and assume. We can go ahead and assume that a 12-pound arm being subjected to 300 Gs we can do the math based on those assumptions. He just hasn't done that for any of the assumptions except the ones that he's confident in.
May I, Your Honor?
Yes,
thank you.
Accept.
Dr. Welcher, I would like to talk now about your paint exercise.
Your paint exercise.
You did not present, as you have stated, a force calculation with regard to the arm. You did a paint exercise. And what I want to do is to reference, and if we need to bring it up, sir, to refresh you, slides 103 to 120 of your PowerPoint presentation in this trial. I'll just call it the blue paint exercise. Is that descriptive enough for you to know what I'm talking about?
No, it's not an exercise, it's a test.
Okay, you want to call it a blue paint test?
Sure.
Okay, let's call it blue paint test. I just want to try to expedite things and use parlance that we can agree on.
Okey-doke.
So your blue paint test involved painting the right rear taillight blue, correct?
Correct.
Positioning the test subject behind the taillight, correct?
Correct.
With the arm held out, correct?
Correct.
And at a right angle, correct?
Correct.
And then the vehicle, the Lexus SUV, is backed into the test subject, correct?
So I ran 3 different tests.
I know, well, let's just do each one at a time, okay?
Okay, so you start with the last one.
I'll start with whatever one you want.
Okay.
How about if we start with the one at 1 mile per hour?
None of them are at 1 mile an hour.
2 miles per hour?
2 miles an hour.
Let's do 2 miles per hour. Let's start with that one, okay? Now, did you conduct that test in an attempt to show that the injury patterns on Mr. O'Keefe's right arm are consistent with being struck by the Lexus tail light on that arm?
So generally, I wanted to show that the location, area, and span over which that headlight covers matches the location and area of the lacerations on his arm.
That's what I want to get to. So you discussed data that you say shows that that you say shows the Lexus SUV was traveling above 20 miles per hour during the period that you allege the SUV made contact with Mr. O'Keefe. Is that correct?
No. Where'd you get that from?
Hold on. Okay. The answer is no. So did you do a test involving 20 miles per hour?
I did some other backing tests.
Yes.
I was looking at how the rear pedestrian system and what warnings you got from the rear pre-collision system, the PCS system.
Let me ask you this.
Mm-hmm.
Would you agree
As part of your paint
that
test?
you did a blue paint test with the vehicle going at 2 miles per hour? Did you?
Of course.
Do that? Okay. You didn't do a blue paint test with the vehicle going at 20 miles per hour, correct?
That is correct. I was not going to hit myself with a Lexus at 20 miles an hour.
You didn't hit a crash dummy.
You could have done other tests where the vehicle was going at 20 miles per hour if you used a crash test dummy, correct? You could have done that.
If you use the right crash test dummy,
Right.
and then to set up the test, because generally you only get 1 or 2 shots at it because you damage the car, you have to know everything about the parameters. And so again, pedestrian impacts are so very sensitive to initial angles. If I were to do a test and it was off a tiny, tiny bit and we got some different results, I would be in here having to defend it. Well, your own testing didn't show it. Point is we don't
You
have
got
enough
it
information
exactly
to be
right
able
with
to
how you
conduct that
chose to
testing.
stand there? You're saying you chose it exactly right with how you stood there?
As I understand it, is that the Lexus was going 24 miles per hour in reverse and made contact with Mr. O'Keefe. That's your analysis.
No, there is not one single slide I have that says this is the speed he was hit at 24 miles an hour.
Do you know, do you have a hypothesis at what speed you believe there was impact? Do you have the point of impact speed?
I do not know the exact speed. We don't know the initial point of contact. We don't know where exactly he was on the road. We don't have enough information to determine that.
Exactly. Let's talk about the other information you don't have.
Okay.
You don't have the information as to from your alleged point of contact to where Mr. O'Keefe landed. You don't have that information, do you, sir?
I'm sorry, where is my alleged point of contact?
You allege that there was a point of contact between the Lexus, the back of the Lexus, and
Correct.
Mr. O'Keefe, correct?
Right, but I don't know where that is on the road.
Correct. You don't know that. I want to go through the information that you don't have.
Okay, dope.
So you don't have that. You don't have the point of impact. You don't have where in the road
there was impact under your allegation.
Those are the same thing.
Right. You don't have where under your view, the body of Mr. O'Keefe landed precisely. You don't have that information, do you?
What do you mean by precisely? We know it's 7 feet off the road. We know it's near the flagpole.
Did you
We
have
don't
a
know where it
measurement?
started. The problem isn't where it landed. The problem is where it started.
Right. And you don't have that
The
information.
problem
have
is
where it
also
started.
where it landed. It. Now we're back to John being it.
The paint tests that you used, aren't those used, if they're used at all, as an element of physical impact reconstruction, an element, not as the focal point of the test itself?
So that was the focal point of that test. The focal point of the purpose of that test was to show the contact width and location of how someone of Mr. O'Keefe's height, which happens to be me, contacts and where it would contact where the broken taillight was. So no, that was the focal point of the testing. That's why I did the testing. That's why we're calling it paint transfer testing.
Right. But my question, sir, I understand you use paint tests as the focal point, but aren't paint tests in accurate accident reconstruction not used as focal points? They're used as supplements to other tests to get more accurate information. Do you agree or disagree with that?
You didn't give me enough information. I can't agree nor disagree. It depends on what you're trying to do.
Let's go to, on direct examination, you testified that after the 1162-2 trigger event, Ms. Reed's vehicle traveled a distance of 87 feet. Do you recall that?
You are mixing up two things. Remember, the trigger is in the middle of the event.
Give me the chart, please. Your Honor, I'll give you the, as soon as Mr. Woke gives it, the slide 23, I believe it is.
I'm sorry, what slide?
Well, I want Mr. Wolt to go through it to check. Let me ask it this way, see if we can get to it quicker. Do you remember talking on direct about a calculation of 87 feet where you added, there was like a 30
Total distance.
something number and a 50 number and you came to 87? Do you remember that in your slide presentation, sir?
Slide 37, yes.
Right. So if we could bring up that slide, please, Your Honor, with your permission.
Okay.
That's 36, but okay.
Are you on 33, sir?
No, I'm on 36.
Mr. Wolf, do you have 33? If you could go to 33, sir.
Oh, sorry.
Yeah, because that's where your 87 number is, not on the other.
It's on a bunch of slides.
Yep.
Go ahead.
All righty. So if you could zoom in, Mr. Wolf, so Dr. Welcher can see the numbers in the column.
You're going the wrong way.
Yep, to the farther to the right.
Oh, I'm not the only one that has problems.
Okay.
You
Sir,
still
do
don't
you
have it.
remember testifying about this to the farther to the right?
Farther to the right.
Yep.
Keep going. Keep going. Yeah, a
Is
little
that
more.
53 number down there? That column?
Right.
So if
Can
you
we,
take-
can we scroll up a tad so you can see the headers? There you go.
Okay.
No, okay, go ahead.
So am I in the right column relative to start? Is that the column?
So there's two columns, like Z is relative to where it started. And then positive is forward. And then as you back up, once you go past zero, it becomes negative.
Right. So what I want to do is have you direct us to the column where you calculated 87 feet.
It's in two spots. It's at the end of column Y.
Right? We go all the way down. Is that in the yellow there? Is that 87, sir?
It is.
Okay, is that the 87 number you were
Hold
referring
on a
to?
second. You asked me to identify. So then it's, see where the one next to it says minus 53?
Yes.
0.429. If you go up, so it's not a little bit down, a little bit, and add, see where it's changing directions at 34.157?
Yes.
You add those two together, that gives you the same result. So it went 34 feet forward and then 50 something feet backwards.
Right. And what is the 87 feet traveled, is that what you're indicating is the distance traveled during the trigger? Is that what the 87 represents to you?
That is so 87 represents the total rearward distance traveled during the trigger.
Okay.
What?
So you believe 87
No.
represents the total rearward distance. Did I hear you correctly?
Correct.
Now, can you
Just hold on, to be clear. So it starts, it pulls forward, then it backs up, passes where it initially started, and goes 53 feet further back.
That's what I want to get to. How
What?
many
Since
feet
when?
did you say on direct, and did you just say now that it went 87 feet in reverse?
Correct.
Okay.
From its furthest point forward.
Well, that's what I want to get to because I want to have this point clear. How many feet do you believe the Lexus went in reverse based upon your PowerPoint presentation? Not when it went forward and then came backwards. How many feet do you believe that vehicle went in reverse?
Your question doesn't make any sense because when it went forward, then it went in reverse.
Your answer doesn't make any sense. He asked you about the reverse part. Answer the reverse part.
How many feet do you believe the Lexus
Forget about it
went
going
during
forward.
the trigger?
So it went a total of 80, it went 34 feet forward, then it came back 80, or another 53 feet past where it went.
Exactly. So
50
you've
feet past where
testified
it
that
started.
the 1162-2 trigger event represents a backwards maneuver, correct?
So again, I was clear, it initially pulls forward and then backs up.
I would like you to define, so it's clear to the jury, do you consider the event of 1162-2 just backward movement, or do you consider the trigger to be forward movement and adding to it backward movement? Which one?
So can we pull the slide up?
Sure.
Could you zoom in? There you go. No, go back to the left. So that T in the third column for data ID represents the trigger. If you scroll over a little bit to the right, where the highlighted yellow blocks are, you can see 1 is a forward drive gear, 0 is neutral, 2 is reverse. So that's where it's switched from forward to reverse. I mentioned the brake. So you have it on the brakes coming in, slowing, stopping, going into reverse, and then backing up.
So you conclude that the vehicle for this trigger went 34 feet forward, is that correct?
Correct.
How do you know the vehicle didn't go 150 feet forward? How do you know it just went 30 feet, 4 feet forward? How do you know that?
So the only data we have is this 10-second window. And so we have the velocity when it's going forward. We know how much time it took to do that. So that tells us how far it would travel. Velocity times time is distance.
So are you saying that it is a certainty that it went forward 34 feet and there's no other number of feet it could have gone forward? You're absolutely certain of the 34 number?
No. Again, if you look, see where it says vehicle speed?
I see it.
So at the start of this event, which is the trigger -5, so the trigger is actually where it's triggered, and it takes 5 seconds before, 5 seconds after. But when the trigger happens, it's actually stopped. But the 5 seconds before, it's going 13.6 miles an hour forward. So at the start of the data, it's still going 13.6 miles an hour forward, but it's slowing down. You can see you have the brake where it says brake SW, which is short for switch. The brake switch is a 1, which means it's on. So when this event data started, it's going 13 miles an hour.
I'll ask the question.
And you
a
could
different way.
calculate every interval
Are you certain
and add them together.
the distance traveled forward during this trigger event was 34 feet? Are you certain?
I'm pretty certain during this trigger event.
Well, he said
certain
no
or
before.
certain?
He's not certain.
Well, I've checked the math. I've had people check my math. So I try to be as accurate as
Oh, you
possible.
have people
I would
check
say
the
I'm
math?
certain,
Okay.
but I'm an engineer.
Okay.
So there's no absolutes. There's no 100% in my job.
So you're certain of the 34 feet, and is it correct that you're certain of 53 feet going backwards? Are you certain of that, sir?
So backwards from its initial starting position.
Yes.
Correct.
Okay. And therefore you are certain of a total of 87 feet traveled that you have at the bottom in that yellow-orange. You're certain of that as well?
87 feet of backing, correct.
Okay. Now, you also testified on direct, as I understand it, in slide 23, that different numbers represent different gear states of the vehicle, correct?
Correct.
And a 0 represents neutral,
I think it's either neutral or park, but I'm pretty sure it's neutral.
a 1 represents drive,
Correct.
a 2 represents reverse,
Correct.
or a 2 can represent slowing down. Is that correct?
Not for a gear shift number.
So you didn't say on direct that 2 could represent reverse or slowing down.
God, I hope not. It doesn't. So those numbers simply represent, is the transmission in drive? Is it in neutral? Is it in reverse? It doesn't tell you anything about whether it's slowing down or not. But the brake switch and the brake pressure and the longitudinal accelerometer data gives you some information on that.
Okay, so if Your Honor, we could go to slide 30, please.
Okay.
Mr. Wolf. And I want to do it generally. There's not a need to read any specific number. I just want it clarified.
Mr. Alessi, so is this 30 or 31?
I'm sorry, Your Honor, you are correct. It's 31 in the most up-to-date presentation. Thank you.
Yeah, which
You
presentation?
see all the numbers in blue font on that slide, sir?
I do?
Those are all numbers that you have placed on that slide. Did I have that correct in your direct presentation?
You do?
Okay. So this Excel spreadsheet, there's also numbers in black, correct?
Correct.
So all the ones that are in blue, those are numbers that you have placed into the spreadsheet. Correct?
Correct. The one exception is column N, where it says ship position.
Yes.
I changed green to forward and red to reverse.
So the data in the columns in blue are not from the original data that was downloaded from the vehicle, correct?
Like, for example, if you look at column H, I simply did a unit conversion. So it's the same number, it's just in different units. But the black numbers represent exactly as it comes out of the vehicle, but it's the same number.
All right, that's what I wanted to get to. So for clarity for this slide, when you download this data from the vehicle, what is in black, those numbers just come right out, correct?
Correct.
As they're stated. But the blue numbers, they don't come out like the numbers in blue. You have to do something, some calculation, some application to get to the blue, correct?
Correct.
Okay, thank you.
You're welcome.
Shut up.
Now, we're going to keep that up, Mr. Wolf, please. Thank you. And when we need to get to the specific numbers, we'll be fair and make sure you can see them. Now, in these columns, do I understand it correctly that you attempted to account for wheel slippage in the revolutions per minute speed values produced by the car?
Not here. You're looking, this is 1162-1. The wheel slippage occurred in 1162-2.
Okay, and so if we go to a slide with 1162.2, we will then go to the slide you believe represents wheel slippage. Is that correct?
There are data points in that represent slippage.
That's my question. In which slide, sir, would you like to pick?
35.
Thank you. So we will go to slide 35. So
I've highlighted the slippage.
exactly. So you agree that there is data that shows that there is wheel slippage with the Lexus SUV during trigger event. Let's enlarge it for this one here. The trigger event, the number 1162.2, correct?
Correct.
And as I understand it, you testified that this trigger event was caused by a depression of the accelerator pedal at more than the 30%. Is that correct?
It's a transition into reverse and then a quick acceleration exceeding 30%
So let's
in reverse.
Okay, got it. So the accelerator pedal being depressed to this degree, more than 30%, can be the result of wheel slippage, correct?
It doesn't necessarily work that way. I mean, you can have wheel slippage at any acceleration, technically, depending on the roadway. It's just what is in the data that shows that it's slipping. It isn't necessarily because of the accelerator. Normally, that's what causes slippage. But it's the data. When you look at the data, you're like, well, that doesn't make sense. It's increasing in speed, but yet the longitudinal acceleration is dropping.
My question, again, doctor, is you can have an accelerator pedal depress greater than 30% and it be caused by wheel slippage. That can occur, correct?
The wheel slippage does not cause the accelerator pedal.
I'm not saying a cause and effect. I'm just saying a correlation. Do you understand what I mean by a correlation?
Let me, if I may, try and straighten this out. So applying heavy acceleration can cause the wheels to spin. Is that what you're asking me?
Yes.
Yes.
Okay, that's all I wanted to get at. Alrighty. So in your review of the materials that are related to January 29, 2022, did you become aware of whether there were, and you said you extensively reviewed documents, did you become aware whether there were people at 34 Fairview?
Yes.
And approximately how many people, without regard to names, just number, how many people did you become aware were at 34 Fairview on January 29th, 2022, the early morning hours? How many people approximately did you become aware were present?
It depends on which time, but there could be as many as 16.
As many as 16. And let's talk about the time period from midnight to 1 a.m. Do you have an understanding of how many people could have been present at 34 Fairview at that time period?
So I'm going to see you at Sidebar on this, Mr. Chairman.
Why? Because it's related. It's based on hearsay. Is that why? Is that why? He wants to know why. He wants to know how many people were at 34 Fairview. How that factors in. 3,600 RPMs is kind of loud, huh? Kind of loud. That's when that car kind of starts screaming a little bit. If you're idling at 600, 700, and then your RPMs are up to 3,600, that's going to be loud. He's talking about spinning out. Yes, you can definitely spin out. Hit your accelerator too hard and the wheels start moving like too fast. You don't have real grippy tires. You don't have your I guess you wouldn't use your racing slicks for that. You just have like your fat, your nice fatty tires, all that grip on the surface of the road. Then you might not spin it. You're still probably going to spin out because it's a lot of torque. It's a lot of torque when you just hit the acceleration. And then what happens when you spin out? You usually hear that too. Now, would you hear it on snow? Not if there was a lot of compacted snow. But that isn't our conditions at this time, is it? So I think that's what Mr. Alessi is leading up to, is the improbability that up to 16 people in the house. Nobody heard, the wheels spinning out. Nobody heard the 3,600 RPM revving. Nobody heard any of that stuff. Did this guy really say he's an engineer, so there are no absolutes? Did he really say that? Is F equals MA not an absolute to you, sir? If it's not, I don't think you belong. I don't think you belong in engineering. It may not be for you. You're like in one of the few fields where there are lots of absolutes. You get to deal with lots of absolutes. F equals MA. Is that not an absolute to you? I mean, what a mess. This whole travel calculation, this is way different than I understood it from the direct. I thought he was saying in the direct it only went back like another 20 feet. It did 54 feet in reverse. I thought the 87 was the total forward and back, but it's just the back. So he went 50 feet beyond where he started.
Thank you. Dr. Welcher, am I correct in my understanding that you believe under your theory, the Lexus for event 1162-2 backed up 53 feet? Am I correct?
No, it backed up a total of 87 feet.
Okay, let's take your 87. It backed up a total of 87, okay?
Correct.
And your further theory is that it did so and reached 24 miles per hour, correct?
Correct.
And you stated you have an understanding of a certain number of people, and I don't want to talk about the inside of the house, but just that were at 34 Fairview between roughly 12 and 1 a.m. Do you have an understanding of that, sir? Approximately.
I believe I do.
And what is that number?
Did you want people that were there for that entire window of time, or just?
Yes, 12 to 1.
Answer the
So
question.
Mr. Alessi, just move to the last question.
Right, sure. So, sir, did you assume that there were cars parked out front of 34 Fairview at that 12 to 1 o'clock window? Did you assume any cars parked out front?
The entire time?
No, I'm just talking 12 to, any time between 12 and 1. Did you make any assumptions whether there were cars parked out front on the roadway at 34 Fairview? Did you make any assumptions with regard to that?
At a point in time, there was a vehicle behind it.
I'm sorry?
There was a vehicle behind it.
Just one?
That is my understanding, in terms of on the street.
On the street, exactly.
Yes.
And do you remember the type of vehicle?
Yes.
What kind of vehicle was
Truck.
it?
An F-150 pickup.
Did you have any understanding as to whether there was a Jeep vehicle on the road at that 12 to 1 time period?
I had seen testimony somewhere to that effect, but the majority of the testimony was there were no other vehicles.
But you did see testimony that there was also a Jeep type vehicle on the front, out the front, of 34 Fairview between 12 and 1. Is that what you're recalling?
So I'm going to let that answer stand, what he's just testified to. Just go ahead and.
Okay, so Dr. Welcher, what I want to do is to have you, using your data, you say 87 feet for the backup, correct?
Right.
1162.
What's the frontage of 34 Fairview?
Isn't there a likelihood, if there is at least one vehicle out in front of 34 Fairview, that there would be a collision of the Lexus SUV with a vehicle out front?
No, the vehicle had left prior to the end or prior to event 1162-2.
What information do you have with regard to how many vehicles are in front of 34 Fairview at between 12 and 1?
So I have Miss Reed's interview statements. I have
Didn't ask you
statements
for
of
the
a number of
statements.
witnesses. I don't know if I'm allowed to say the names.
I'm just going to say, let's not just number of vehicles.
Okay, so I have a number of witness statements
He's
at
still
different,
not answering the damn
multiple
question.
statements from the same witnesses at different times, indicating the path and following the Lexus to the house and then leaving before the event.
Assume that there were vehicles, at least one vehicle parked out front of 34 Fairview. Is there a likelihood that given 24 miles per hour over 87 feet, is there a likelihood that there would be a collision given the weather conditions as you knew them to be at that time?
Well, the weather, I don't think necessarily plays into whether there would be a collision or not, but we know it backed up 87 feet. So again, it goes forward like 35-ish and then back like 60 something. And so if something is within 65 feet of the rear of it, or whatever the numbers are, I don't need my slides.
It was 50.
50,
Okay. Yeah, go
57. If something is within that window, then it would hit it.
All right, good. So now let's look at another scenario. If it's going as you describe it, is there a likelihood that the Lexus would also go upon the lawn in front of 34 Fairview?
It depends on where it starts.
You have an opinion, don't you, as to where it starts?
No, I do not. That's actually why I have that diagram showing it off to the side.
That's
I'm
right.
simply showing how far it moved forward, how far it moved back.
Exactly.
We don't know where on the roadway it started.
Exactly. You don't know where on the roadway it started. And therefore, all you have is the distance covered, correct?
Correct.
So, but you're saying the distance is 87 feet, correct?
87 feet backwards, yes.
So backwards, 24 miles an hour. Have you ever driven a vehicle backwards 24 miles an hour, sir?
Yes, I think I've driven this Lexus backwards 24 miles an
Right.
hour.
So if anybody who's driven a vehicle back, have you ever driven any vehicle back 24 miles an hour at 1 o'clock, 12 o'clock in the morning?
Probably not since I got out of high school.
Have you ever done it when there's a storm that is beginning?
No.
Have you ever done it when there is less than clear visibility?
No and no.
And have you ever done it when there's low lighting?
Oh, maybe when I've been up skiing in the snow, I've
You
done
went
it.
up skiing and you reversed at
But again,
24
that's
miles
been
an hour?
Decades.
Right. So
Really? Tell us more.
87 feet,
Tell us more about your ski
24 miles
adventures.
an hour. Are you saying that in every instance that vehicle will stay on the road and for 34 Fairview, it wouldn't go up on the lawn?
When you mean every instance, mean like every possible location on the road it starts from?
Correct.
No, there's some spots, if you start here, it's going to go up on the road, on the yard. If you start too far on the other side, you're going to go over into the neighbor's yard. So it depends on where you start.
Right. And so in given the conditions that we've just described, right?
Conditions
the weather,
have nothing to do
I
with where
need
you
to
start.
finish my
Hold
question,
on.
sir.
Only one at a time.
Yes, ma'am.
Let him finish his question, please.
Given the conditions that you've described, it is reasonable to conclude that that vehicle, under your parameters, would have gone up on the lawn. Is that a reasonable conclusion?
No.
So you don't think there's any possibility that could occur, a vehicle going 24 miles an hour at this location, 87 feet backwards,
You already
in
said
the
it could have
dark,
gone up on the curb.
with wet pavement at a minimum, and low lighting, you don't believe it's possible for the vehicle to, under your scenario, to have gone up on the lawn? That's not
So
possible.
your first question was reasonable, and I said no. Now you're asking possible. It, of course, is possible. Whether it's reasonable or not, I'd have to know the starting position.
Right.
If it's very close to the side, then it could be reasonable. If it's further towards the middle of the road because snow is building up on the side of the road, then it's probably not as reasonable. I would need more information to be able to determine whether it's reasonable or not. It's certainly possible. It's possible it could have shot off into space as an engineer.
Oh,
but
is
not
it?
probable.
Is it?
Oh, you
Tell
think
us
it's
more about
possible
that.
that it could have been shot off into space, sir?
As an engineer, it's a possibility.
It's a possibility that this
Absolutely.
Lexus could have been shot off into space.
Yeah, highly, highly unlikely. But
All right.
again, you're asking an engineer about possibilities and probabilities.
Let's get back to reality. So in terms of
Yes,
the
let's.
Lexus itself, because you, under your method of analysis, don't have the starting point, you can't rule out that under your scenario, the vehicle would have gone up on the lawn. You can't rule that out, can you, sir?
I cannot, no, it could have.
Okay, now let's go to the next topic. If we could, Your Honor, have Exhibit 168 published in evidence, which is now under the 167. Now, as I understand your testimony, Dr. Welcher, you believe that it's possible that the Lexus taillight could have caused these wounds to Mr. O'Keefe's right arm. Is that correct?
Correct.
And more specifically, it's your belief that the lacerations would have been caused by the vehicle scratching Mr. O'Keefe's arm as it drives past him. Is that correct?
I don't know, I'd characterize it that way. What happens is, you know, this 6,000 pound vehicle is coming and he's standing on a, you know, icy, snowy roadway area, and it's going to contact him and move his whole body and induce rotation.
Right. So it's going to contact him and, under your theory, induce rotation. So wouldn't such a movement of the car relative to his right arm result in horizontal injuries to Mr. O'Keefe's arm, as can be seen on his bicep above the elbow?
So could we pull up one of my slides to address this issue?
Sir, I'd like to
I'd like to answer your question with a slide that I have that addresses this exact point.
I'd like to stay with this slide, Dr. Welcher, and see if you can answer my questions off of this slide. So I'll repeat it.
Sure.
Do you agree that the injuries up at the upper part, where you're familiar with the bicep brachialis?
I am.
And aren't those two up at the top, right over the bicep brachialis?
They're actually about midway between the biceps and the triceps.
Right. So you know which two I'm talking about, the two up there. Can you just use your laser pointer just so we're talking about the same two? Do you have one?
I'll give it a try, but the upper ones,
I know it's not your fault, but
on the
sometimes it
image,
doesn't
the
show.
upper left, I mean,
Yes.
technically the ones right to the right of that are also on the biceps and triceps.
Right, but
The
I'm talking,
biceps goes all the way to the elbow, so do the triceps.
right, so I'm talking about the two that are the farthest up.
Correct.
All right, would you agree
He said brachialis.
that those are
you
in
know what that
a
is?
horizontal orientation?
Generally, yes, which is what you'd expect with your arm like this, and the taillight coming across like this, which is what I showed in my slides.
My questions are trying to keep this moving. I just asked if those are in a horizontal orientation.
Yeah,
Yes
more
or
or
no?
less. They're angled down slightly, but more or less horizontal.
Okay. Isn't it true that if Mr. O'Keefe's arm were to be flexed like it was with the
In your
test
demo.
subject in your blue paint test, the lacerations on Mr. O'Keefe's forearm would be oriented in a vertical direction?
Absolutely not. If you pull up my slide 117, it'll show exactly that it is like perfectly horizontal. When you're standing like this, and this is the tail light, the laceration, when it comes across here and pushes my body,
Yeah,
it's
but
going
now
to
we're
make a
talking about your
horizontal
forearm.
laceration because the 6,000-pound vehicle is going to push me out of the way. As this pushes me out of the way, it's going to drag and create a horizontal laceration across my arm. This is exactly what you'd expect.
So let's talk about the forearm, sir. We may have miscommunicated. I'm talking about the lacerations on Mr. O'Keefe's forearm now.
So we're switching from the arm to the forearm.
Correct.
Gotcha.
Wouldn't those be oriented in a vertical direction?
No. Again, you have the vehicle, if this is me and this is the car, it's pushing and pushing across like this. And with your arm bent like this, it's going to cause laceration as it pushes my arm away.
Yeah.
It
Now
pushes
straighten your arm
that.
like John's.
Okay, I
And
got
it's- my slide shows this quite clearly.
So you disagree,
Just a
you
masking
do
tape.
not agree that the
Do it, and now
injuries
straighten
to
your
Mr.
arm.
O'Keefe's forearm, under your theory, would be oriented in a vertical. You disagree with that. It's just want to get that on the record.
I disagree with it.
Okay. Now, also, do you understand that under your theory of injury here, that there would be injuries caused in two different directions by the same movement of the car? Agree or disagree?
I'm going to say I disagree. You need to give me a little more. You're going to have, again, this is a glancing or a clipping type impact. And so it's going to be it's going to sweep across the arm, which is what causes the horizontal lacerations.
We're talking about a flat surface, right, sir?
Approximately, yes.
And therefore, you would have to maintain contact with the arm as the car moves. Am I correct about that?
Maintain contact with the arm? I'm unclear what you mean.
Tail light?
What I'm trying to do, sir, is to get under your theory, right? Given the contact that you've described, what would you expect to be the orientation of the wounds to the upper part of the arm and to the lower part of the arm?
Just like it's shown in this photograph.
Okay.
Okay. If you insist, we can all flex our
Isn't it
arms
the
and then
case
straighten
with
them
your
and see how that
theory
doesn't work.
that the tail light would have to break? And after the break, the arm would have to maintain contact with the arm as the car moves.
So that is what happens in pedestrian contacts. There is a contact duration. For example, you asked me earlier in that calculation you had me ran, you said 0.01 seconds. That was the contact duration. So when you have things like this, that's why you have to allow, if you do testing, the body to move, because the car is going to hit the body. It's going to cause it to move. The body's going to rotate away, and the car is going to continue on in that clipping type impact. So the arm is definitely in contact with the rear of the car for some time.
That's what I wanted to get to, is simply that under your theory, the taillight would break And also, the arm would need to maintain contact
So where's the
with
blood?
the taillight area as the car moves. Is
where's the
that
blood?
your supposition?
So at a point in time, it'll stop contact, but the 6,000-pound vehicle is going to want to continue moving on. It's going to push. It's going to initially contact the arm and then push the arm away as it rotates the body. So yes, it's going to maintain contact until the clipping is over and the vehicle continues on.
So my next question is simply, how long do you believe the arm needs to maintain contact with the taillight after, under your theory, it breaks to produce those types of wounds that you say came from a taillight?
We don't have enough information to determine that.
Right.
Right.
You don't have enough information to make that determination, do you, sir?
Correct.
And-
But we know because of the laws of physics that it has to be some amount of time. It doesn't occur instantaneously.
How do the laws
So
of
now
physics
you
explain no
apply
blood?
the laws of physics to the right arm that weren't applied before because you applied a paint experiment. Is that correct? You're now applying the laws of physics to the injury to the right arm. Because you
No.
didn't do that in your report.
Nope, always applied the laws of physics. The paint experiment, as you're referring to it, was to look at basically the orientation of the scratches that matched this. So that was an engineering experiment to correlate height, position of the taillight relative to height, orientation of the
What other
lacerations
things
on
does the
Mr.
taillight
Kufarm.
height correlate
You just
to?
said, sir, if I heard you correctly, you, to answer my previous question, applied the laws
else
of
does the
physics.
taillight height
That's what you
correlate
just said,
to?
correct?
So the laws of physics
Offense codes?
cover more than Newton's second law. There's a whole law of physics. The whole field of physics is a broad subject. So a simple measurement of height is a physical measurement.
Sir, I have your
So
entire
touchy.
report in my hand, right here. Where in the report do you apply the law of physics to the right arm of Mr. O'Keefe? Where?
So in the paint experiment we did, the laws of physics about gravity, orientation, things like that, I didn't apply Newton's second law as we already went through. But again, those simple positions, arm angles, the possible physical arm angles, those are all generally governed by the laws of physics. The laws of physics are very broad.
Sir, I'll ask it this way.
Really?
Where in your 14-page report do you even mention the laws of physics related to the right arm of Mr. O'Keefe?
So in terms of applying the laws of physics.
I'm not asking applying, just where in the report is it mentioned law of physics relative to the right arm? Can you point me
I
to
don't
where?
would write a report that said, these are the laws of physics. I would say, these are the numbers. But for example, the timing in GPS, how a clock times, the concept of a second. What does that mean? Those are all concepts of physics. So the timing, the GPS, the mileage, how we calculate the mileage, those are all based on the laws of physics.
I'm talking about injuries to the right arm.
That's not what you asked. You asked me about my whole report.
Sir, if you could, please, I just need to finish my question. Where in your report do you use any laws of physics in connection with injuries to the right arm of Mr. O'Keefe? Can you point me to a word or a page in your report?
You listen
Yes.
to the whole question?
Where?
2A Roman numeral 1, 2A Roman numeral 2, 2A Roman numeral 3, 2A Roman numeral number 4, 2A Roman numeral number 5.
Sir, I followed all of it, but what I'm asking about is where in all of what you just mentioned is the word right arm? I'll take what you just said. Where in 2A and all of those is the word right arm? Where is it?
Oh, sorry, it's in number 3.
So let's go to 3. You state the location and orientation of the laceration on John O'Keefe's right forearm and right arm are consistent with the geometry and orientation of the right taillight of the Reed 2021 Lexus LX 570. Where,
Can you read the next sentence?
I'm sorry, is it see PowerPoint slides 102, 120, correct?
Correct.
All right. I want to just start with the report. Did you apply any force analysis to support 3?
So in terms of the force analysis, I did not do an F equal MA analysis, but in terms of, say, the contact pattern, I obviously had to apply some force, even at 2 miles an hour, to do that.
So the answer is, what you cited, number 3, you did not use a force analysis, correct?
We used a contact pattern.
Force
just
was
said.
applied to my arm in the paint test. I didn't do an F equals MA force analysis.
Thank you.
You're welcome.
So now let's
Start
go
using it. You're
to-
welcome to your benefit, Mr. Alessi.
the horizontal movement we were talking about with regard to the car. And you can agree or disagree.
Sorry. The picture's done.
I'm sorry, we'll take that down. Do you agree or disagree that given a horizontal movement of the car, vertical lacerations would be an inconsistent injury pattern?
So horizontal motion generally will cause a horizontal laceration. You can get what are called stellate, which are a blunt force, and it causes a splitting of the skin as well. But generally, when the vehicle is clipping or running horizontal across it, it will generally cause horizontal lacerations. But when you have a fractured taillight, you can get pieces going off in other directions. So it's not necessarily going to be perfectly horizontal.
So my question is,
Pieces
not with
have
clipping,
nothing to do
you
with
keep
it.
inserting
It's the
clipping into
movement.
my question. My question is this: if you given a horizontal movement of the car, do you agree that it's more likely than not that vertical lacerations would be an inconsistent injury pattern?
I'm trying to help you, but you got to give me more. So, like, is
We're
it a
going
clipping contact or is
with
it
what
not a
you
clipping
had.
contact? Is it a direct in the center of the car impact?
Okay, are there only 2 variables you need to
No.
answer the question?
But this is a good start.
All right, so let me do it this way. You can't answer the question on a general basis of whether there's horizontal movement of a car, whether vertical lacerations would be an inconsistent injury pattern. You can't answer that question without more information. Is that your answer?
So generally, again, horizontal motion should cause horizontal lacerations. But again, it depends on what's being hit.
Okay.
So for example, if I
Give
have
me an
something
example.
that bends as a result of the impact, it could bend up and create a vertical laceration.
So you would agree,
The
based upon what you
polycarbonate
said, that
bends?
generally, horizontal movement of a car would be expected to cause horizontal lacerations. Is that-
Generally,
Okay. Now, during your blue paint test, the blue paint was featured more predominantly on your upper arm than your forearm. Is that correct?
I think it depends on the tests.
Do you want, we bring up a slide? Will that
I'd
help
love to
you?
bring up a slide.
We're
I'd
going to be
love to
running
bring up a
the
slide.
thing, so we'll just bring one up and you tell me whether this slide works for you, sir.
Do you want me to tell you the slide I want?
If we could take a shot at it first, and then we may ask you for it, but I think we've got a slide for you. And what number?
Dr. Welcher, 111.
111 is on the screen, sir? Is the blue paint more predominantly on your upper arm than your forearm? Is there more blue paint on your upper arm than your forearm?
Come on, camera guy.
Probably. This is the one where I actually walked sideways into the back of the car. The one where the car's moving. is probably a little better representation.
Sir, I'm just asking you a question about this slide. If you
Okay.
could just focus on this slide here, and if you can't answer it, so be it.
I just answered it.
Is the blue paint featured more predominantly on your upper arm than your forearm?
It sort of looked like it. I didn't actually measure the total area of it.
All righty. So on direct, you stated that in order for the injuries on Mr. O'Keefe's forearm to have been caused by an impact with the taillight, his arm would have needed to be held outstretched as you did in your demonstration, correct?
You would need some degree of outstretch, yes.
Yes. So isn't that an example of confirmation bias?
No, that's matching the contact pattern
No.
to the injuries.
But don't you have to select among other choices this outstretching of the arm? You have to make that selection from among others, correct?
So that was matching the physical evidence on his arm to the physical evidence on the car, and then running a test to see if dynamically those matched up. So it's, I didn't have it hit the exhaust pipe, for example, because there was no assertion it hit the exhaust pipe. There was no damage to the exhaust pipe. So it was based upon the evidence, and the testing was done to test, to use your vernacular, the hypothesis that that's where it came from.
Sir, have I ever asked you anything about a tailpipe in any of my questions today?
Yes.
I have not. I've never
Yes,
asked.
you have. You asked me about the totality of the rear of the Lexus, which includes the tailpipe.
All right. I
Oh.
am not going to be asking any questions that involve the taillight in any fashion.
The
So what I'd
tailpipe.
like to do is to go back to the question that I'm asking, which is, did you consider, as part of the scientific method, in terms of more than one hypothesis, did you consider in your analysis any other orientation of Mr. O'Keefe other than the one you selected for your paint test?
Yes.
And where is that consideration of other hypotheses stated in any report?
It's not. I was just looking at the damage that was up on the sheet metal.
Okay. So are you saying that you considered other orientations of Mr. O'Keefe relative to the vehicle as part of your analysis?
In terms of where exactly the hand would be, some slight different angles in the forearm, which is from the elbow to the hand. I did consider that, but all the physical testing is done with the hand hitting the approximate center of the taillight.
Do you have any notes that you took for these alternative orientations?
No, I think I just included photographs of that damage.
Do you have any proof at all that you considered those other orientations? Anything in writing?
No, I don't believe so.
Did you consider any other locations of Mr. O'Keefe under your theory relative to the back of the SUV?
Sure. In the beginning of this, I started about, hey, it's all over. It could be anywhere on the back of it. Then whittled it down based upon the evidence, started eliminating various hypotheses based upon the evidence, and came to this conclusion, eliminating hypotheses based upon
that there was no
the
collision.
taillight fragments near his body, the lacerations, his height, the height of the taillight in a Lexus. So it was an iterative process.
Did you mention any of these supposed hypotheses in your direct testimony?
No, because I was able to reject them. I didn't come in here to tell these people what didn't happen. I came in here to tell them what I believe happened.
Would you agree, sir, that the scientific method earlier has the scientists identify various hypotheses, go with the data that supports it, but you show your math as to why you're rejecting hypotheses. As you said, you rejected them. I'm asking for proof that you considered other hypotheses. Do you have anything in writing, any notes at all, any videos
any tests that you did, documentation of other hypotheses other than picking this one? Do you have any documentation of that?
So I did a bunch of tests with Alexis. I did backing tests. I looked at how the rear system worked to see if it would autonomously brake. I confirmed it did not, so I eliminated that as a hypothesis. I tested the steering. I tested the transmission, what 1, 2 represented. So I did a whole bunch of tests on the vehicle.
I understand you say you did a bunch of tests on the
Good
vehicle.
non-answer.
My question is,
Mhm.
did you ever take the vehicle and position yourself or anybody else in various locations to determine whether or not your hypotheses could be properly rejected? Do you have any documentation that you did that?
I mean, I did do one static and 2 dynamic tests in very similar positions, though. So I did a total of 3 tests relative to the arm.
Where is the documentation for that, sir?
It's in the file. I gave it to you. Did somebody?
If I could,
Okay.
please.
I wasn't finished my.
Go ahead, finish your answer.
So slides 109, 110, 111,
I think we just skipped a couple seconds
actually
maybe.
through, I guess, 121 deal with the testing of the hypothesis.
We'll come back to this at another time, Dr. Welcher. So what I want to do is to finish up on this point. So is it your testimony that no part of what you did in selecting this area, no part of it is confirmation bias? You say there's no confirmation bias at all in what you did. Is that your testimony?
That's certainly my goal. I try and eliminate all confirmational bias. I didn't start out at this particular location. This is where the physical
really?
evidence led me to. So I would say the conclusions are supported by the science.
My question is, did you engage in any confirmation, and this would be my last question, did
The
you
answer is no.
engage in any confirmation bias
Listen to the
in
question.
terms of how you approach the issue that you have testified about in written reports?
The answer is still no.
It's a
All
good
right,
written.
so, okay, thank you. All right, so jurors, we're going to send you home because we still have work to do here and we don't need you waiting there while we do it inside the house. So tomorrow is a half day. We'll see when exactly that half day ends, but we won't be here until, we won't go until 4 tomorrow. Those 3 cautions: do not discuss this case with anyone, don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. 4th admonition, please be very careful with your social media use. See you tomorrow morning.
Rise to the jury.
So they still have some work to do. Are we going to get to hear it, or are you going to bustle them over to Sidebar so we don't get to be aware of what's at issue in the case and what's being argued and so forth? I saw that there's a new motion filed. I wonder if that's what it's about. The Commonwealth has filed something about how to handle expert testimony. Rule 14 something.
All right. Okay, Mr. Alessi, it's your voir dire.
Oh,
Have a moment, Your Honor, to switch.
we're going back to the voir dire that we just had earlier today? No, yesterday. Days run together. We had the voir dire yesterday. Now we're dealing with it? That sounds like a formality, doesn't it?
I load my slides.
Yeah, can you do that while you're sitting here answering questions? Yes.
Oh, we're doing more voir dire.
I'm going to start with Your Honor with regard to the Tr Paul issue.
Okay, and we're on a very limited schedule here, okay?
Okay, Your Honor.
This is what she didn't let him go into earlier.
Mr. Wolk, with Your Honor's permission, if we could pull up the January 30th, 2025 PowerPoint of Dr. Welcher in slide 36. You see that, Dr. Welcher? Do you recall that from your January 30th, 2025 PowerPoint?
I thought I had replaced the video on the left-hand side by the time I produced it.
Sir, I got to
don't
go through
recall
this
that.
quickly. That image is a drone image on the left, correct?
Oh, correct.
And you had that in your original report, but you removed it in subsequent reports, correct?
Correct.
Where did you get that drone image from?
It was in the file.
Wasn't it in the CARS report of Trooper Paul?
I believe it was.
So you took that drone image from the CARS report of Trooper Paul, correct?
Correct.
But he didn't review very carefully.
Let's, if we could, Mr. Woke, go to diagram 1. Do we have that electronically of Trooper Paul's report? Do you recognize that as diagram 1 from Trooper Paul's report?
Yes.
So, and that's the diagram that you took that image and you put it in your January 30th, 2025 PowerPoint, correct?
I'm pulling up my version of PowerPoint.
Needs a safety blanket for this. You can't just look at what's on the screen in his own eyeballs.
Yes, that's correct.
Okay, if we could take that down, I'm going to go to the next example. We could go to Dr. Welcher.
I'm sorry, actually, can we go back to that?
Yes. With, Your Honor, why do we?
Well,
I have limited. Go ahead.
so that particular diagram I did not use. If you notice, the diagram I use has different cars and doesn't have all the writing about the position of things on it.
I am going to now, Your Honor, have to take the time to go to Trooper Paul's report. We have the hard copy of Trooper Paul's.
Would you turn the lights on, please?
He's admitted he saw it and he used it. He pulled it from the file. It was from Trooper Paul's CARS report.
May I approach, Your Honor?
Yes.
He certainly didn't operate a drone himself.
This is.
How many drone videos were taken
Yeah, quick
during the
choice.
course of this investigation in the file?
Excuse me, Dr. Welcher. You see this first page, do you recognize this as the cover page for the Trooper Paul report that I was referring to?
Well, Lisa, can you show me the signature?
You want to look at the report, sir? I'm not so sure there is a signature on the report.
Signature block right here.
Yeah.
Trooper Paul, page 16.
I have that.
Yes.
Thank you.
You're welcome.
Now, what I want to do is to go to diagram 1. And if I could, Your Honor, republish what was just up. I'm showing you diagram 1, sir, and I'm asking you, is that the image from Trooper Paul's report that you then used to put into your January 30th slide presentation?
No. See all the writing on here, the glass cup, all the dimensions here. Here's my January 30th one. None of that stuff's here. There's different, none of this stuff is here.
Isn't it the case that this is cropped more and there's a larger picture of the same image or not?
See this tree?
Yes.
See these trees?
Yes.
See all these measurements by the trees? All
Yes.
these? That's right here.
Okay.
Those do not show up on my image.
Let me go to a different method then to do this. You have an image. Can we go, Mr. Wolf, to the January 30th presentation?
Slide 36.
Correct.
Oh, you already know you used it.
Where did you get that image from that's in your PowerPoint presentation on the left?
I think it was from the file, a satellite image from the file.
What part of the file, sir?
I actually don't know at this time.
How close is the image on diagram 1, the drone image, to the image that you can't now recall where you got it from for your slide presentation? Are they similar?
So that one has a whole bunch of measurements and ID on it, but the underlying image is very similar. It's probably the same one.
Right. Yes. You're welcome. Do you know of any other place you could have, let's put the presentation back up on the slide presentation. Do you know of any other location other than Trooper Paul's report that you could have got that drone image from?
No, I'm not sure I got it from the report. I recall getting it from the file.
My question is, do you know of any other source other than Trooper Paul's report that you could have gotten that drone image from?
So this image is not in that report.
It's not my
Yes, it is. You asked me anything but the report. That image is not in that report.
Did you get the drone image from any file from the Massachusetts State Police?
Yes.
Okay.
Which one?
Did
You can remember that.
Trooper Paul work on any drone images to your knowledge with respect to 34 Fairview?
I don't know.
But you would agree that the drone images are from the Massachusetts State Police file, correct?
Give me 1 second.
Sir, let me know you've had a fair opportunity to answer that question.
Yeah, give me a second.
Oh, now Bev's twirling glasses.
Yes, it came in a file called cars-trp.jopal.
Okay. So it came from, and that's the report of Trooper Paul, correct?
No, these are drone images that are not in the report.
No, I'm saying what you just read. Can you repeat it again, what you just read, where it came from?
I read you a folder
Yes.
that contains a bunch of things, including the report.
Understood.
That image is not in his report.
Can you read the file name again that you just read?
The folder name
Yes.
is
Oh my God. What a loser. Folder name.
cars-trp.jopal.
Okay. And did you get the drone image from that file folder?
I did.
Okay, thank you.
You're welcome.
Now let's go on to the May 26, 2025 PowerPoint that you created. And I'd like to go to slides 25, 26, and 27. Have you discussed with anybody today at all the source of what is depicted up on this slide?
No.
Okay, so let's now go to where did you get you see the larger chart to the left there in the, looks like mostly a rectangle. Do you see that, sir?
What slide are you on? What slide is that?
25, I believe.
Okay.
Okay, and then if we could click to 26, because it looks like it's the same. If we can go to 26 and 27, looks like it's the same one. You tell me.
Similar.
Similar, okay.
Yeah,
In 27,
correct.
see the same or similar one there, okay.
These are all from Google Maps.
Well, my question is,
Not the ones on the right. The chart on the right or the left. The chart on the left is not from Google Maps.
may I first,
Maps
Your Honor?
are from Google
Yes.
Maps.
Thank you. Let me ask you this so I don't have to keep going back and forth. Do you have access, sir, to the cars report of Trooper Paul on your computer?
Think so? You remember the name of it?
I don't. We'll do it there with the hard copy. Mr. Brennan, I'd like to show him this one. Thank you. So if I could, approach Your Honor?
Yep.
So you see what I'm pointing to right here, which is page 10 of Trooper Paul's cars report. Do you see that?
I do. Is this the same report dated 1/29/2022?
I believe so, sir. Let me just take a peek. This is, you can just compare. This is the one I have in my hand. Take it and look for any identification that gives you, right? We got the same one.
Yeah, mine's broken.
There's the chart.
Okay, so.
Thanks for showing
we
the
have that
camera,
report,
Alessi.
And I now am referencing page 10 of that report, and I'm looking at the chart on page 10. Is that chart on page 10 the same or substantially the same as the chart that is up on your slide presentation?
Yes, it
right
is.
now?
So it's not the same. I did not use this data at all, but we both use Google Maps.
Okay. All right.
Oh, God.
Now let's go to,
It's the same one.
your continuing on the same slide. If Mr. Wolf, we could go to slides 22 and 23.
Okay, and this will be the last on this, Mr. Alessi. If you want to get to the autopsy photo, we're wrapping this all up at 4:10.
Okay, Your Honor. You see these photos?
I'm sorry.
You see the photos that are up on that?
I do.
Okay. Do you, in terms of those photos, do you recognize
Oh, yeah,
any
look at the
aspect
thumb.
of those photos?
Yes.
What do you recognize in terms of the person in it?
Oh. You want me to limit it to just these 3 photos?
Any photo that would be, this photo
Answer
or any
the
photo
fucking
similar to it?
question, dude.
But let's start with just these 3.
If I have to limit it to these 3, I don't know who that is.
Okay, and if you don't limit it to those 3, who would you conclude it is in those photos?
It appeared to be Trooper Paul from other photos.
Okay, so you can tell from other photos that this is Trooper Paul in these photos, correct?
I have photos of Trooper Paul in the car. I don't know that someone else switched out. I have no reason to believe this isn't anybody but Trooper Paul.
Okay. Would you have any understanding that there's any other trooper that would be doing this type of analysis other than Trooper Paul?
Someone else took the photographs?
No, I'm talking inside the vehicle.
I'm sorry?
Inside the vehicle doing what's depicted here.
Someone is inside the vehicle taking a photograph.
What's your best conclusion as to who that is?
Trooper Paul.
Thank you.
God.
Your Honor, that is,
Okay, so next topic.
yes,
Go right
thank you.
ahead.
And I just need to reload, if you will, with regard to that topic.
Oh, she just rolled her eyes before doing a deep sigh. Mr. Alessi, you're making things very difficult here by seeking to confront this witness,
Your Honor, you can go to slide.
prior theories of the Commonwealth.
Okay,
If you can go, Mr. Woke, to slide 131 of Dr. Welcher's PowerPoint presentation. And it's now 132. I don't believe that's the right one. It's the,
One before that.
yeah, I think you're, yeah, okay. So this is slide 131 from your slide presentation, correct, sir?
Correct.
And if you look to the far right, I'm sorry, Mr. Woke, you go to the other one. Yes, that one, and scroll down so we can see what's in green. For that depiction, that is from Dr. Scorty Bellows' autopsy report, page 3, correct? Is that where you got that from?
It's from the report. I'll take your word for it on page 3.
So, but it is from Dr. Scordi-Bello's autopsy report, correct?
Right.
Now, if you could go to, if we could zoom back out and go to the multicolored image in the center, up at the top.
More deep size.
Yep, thank you. If you can go to the very top line, it says autopsy report performed by Irene Scordi-Bello, MD, PhD. If you could scroll back over, date of autopsy, January 31, 2022, and then you see final diagnoses. That is all directly from the autopsy report, is it not, sir?
Yes.
And that is in your slide presentation, correct, sir? This is page 131 of your slide presentation, correct?
Correct.
That's all I have, Your Honor.
Okay, you are all set, Doctor?
Thank you, Your Honor.
All right. Oh, did you have any questions, Mr. Brennan?
If it'd be helpful to the court, I have a couple quickly.
Okay.
Can I keep it under 2 minutes?
Oh, Mr. Brennan, it's now his word here. I thought we were in a rush because we were going to be done at 10 after, but it's 10 after, and I guess
Dr.
we're
Welcher,
not.
you were shown a photograph of the street of Fairview Road. Did you know that didn't come from Trooper Paul? It came from the CERT report, and Trooper Paul then took it from the CERT report and put it in separately in
for
his
Christ almighty.
presentation. Did you know that?
I had no idea. I just was given it as a folder.
And the photo you were using, it didn't have the markings that Trooper Paul put on his report, did it?
It did not.
When Trooper Paul, when you used that photo, was it because you were borrowing, relying on, or using any of Trooper Paul's reports for your conclusions or any of your decisions or analysis in this case?
I did not use his report at all.
It was simply limited to the use of the photo to show a different demonstrative issue.
Correct.
And then when you saw diagram 1, again, that was different than what was used in Trooper Paul's report because it had absent in it all the writing. Isn't that fair to say?
That's fair to say.
Did you rely on Trooper Paul's analysis or conclusions in this case for your conclusions and your analysis?
Not at all.
Is that why you went and downloaded the information and looked at the car and did everything individually, separately, and uniquely from Trooper Paul?
I wanted to be independent.
Did
in
Hank
my
dye his
analysis.
hair over the
Regarding
weekend?
Dr. Scordi-Bello, did you ever consider her conclusions regarding manner or cause of death as a basis for your analysis and conclusions?
Yes.
And when you considered her analysis, did you consider the conclusion of undetermined cause of death? Was that part of your analysis?
Oh, no. I was using like the skull fractures, the description of the injuries.
So you were considering the information in her autopsy report?
Correct.
How about her conclusions? Did you rely on her conclusions to do your studies or any analysis in this case as far as cause of death or manner of death?
Only I thought I said blunt force trauma and hypothermia.
Okay. Regarding her conclusions about whether this was caused by a car accident or not, did you consider that as the basis of your opinion?
No, I wouldn't take a person like that's opinion for that.
Did you ever have a
Person like
conversation with
that.
Dr. Scordi-Bello about her expertise limitations?
No, I would want a biomechanical analysis.
Was your opinion regarding the collision in this case, did it have anything to do whatsoever with Dr. Scordi-Bello's conclusions regarding cause of death, whether it was accident, undetermined, or homicide?
No.
Okay.
Thank you.
Yeah, Your Honor.
All right, one question. Can we just wrap it up? I'd like to hear you argue, but we don't have time, so I'm just
One
gonna
question.
I have
decision.
two questions, Your Honor. You put in your slide presentation information from the autopsy report of Dr. Scordi-Bello for a reason, correct, sir? And that reason is because you considered the autopsy report as part of your analysis, correct?
So I considered portions, which are the portions I
Oh.
included
You chose
here
what to consider
in
and
the
what not?
autopsy report.
And part of those considerations were the final diagnoses. We can put that back up, Mr. Woke. But you recall, the slide that you had has the final diagnoses of Dr. Scordi-Bello, and you put that in your slide presentation because you considered that as part of your analysis, else it wouldn't be in there, correct?
So the final diagnosis is in there. There's a line, then it says cause of death, and then manner of death.
Right.
The things I highlighted are the things I thought were important. So the highlighting on slide 130. So The final diagnosis, again, does not include cause of death. It does not include manner of death. There's that horizontal line demarcating those. The important things that I was looking at are the under or highlighted, which is why I highlighted them.
Exactly. So the ones that you highlighted, you considered are from the autopsy report. That's why you're highlighting them, right, sir? You considered that.
Correct.
Thank you. No questions, Your Honor. I
All
appreciate
right.
that opportunity.
So I'm not going to let you argue now. I'll hear you very briefly tomorrow before we stop. But Mr. Alessi, how much longer are you going to be tomorrow?
If I could have a moment, Your Honor, I'll
Yes.
give you my best estimate.
Well, that depends on the witness a little bit, Your Honor.
I'm about halfway through, Your Honor. I think it will take up, tomorrow. If we can get through things quicker, I would like to do that, but given today, that's my best estimate.
So we're half a day tomorrow.
Oh, that's right.
So we'll see you. See you Friday.
So it may be that we have a 20-minute break tomorrow and we finish up by 1:30 by going straight through. We've got a juror who has an appointment that we told her she'd be able to make. So I'd like to do everything we can so that Dr. Welcher doesn't have to come back or stay here another day. So let's just see
Well, then maybe
what we can do, and we
answer the
will do the
question.
same thing for your experts as well.
But no, I understand, Your Honor, and I respect everything that Your Honor is saying. I must say, Your Honor, to state the obvious, this is a key aspect of the case, and we've got to be able to proceed through with the question. He covered a lot on his direct and he properly.
And I'm not asking you to curb it. I'm just hoping that we can do it. So I will ask you tomorrow at a certain time to see whether we're able to do it with the 20-minute break and finish.
Fair enough, Your Honor.
Okay.
That would be my answer with that particular point.
Okay. All right. Thank you.
All rise for the court, please.
Thank you, Dr. Welcher.
Thank you, Your Honor. Can I step down?
Oof. Oof. How obnoxious was that? What an obnoxious day, man. Dr. Welcher has been just a whole theme of obnoxiousness all the way since yesterday. So they're clearly arguing about that objection that they took the long sidebar about and then weren't able to come back to, at least right at the time. Now, Mr. Alessi said, okay, we'll come back to this later. And he does say that a lot, though. And I'm not sure if he says that and always means it, or if it's just a way to like transition away. Okay, we're going to stop talking about this right now, but not necessarily come back to it later. But he did say we'll come back to this topic after they had that long sidebar. So he had been asking if he had relied on Trooper Paul's reports. All right, the stream is over, so I'm just going to kill it. And he said, well, it was not important to read it very carefully. He did his own independent analysis because, it might induce confirmation bias if he were to read Trooper Paul's report. And this was all in the context of talking about the Commonwealth's prior theory. Okay, the question had been the Commonwealth had maintained until September of 2024 that all the key cycles of 1164 and 1165 and 1167 occurred while the car was in the custody of the Massachusetts State Police. That's what all of this is arising out of. And so what it seems to be the situation is that she's not convinced that there is a basis for him to opine about the Commonwealth's prior theory. I guess because he says he didn't read it very closely. So get this, guys. Get this. The way it works in Bev's court is that if you choose not to review some of the materials that are provided to you, then you can't be cross-examined about them, period. Whether they're the types of things you should rely on or not, I guess they're just off the table. Not a basis if you didn't actually read them closely. Okay, reading them not carefully, not enough. That's not enough foundation for Bev to say, yes, you can answer questions about what was in that report. If anybody can find some consistency in the judge's rulings when it comes to the basis for the expert's opinion, when they're allowed to rely on hearsay, when they are not allowed to rely on hearsay, when they're allowed to describe it and when they aren't, please share it with me. Please share it with me, because I'm really not seeing it. I'm really not seeing that at all. He made a whole point of talking in the first trial multiple times. You know, spit it out. Oh, I relied on the Karen statements, the Sallyport video, the diagram, the Verizon records, the Jen's testimony, her Celebrite, the summary of the testimony. Okay. Well, I hear say in there. But sometimes it's okay. And sometimes it's not, apparently. And I guess the fact that he said yesterday in his direct examination that he relied on the CARS report is one of the things that he considered. Isn't opening the door to be asked questions about it. Anybody understands why? I sure would love to hear it, because it's not a distinction that I can really make sense of based on what I'm seeing. But, you know, this is a pretty devastating problem as far as the change of theory, because you have to change the theory to get the key cycle count to work, right? There has to be another way to show this, right? Because well, we'd have to go back to Trooper Paul's testimony. I mean, it's the bottom line. We'd have to go back to Trooper Paul's testimony from the first trial. Remember exactly what he said about how he identified his particular key cycle and then worked backwards. But as I recall, it was during his testing. He was able to do that. It's kind of like we saw that readout that Welcher did. It was something similar to that. Or he knew the mileage. He was able to associate it with the mileage. Wouldn't we still have a mileage problem? I don't know. I don't know how that is all going to be reconciled, but that seems to be what's going on. Is she needs more foundation. Judge Bev is requiring more foundation that Trooper Paul looked enough at the CARS report to be asked about it. What's enough? Who knows? We don't know. We don't know. It's in Bev's mind how much is enough before he can be asked questions about it. See, this is why in her mind, allowing a robust cross-examination, she really does think that's a matter of her discretion. She'll allow it or not allow. Why? Because in her mind, there's some degree of attention that must be paid to this report before he can be asked questions about it. So even though he testified on direct, this was part of the basis of what he considered. No questions about that. So they had to go through and establish this overhead image looks the same. Looks the same as the one that went into Trooper Paul's report. The chart, dude. We saw the chart in Trooper Paul's report in Alessi's hand. He had the page turned. It's pointed straight at the camera. We see the freaking chart. It's the same chart that was on your PowerPoint. It's the same chart. I don't care if you use different screenshots of the maps. It's the same chart. It's got the same color, same format, all that. It's the same chart, dude. Then the photo showing the, oh yeah, the mileage, right? Showed the mileage right there. Is that going to be an issue for the key cycle? How many key cycles are at that mileage? Huh. Is that going to be an issue? But yeah, that photo, that's Tr Paul. That's Tr Paul in that photo. Yeah, that's because it came from his report. And then the things that he screenshotted and incorporated from Dr. Scorty Bellows' report. Yeah, he relied on that also. So then Brennan is wanting to make sure the distinction is made that he didn't actually consider her opinion on whether there was a car accident. No, because he wouldn't rely on a person like that. He wouldn't rely on a person like that. A person like what? A person whose job it is to determine cause and manner of death. You wouldn't want to rely on them to determine the cause and manner of death. Why does that not surprise me with this guy? So no, he only considered part of her autopsy. He only considered portions of it. He didn't consider the whole thing. He only considered portions of it. Huh. That sounds a lot like bias, doesn't it? I only looked at parts of it. The stuff that I liked, I considered. The stuff I didn't like, no car accident, undetermined. I didn't consider any of that. Huh. You don't say. You don't say that's what you did. Well, this has been a real struggle of a cross-examination for Mr. Alessi. And I got to tell you guys, yesterday I said I want to keep my expectations low. Because it is a very important part of the case. But you can't expect like home runs every time somebody comes up to the plate. We don't really know what he has to work with in terms of how has ARCA critiqued this. What other data is out there for him to be able to work with this. But I think part of the challenge here is just that this witness is so incredibly argumentative. So incredibly argumentative that you can't establish predicates on which to build any kind of a point. Mr. Alessi has a very Socratic, a very syllogistic style of establishing his points, where we establish this very simple point A, and then we move on to establish other points, and then we're able to tie those all together into a conclusion that, is, if you accept all of these predicates, it's very difficult to argue with the conclusion. So does that with very simple things like the scientific method is this, the scientific method is that, it's this process, it's developing hypotheses and then testing them, and you did the scientific method. Where's your proof of your hypotheses? Oh, there isn't any. He doesn't have to ask the ultimate question of, so that means what you did was unscientific. Because the guy's fighting him at every point anyway. But that's why this, I think, is proving to be so difficult for him, is because the basic foundational information that we should be able to be on the same page about, you can't get this guy to establish it because he's got to quibble over absolutely everything, including whether we are calling the icon on your computer a file or a folder. Critical distinction there. So a lot of nitpicking over stuff that really isn't important. And so that's making it difficult for Mr. Alessi to try to make any progress. And he's trying to work around the witnesses, avoidance. He's trying to kind of cut him off, get him oriented back to the information that Mr. Alessi, find a different way to ask the question or something like that. But it's just not, he's finding something else to argue with, so they're getting very mired down in a lot of what should not take a gazillion years to establish. He did not do the F equals MA force analysis calculation on any part of the body except for the head. It should be that simple. It should be that simple, but no, we had to fight about how it's complicated because you can't necessarily do a force calculation on an appendix. Nobody asked you to do a force calculation on an appendix. That's okay. So then we'll talk about the musculoskeletal system. He interrupts him to say, that's inside the body. Yeah, no shit. No shit, dude. Really? Wow, thank God you came here to testify at this trial and that the Commonwealth has paid you almost $400,000 to tell us that a skeleton is inside a body. Where would we be without this guy? Yes, you can do force calculation on bones. He didn't do it for the right arm. He's done it hundreds of times before for different kinds of accidents. We can do some math if we make some assumptions. We'll argue about the assumptions, of course. A 7-pound hand, we're going to argue about that. That's not a good assumption. So great, we'll just make up a number. The whole arm weighs 12 pounds. Okay, so now we've switched from a hand to an arm because that's what he wanted to do. So the whole arm now weighs 12 pounds. We assume the Lexus is traveling at 20 miles an hour. We assume there's an impact window, meaning the time of contact between the arm and the Lexus is 10 milliseconds. Then we're going to argue about it's a glancing impact versus it's a direct, and what matters is the center of mass. And if it's not directly in line, it's a glancing blow. This is not the question. Okay, this is not the question. You don't have to worry about that at this point. That's not what's being asked. You're being asked to do some math. Just do some math. That's all you're being asked to do. You're not being asked to critique whether this is a good math problem. You can just do the math. Except it was a struggle. We sat there and we waited 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 and we finally got 2,188 pounds. 2,188 pounds from the arm. Arm coming in contact with a Lexus traveling at 20 miles an hour. And that's if you make a triangular crash pulse assumption. What the fuck does that even mean? You think you're helpful to the jury? I'll tell you why he thinks he's helpful to the jury. He really does. He really does. And he actually is, from the standpoint of people that want to hire expert witnesses. Yeah, this guy kind of is killing it. Why? Because his goal is to obfuscate. His goal is to obfuscate the defense points. The defense has points to make. Your job is to get in the way and make that difficult. You know very well what team you're on. You know very well who's buttering your bread. Okay? So he's actually doing a great job by that standpoint, because if the defense has a point to make, he'll throw out something to try to confuse it, like, well, that's a triangular crash pulse assumption. You know perfectly well the jury has no idea what the hell you're talking about, what any of that means. It's just there to confuse. If it mattered, you would explain it, but you didn't do any of that. And so, and then we get clarification on how the assumptions affect the math. If you have a shorter period of contact between the arm and the tail light, then the force would double. Apparently the impact being spread out over time makes a difference in the force that you get. And how much force from the literature to break an arm bone? Well, for distributed loads in a cadaver test, you need 2,500 to 7,000 pounds. Then we got into this distributed load issue. Distributed load. Every freaking contact on a human body is going to be a distributed load, unless you want to define that term a little bit more specifically. Is there a surface area of the human body that you consider a concentrated load versus a distributed one? For that matter, with these cadaver tests, how was the load distributed in these cadaver tests? Was it isolated to a, roughly, I don't know, maybe 6-inch diameter area on the cadaver's arm? Was that kind of testing done? It's not offered to explain, it's offered to obfuscate. And remember, we're talking now about a center mass impact. Did you Alessi's like, did you switch to an angular impact? Did you switch to some other impact? Did you change your math for some reason? To break hand bones with a distributed load, you need over 300 Gs. 300 Gs is not a force. That's an acceleration. It's the wrong part of the equation. You would need 300 Gs with what weight of hand to produce what force? The question is what force, not how fast do you have to accelerate the hand. So he doesn't know from literature, 300 to 600 pounds, more concentrated impact would decrease the force required. It just depends on what you're hitting, making everything quite difficult. We can't just assume we're talking about the SUV. He doesn't deal in possibilities, guys, just in probabilities. He doesn't deal in possibilities. So when he did that paint test, guys, that's not dealing in possibilities. That's probable. Probable. How that configuration and orientation and everything like that all lined up. This was not just a possibility, one possibility out of probably thousands, if not tens of thousands, if not hundreds of thousands of possible configurations of John O'Keefe in relation to a Lexus SUV. Potentially hundreds of thousands of ways that they could have been lined up if there was a collision, as the Commonwealth asserts. And this one you chose is a possibility, dude. It's like the one possibility out of all of those tens, if not hundreds of thousands, where you can make it line up height-wise. That's it. It's all you established is that you can hold your arm in a way to make these things line up. That's what your testing established. So the force required to break the hand, first it depended on the weight of the hand. Now it depends on the loading. Up to 750 Gs to break a bone in the arm. Again, we're back on acceleration, not on force. It's just a mess. It's so confusing. That's the point. That's the point. Some arguments about math that were just entirely unclear. He disagreed that the 2188 pounds was more than it would take to break a hand, but then that's because he went back to an arm and said it would take 3,600 pounds to break the arm. But you switched it from the hand to the arm. He wasn't struck on the hand, he was struck on the arm. And then he goes back to the cadaver test. It would took 2,500 with a distributed load with similar structure to John O'Keefe and even similar Really? Really? I want to see this study. I want to see where they took a cadaver and they bent his arm and they held it out and they backed a car into it at 24 miles an hour. A glancing blow, okay? Not full center of mass, but just one to get him rotating. I want to see the cadaver studies where they did that. I don't even know how this makes sense. And it would take 300 to 400 pounds to break a hand bone. He disagrees because it depends on the loading. If it's distributed over a large surface area, it's different. So he did at least eventually concede that there are probably points on the back of the Lexus that would break the bone, that would be concentrated enough if you made contact with them. Like, yeah, if you got it stuck under the bumper, yeah, or part of the protruding metal pieces at the back, possibly. The whole wiper and the wiper mechanism right there, possibly. Maybe the exhaust pipe. He brings up the exhaust pipe. Because, you guys remember. It wasn't too much later before he was blaming Mr. Alessi for bringing up the exhaust pipe. So, yeah, there's maybe a few places on the back of that car he can find where a fracture of the hand would result. Maybe down by the transition between the body panels. But he didn't do any of that kind of calculation for the arm. So that was a very difficult trying to wade through quicksand that Mr. Alessi dealt with that particular line of questioning, trying to get the witness to do math. It's not gonna work very well. He's going to fight absolutely everything. He's not even going to concede that John O'Keefe didn't have any fractures other than his skull. He's not going to concede that. There's no x-rays. The fact that the medical examiner who performed the autopsy said no fractures doesn't rule out for him that there's a fracture. That's good to know. Because that right hand sure does look like a boxer's fracture, doesn't it? It sure does look an awful lot like a boxer's fracture. And here I've been told that this is a lay term, okay? It doesn't necessarily mean you have to have an actual fracture. It's a common lingo for just a specific type of soft tissue type of inflammation kind of problem that you get when you punch badly. You punch off, your wrist isn't straight, you're not braced, you hit it weird, you hit it at an angle. Those little bones up here, right on the outside, those little bones are very fragile. And they can tear, they can break, they can get inflamed. I mean, things can happen. Boxer's fracture is a lay term, but I've been told all this time, no, it's not that because, Andrea, there's no broken bone in his hand. Huh. Not according to Jud Welcher. Sounds like maybe it's a boxer's fracture then. Huh. So then we moved on to the paint exercise. He didn't like that description. No, it's a test. He's going to quibble. Don't call it an exercise. It's a test. We have to use his parlance. And so he was looking at whether the injury patterns in the right arm are consistent with John being struck by the tail light. That was the quote that Mr. Alessi read from his report about what that blue paint exercise was all about. But he's going to argue with his own report now. He's going to say, no, I wanted to show just the location and the area of the lacerations they matched. It would match up height and orientation wise. But he did other stuff. He looked at the rear pedestrian system. He looked at the warning system. He looked to see if there was automatic braking. Dude, you didn't do that during your blue paint test. Okay? You can stay where we are. You don't have to run off into something else that you did. When that matters, you'll be asked about that. But that's the point. We gotta run off and confuse and conflate. So run away from the blue point test, but Alessi's going to bring you back. No, he didn't do it at 20 miles an hour. He didn't want to hit himself at 20 miles an hour. Yeah, no shit. So not exactly apples to apples, is it? One of the things I think about with a 20 mile an hour is the contact, the loading, and how that's going to work, right? It seems to make sense to me that because the human body is, look at that. Look at how much it moves. It's very elastic. Even your bones will like bend and stuff. You got some give in your bone before it will break. Your body is elastic, and so when you're also like mostly water. So when you're hit by the vehicle, you're going back into the vehicle. The force and the distance with which you do that is going to determine in part, I would think, how much of the paint ends up on your arm. Because if your arm just comes back this much, it's only going to be that. But if it depresses even more, you're going to have a wider area of paint covered. So if the car puts that much paint on him at 2 miles an hour, at 20 miles an hour, isn't that going to look like more of a splatter? I mean, of course, we'll never know. If only we had some testing, some sort of comparison that one might be able to do, like with, for example, I don't know, a crash dummy. But you couldn't do that because that might hurt the Lexus, guys, and you got to resell that Lexus. So you can't possibly do a crash dummy. You wouldn't be able to configure it correctly anyway, because there's so many variables involved with where the feet are located and stuff like that. Let's not think about that for when it comes to positioning your own body behind that car. You didn't seem to have a problem with the fact that you don't know how to position your own body either. Somehow this is only a problem for a crash test dummy? What principle of physics is that based on? That is not clear. That is very, very much not clear. Yeah, you could have just put a crash dummy the same way that you stood there, in the same orientation, and you could have hit it with the car at 20 miles an hour. You could have done that. You didn't. We got this explanation of the travel that is way worse than I thought it was when I was listening to this yesterday. So when we're listening to it yesterday, my understanding was 87 feet is the entire distance, both front and back. And so it meant she went 34 feet forward and then 34 feet backward, and then an additional 20 feet backward. And that's what gets to the 87. That's how I understood it. So only 20 feet past the point where she started. No, 87 is just the distance in reverse. 87 feet is just the distance in reverse. It doesn't include that forward time at all. It's very confusing. So it actually went forward 34 feet and then back 34 feet and then another 53 feet from the point where it originally started. What's the frontage of 34 Fairview? Anybody happen to know that offhand? If only somebody had done like a fancy digital scan where you could have that information down to the millimeter. What's the actual frontage of that property? 53 feet beyond the point, just where she started. I'm pretty sure they're going to have some measurements of some of that. Okay, you got, what's the frontage of the entire property? Then the driveway. Okay, we got to take the driveway out of it. Higgins' Jeep was parked on the mailbox side. Okay, what kinds of distances are we working with here? Seems pretty well within 34 feet or 50 feet. At what point in this does John get hit? There's literally nothing in this data that would show a point where like, ooh, John got hit then. The wheels slipping again, perhaps. But nothing. We just have this reverse. Well, we know intuitively it had to happen like immediately, right? Because for him to end up by the flagpole, he had to be hit on the neighbor's side of the flagpole. If she's backing up towards 34 Fairview, his motion is going to be following that same motion. So he had to be hit on the neighbor's side of 34 Fairview to end up over by the flagpole. But there's nothing in any of this data that shows like a point where we might be able to say, oh, that's where something looks slightly different. That looks unusual. That's not how the data usually operates. So then we talked about the blue numbers, show his math. The 1162 showed some wheel slippage. It's not caused by acceleration. The depression of the accelerator pedal beyond the 30-degree throttle combined with the transition to reverse is, according to him, what caused this trigger to be registered. It seems like a strange thing to register, just out of the blue. It seems like a strange thing to register and not continue to register if the issue is the accelerator throttle being open and being in reverse. It seems odd to not continue to record that when the throttle continues to be open more than the threshold point of 30% and the car is still in reverse. That doesn't make a lot of sense. If only there was an exemplar that testing could have been done on to perhaps clarify why that didn't happen. What exactly is it about this trigger event? Does it recall? Is it triggered by the actual putting it? The car only cares if your throttle is at 30% in reverse. If you put the car in reverse and not if the car is already in reverse. Does that even make sense? Does that make sense, like diagnostically? Wouldn't you want to know if there is like issues requiring you to do a really heavy throttle while in reverse, regardless of whether you just shifted into reverse or you've been in reverse for a while now? I mean, if I'm in reverse and my car's not moving and I'm having to lean on the gas, having to really lean on it, I'm thinking a lot of different things. I'm thinking my brake is stuck. I'm thinking something's wrong with my transmission, something's wrong with my gearbox. Something's wrong, maybe a fuel line is plugged, there's not enough fuel getting in or something like that. I'm thinking about lots of different problems that are going to be associated with my car is not going. I'm having to hit the gas too hard to get my car to move in reverse. It's almost like it's going to be more of a problem, right? If I have the kind of problem, I have a problem, my gearbox is broken, my fuel line is blocked, whatever, the car is not moving after I've shifted it in reverse, I'm going to continue to try, aren't I? And I'm going to keep like doing it over and over. I'm going to hit the gas pedal at least a couple times, to check. Maybe I'll shift the gears again and try. Okay, that didn't fix it. So maybe I'll lean on it a little bit heavier. Maybe I'll check the brakes, make sure I don't have my e-brake on. I never use my e-brake, so it's not that, but I can't say never. I rarely. I know I should, but I don't. I just park it in gear. It seems like a lot of your data is going to be after. It would be after you put it in reverse, and it doesn't work right, and so then you fiddle with it. It just doesn't make sense to me from a diagnostic perspective why this would be like such a limited trigger event that it would not continue to regard it as a trigger when the car is still in reverse and still at the 74% ratio. Don't know. And then Mr. Alessi had that gym. Yes, you can have wheel slippage at any speed or at any acceleration, but you have to look at other data. Just stepping on the gas alone is not necessarily going to cause wheel slippage. And Mr. Alessi asks, do you understand what I mean by correlation? Ooh, knife to the engineer here. Do you understand what I mean by correlation? Yes, we can agree now that hitting the accelerator hard. Oh, but we're going to jump past it. Not just correlated with the wheel spinning. Okay. Not just the hitting the accelerator. Yes, correlates with the wheel spinning in a functional vehicle. That's going to be normal. But it can cause, just hitting the accelerator hard can cause the wheels to spin. So, he made no assumptions about cars parked out front. We went back around with that. F-150. He saw testimony about the Jeep, but the majority of the testimony was there is no other vehicles. Oh, so it's majority rules when it comes to hearsay? Is that the case? Because I think majority rules on the hearsay is that there wasn't an accident here. Looking at the reports, looking at all the data, looking at the testimony. I kind of think the majority consensus is not a good correlate for what is fact and what is not fact. So what do we know? He didn't consider the presence of the Jeep. So testimony that said there was a Jeep there, he would disregard that. He would disregard that in favor of testimony that it was not there. Why? Because if you don't, you have a collision. You're going to have a collision, but it would depend on where you start. Going up on the lawn, it would depend on where you start. Don't mind the fact that nobody has documented any sort of skid, any sort of tracks, any sort of rutting in the yard from a 6,000-pound car going up into the lawn, because it's rock hard anyway, right? It's rock hard. Snow had only just barely started to stick, but it's rock hard. Then we go off on his fantasy journey where he has not only driven this particular Lexus backwards at 12 miles an hour, but he might have done it years ago on a skiing trip. He might have driven 24 miles an hour backward during low light conditions or low visibility conditions, maybe years ago when he went skiing. Oh, no kidding. What? What the hell are you talking about? No, you didn't. No, you didn't. Nobody has just incidentally gone 24 miles an hour backwards in reverse. You did that on purpose if you did that. It wasn't just a thing that happened to you. You did that purposefully if you did that. It's not just an incidental on a ski trip. What even is that? What is that even supposed to mean? Maybe years ago when I went skiing? Oh, nope. He would not agree that it's a reasonable conclusion that the car would have gone up on the lawn. Just possible, but it depends on the starting position. And oh, wait, you don't know the starting position. So actually it could be reasonable depending on the starting position. That seems to be what you're saying. There was that slight leftward turn, remember? So if she is right at the curb, parked right at the curb, kind of like where she was seen by the witnesses that you just mentioned reviewing their testimony, then probably more reasonable she'd end up in the yard, like you said. Like you said, if she was more out in the middle of the street, like where nobody saw her, then less likely she'd end up in the yard. So, what's reasonable depends on starting position, but we will only selectively entertain the information that we have about the starting position. Okay. But it's possible because everything is possible. Everything is possible, says the engineer. Everything is possible, says the engineer. Did you know that sometimes F does not equal MA? Sometimes it doesn't, because anything is possible. It's possible that this car would have shot off into space. As an engineer, that's possible. That tells me everything I need to know about this guy's testimony. Okay, if you think that's possible as an engineer, you got problems as an engineer. If you think that's possible as a philosopher, I might buy it. But as an engineer, it's very distinctly not possible. And you can actually say that because you can actually look at the laws of physics, the laws of gravity, the engineering of this particular car, the capabilities, how it moves. And you can actually say definitively with 100% certainty? With certainty to within at least probably one standard deviation that the car did not, in fact, shoot off into space, nor could it, nor would it ever. You can actually do that as an engineer. It's like one of the few disciplines where you can be extremely certain about what you're talking about. It's absolutely wild to me. Possible it could have been shot off into space as an engineer. I think you have confused engineering with some form of sophistry. So let's get back to reality, Mr. Alessi says. Yes, indeed, let's. He cannot rule out the vehicle going up on the lawn. Then we go into the orientation of the injuries. This is something we pointed out yesterday when we heard his direct examination. We talked about this. I screenshotted the photo so I could pull it up and share it. Do I still have it? Yeah, look at that. I still do. Let's go ahead and just look at it again. Because why not? Why not go ahead and look at it again? Make sure I'm in the right place. Okay, there I am. Arm curved, arm straight. And so see, the problem here is that the wounds are all running in the same direction on the straight arm. But when you bend the arm, if they all run in the same direction, that means these ones should be running more down the arm. That's how you get a parallel pattern between the forearm and the bicep with the same motion pattern. We talked about this yesterday, literally looked at his own photo to bring this up. But no, that's not what he sees is exactly what he would expect. I mean, just look at it. Look at the photos. Look at the arm. Yeah, I am looking exactly at the arm and seeing that this one is at a 90-degree angle, whereas this one is straight. So they should not have the same pattern of injury on them. That's what I see. If John O'Keefe's arm was bent and these injuries follow the same pattern, then they are running lengthwise along his forearm. Everybody see that? This is not rocket science, guys. That one is not a difficult one to follow. But Dr. Welcher doesn't agree with that at all. The injuries he would expect are coincidentally the exact injuries that he happens to see on John. So then I think Alessi is starting to get frustrated. I mean, he's been frustrated for most of the day. But it's kind of getting pretty bad. So how long would the taillight have to be in contact? The taillight would have to break the arm, and then the arm would have to maintain some contact with the taillight while this motion is happening to produce that injury. And yes, that's what happens during a pedestrian collision. We didn't ask you if that's what happens during a pedestrian collision. We asked you about this particular mechanism. There would be contact between the arm and the taillight throughout the movement. Asked him how long there would need to be contact. Well, we don't have enough. We don't have enough information. We don't know. I'm not sure what else you need. You need the speed. You have a range of speeds. Why don't you go ahead and calculate it from the slowest possible, 13 miles an hour point of your trigger, and the 24 miles an hour high end point of your trigger? Go ahead and just calculate for both of those. How long would the arm have to stay in contact with the taillight in order to produce a laceration of this length? If that's your explanation of how these injuries were caused. Why? Because there's no blood on the taillight. That's why the contact matters. There's no blood on the taillight. Not a single one of those taillight pieces or the taillight itself, not a single one had blood. Oh, but it had DNA. It did. What about the other two guys? What about the other two guys in the DNA? We're just going to not consider that. It's important when it's John's DNA, but when it's not John's DNA, it doesn't matter. It doesn't matter. So I think part of why Mr. Alessi may be getting frustrated is because, he is certainly showing confirmation bias. At least I'm seeing it. Is the jury seeing it is maybe a harder question. And that's why he's having to try to lean in and kind of make it more explicit. And of course, the witness is never going to say, yes, you're right, Mr. Alessi, this is confirmation bias. You're never going to get that answer. There's no point really in answering that, in asking that question at all. Unless the denial doesn't matter. You already know he's going to deny it. You can take that to the bank. So I think that's just a sign of getting frustrated and not sure that it is actually being demonstrated that confirmation bias is taking place here. But I think if you have followed this and kind of understand what he's talking about, you see that. You see that that's what happens, that he ignores what he doesn't want to think about, and he highlights what he does. And that's pretty much the classic definition of confirmation bias. But no, it wasn't that. It was just matching the contact pattern to the injuries. And it was done to test the hypothesis that the tail light is what caused the injuries. It was done to test the hypothesis that the tail light caused the injuries. So under this one limited set of parameters, without taking into account other data like should there be blood, should there be other injuries, et cetera, but just based on this one set of parameters, if we stand in this way, hold the arm in this way, there can be contact between those two things. Quite a different test. Like, okay, you haven't ruled out that the taillight caused the injuries. What might cause you to rule out that the taillight caused the injuries? Well, things like there's no blood on the taillight. Just little things like that. Little things like if this collision actually happened the way that he described it, would there not be other injuries, such as, for example, major lacerations to John's hand from the glass that, according to you, he was holding and that broke? How'd the glass end up over there on the grass, too, by the way? How'd that happen? He hold on to that glass the whole time his arm got hit. Is that how that works? Ah, it's not confirmation bias. It's just matching the contact pattern to the injuries, except it's not. All you literally showed is that if you bend your arm a certain way and stand a certain way, you can make it match the height of the tail light. That's what you showed with your test. But no, he considered all kinds of different configurations, all kinds of different hypotheses. Also, he didn't write about it, but he did a bunch of tests, such as for rear braking that's not autonomous. So he ruled out the possibility. He tested the steering, the transmission. Nobody asked about any of that. Just asked you for the alternative hypotheses for the sources of John's injuries that you considered. Did you consider, for example, it wasn't a collision? Did you consider that? And how did you rule that out? How did you rule out the possibility that this was not a collision? Curious about that. So he just followed where the evidence led, guys. No confirmation bias at all. Not on this guy. So that's where we ended the testimony for today. Then we moved on to this voir dire. I already kind of recapped that. Establishing he did, in fact, rely at least somewhat on Trooper Paul's report. He pulled things from it. He incorporated them into his own slides. Same with Dr. Scorty Bello and her autopsy report. This is because Bev seems to have limited questioning about those subjects, because him saying he reviewed those things and relied on them as part of his analysis in his direct examination is not enough, apparently, to prove that he reviewed them and relied on them in the course of his analysis. As long as he disclaims and says, I didn't pay very close attention to it, then we don't get to ask questions about it in Bev's court. Seems to be the issue. So they're going to argue it tomorrow. And then we're going to have a half day. We're going to finish early. And it sounds like that's because of a jury. A juror has an appointment. Frustrating day. So they're going to have a night to recap. Go over what was working here and what was not working here. My sense, I'm just going to throw this out here. And I like to be a problem solver. I like to try to problem solve. People have a lot of different, as we've talked about many times, strategies, approaches, persona to use in a courtroom. And sometimes if one's not working, it might be helpful to shift. So we saw that with Alan Jackson, with the cross-examination of Jen McCabe. As soon as he switched to pin her down, cut the ring, keep her in the corner, but do you deny it? He made so much better progress with his cross-examination. So I'm just going to put out there that my read on this guy and on this witness and on what Mr. Alessi is trying to accomplish here, it could perhaps benefit from a little more mockery. See, this guy is super self-important, very self-important, and quite touchy. He's real sensitive, like kind of reading a little insecure, maybe. You don't rely on those people. No, those people that completed medical degree in like a 6-year internship to become a forensic pathologist who's looked at thousands of corpses from different circumstances and determined cause and manner of death. That person? No, talk to me, my biomedical guy. I didn't do medicine. Oh yeah, he's got some daddy issues with the doctor degree, huh? And he went into biomedical engineering instead. Maybe there's a little sensitivity about the doctors because of that. Well, anyway, this guy is very self-important. And so if you can mock him a little bit, obviously, there's a way to do it. You can't just be like, geez, you sound like a dumbass. No, it's again, you show, don't tell. You show, don't tell. And so part of what you can do is you can ask him, just structure your questions in a way where the wrong answer is evidently ridiculous. It is evidently ridiculous. So that then when he fights with you about it, you can emphasize how ridiculous it is. Might work a little bit with this guy. I don't know. That's one of the things I would be thinking about if I were going back to the hotel room tonight to retool my cross-examination, to kind of war room what I've been doing today, what worked, what didn't work. I might start thinking about how I can get a little less annoyed and a little more amused. A little more amused. It's funny when people say ridiculous shit. It's funny. And then we laugh at it. And if I can get the jury laughing with me, I'm going to feel pretty good. Especially if I can get the jury laughing with me at this guy. He's not going to like that. He's not going to like that at all. So that's just what I might be thinking. How can we emphasize the ridiculousness of some of these positions that he's taking? This need to argue. Simplify the question, perhaps. You know, he likes to offer this commentary on the question instead of answering it. Well, that was 2 questions, not 1. Nobody asked you for your sentence chart. But he likes to comment on it. Simplify. Simplify. Single proposition at a time, build it very slowly. It's fine. And so then if he contradicts it, really? Huh. That seems a little ridiculous. He has actually pulled this off. He's pulled that off before. The little incredulity with a question. Are you saying it's your testimony that he's got that speed? He's got that gear. So I just might be looking at how can we highlight that so that Alessi can stay on top, just energy-wise. Energy-wise. You get mad, you get frustrated. It looks more like, you know, you're getting your ass handed to you. You get mad. But if it's funny, and you're mocking that guy, and we're all kind of mocking that guy, yeah, you're winning. You're winning in that situation. So just a thing I might be thinking about. Well, I see oh, I still have my banner up, huh? I've been really bad with the banners today. It's just been a tech issue kind of day. I see that somebody has volunteered that it is 67 feet from the bushes to the driveway, which is 93 from the neighbor's side. I think the property line to the far side of the driveway. So from 67 feet from the bushes on the property line over to the driveway. Then we have the Jeep. How long is the Jeep? How long is a Jeep Wrangler? 188.4 inches. I can't do math in my head very well, so I got to do that. And it's it's about 15 and a half feet. About 15 and a half feet long. So lo and behold, that takes us down to about 51 feet from the bushes to the front of Higgins's Jeep. Sounds like that's room for a collision to happen if that Jeep is there, where that very honest and sincere, who never lies, Jen McCabe, told us it was. Oh, yeah. And the plow. I didn't even think about the plow. You're absolutely right. There's a plow at the front of it. The plow is probably adding another, 3-4 feet. So maybe 20 feet. Yep. Excellent point there. Well, guys, Let's see what you guys have been thinking while all this is going on. Bird, have you seen the Commonwealth's new motion? Hank is big mad. Alessi did his research on Burgess. Pathetic. So I just saw that it had been filed. I haven't read through everything yet, but I do have the one that he filed about Burgess. I can go ahead and pull this up and share it because it is kind of funny. Oops. Where am I? Okay, here I am. Let me go ahead and pull that up. That's not it. Here we go. Motion to preclude the attempted use of any information not produced in violation of Rule 14. Oh, he is big mad. Both the Commonwealth and defense are bound by Rule 14 obligations. During the course of this trial, notably during Shannon Burgess's testimony, the defense presented documents that were not previously provided, which eliminated the ability to review and vet the documents. How dare they? How dare they not produce their rebuttal evidence in advance so that the Commonwealth can work around it? How dare they? How dare they respond to what the witness is saying and doing on the stand? How dare they? Notably, the defense presented a CV provided in 2023 that noted a graduation date of 2024. The effort of providing documents as a witness is being confronted with... Wait, what? What is the sentence? The effort, does he mean the effect? No, that doesn't work either. I don't know what this sentence is trying to say. The effort of providing documents as a witness is being confronted with documents is improper, trial by ambush, a violation of Rule 14, and creates needless delay, resulting in objections, unnecessary sidebars, and a waste of time for the jury. I'm not sure that if we look back over the past few days, the sidebars and the objections and the wasting of the jury's time is related to Shannon Burgess's 2023 CV. Don't really recall there was much to argue about that at all. Commonwealth seeks a ruling precluding the use of any materials that were not noticed by the defense other than materials in the witness's CV referred to during presentation or discussed during testimony. So you're not allowed to do any additional investigation. That is the general gist of the motion. If he lies on the stand, you are not allowed to go bring in the documents to prove it because you have not disclosed them in advance. That's what the Commonwealth is arguing here. Maybe we'll get argument tomorrow. Maybe we won't. There is, it looks like one other motion too that has been filed. I have not looked at this one at all. It's the trial memorandum on expert opinions. So maybe we'll look at this tomorrow before court gets started. We'll see what else is going on. But I want to take a look at that and see what it's all about because I don't know if it's even anything worth looking at or not. So AP, I said always. I retract that always. Okay, for the Lexus 570, our gear is 3.785. First gear is 4.795, respectively, for gear ratios. 4.7 is a little giddy up. That's a little giddy up on that gear. So it's not quite as tall as the first gear, but it's still pretty good. 3.785. Not bad. Sweet Lorraine, he had bilateral pneumothorax, fractured ribs. That's what I saw. That's what I saw. Correct me if I'm wrong, but is the bilateral pneumothorax not collapsed lungs? Pretty sure that's collapsed lungs. I could be wrong. But this was the guy in LA and the injuries that he had. He had 2 collapsed lungs. That's how I understood it, not being a medical doctor or anything like that. So that's what it said. The Marilyn Manson cases, he comes off like a real douche on my end. I wonder how the jury will take that. The douchey, it like emanates from him. It's some of it is just in the handling and the you know, that's where I was getting that Phil Hartman vibe from yesterday when you guys are all yelling at me. No, it's Dana Carvey who does a chop and broccoli. I'm not talking about Dana Carvey in that skit. I'm talking about the guy who's listening to the music and he's got the vibe. He's feeling it, man. That was Phil Hartman. That's the vibe. That's the vibe. That's the douchey vibe, like that douchey jazz listening guy. That's the vibe we're all getting from this guy on the stand with his, you know, his careful skepticism and kind of pursed lips and all of that kind of thing. That's the vibe I get. I have no idea how the jury is reading it. Maybe the jury thinks he seems like a very reasonable and educated man, and he's being so patient with all these ridiculous questions. We don't actually know. Sandra, is Alessi going to show that they received a huge payment when they changed their data/report? Boy, I don't know. He didn't get there. He didn't get there, but they did change that contract, didn't they? April 5th. So that was before, at least before Shannon Burgess changed his report. So it wouldn't have been in response to that, but might they have anticipated it? Who knows? Who knows? Duncan, Idaho, would you have objected to a reasonable degree of engineering certainty? Is that a common phrase in trials? Not anywhere where I have practiced. There's no magic words that you need to use to introduce an expert opinion. Whether the opinion meets the standards for admissibility in any particular jurisdiction is a legal determination that the judge makes. You don't magically make it qualified because you invoke these words. But that's not how it seems to be in Bev's court. In Bev's court, it seems to be you have to invoke these words. And I remember this coming up because it was an issue that Hank took with Dr. Russell's testimony, because Dr. Russell didn't testify to a reasonable degree of medical certainty about her conclusions. She didn't use the magic words. And so we had to voir dire Dr. Russell, apparently. There's no magic invocation. Reasonable degree of scientific certainty seems to be like the general standard that Massachusetts applies. If a expert opinion is going to be admitted. And so then that's going to be broken down by discipline. If you're an engineer, is this, would reasonable engineers reach the same conclusion? This is more or less what you're getting at. If you're a pathologist, would reasonable pathologists reach the same conclusion? Reasonable degree of certainty considering the field that you're operating in. The thing, what is a reasonable degree of certainty anyway? It's such a, this is where the intersection between law and science is really bad sometimes because reasonable degree of scientific certainty is not a scientific principle. Reasonableness is not scientific whatsoever. That was pretty extreme what I just said. So now I instantly have to go into my head and think, are there any ways that reasonableness as a question could be a scientific question? Guess it depends on your view of like psychology and cognition and hard science, soft science, that kind of thing. Maybe. I don't know. It's not a scientific concept at all. They don't define your conclusions in terms of reasonableness. We define it in terms of, propositions and with error rates and with, to within however many standard deviations. Like we account for the possibility that we're wrong when we give the answer to a scientific question. It's not about reasonableness. So, you're already far afield from what makes sense by the time you're getting into this kind of lingo anyway. This is the court's standard. Doesn't necessarily make a lot of sense if you're a scientist. I had to think about this. Okay, Kant did the critique of pure reason, but that's not really talking about what's reasonable. It's just talking about cognitive processes. Anyway, no. So no, from my perspective, this is not at all a common phrase in trial. It's limited to Judge Bev's court. It seems to have something to do with the standard for admissibility of an expert opinion in Massachusetts. But it's just conclusory for the expert to be saying that that's what it is. What expert is ever going to say, here's my opinion, but it's not reasonable? I mean, come on. You don't make it so just by saying it. The opinion should have been vetted ahead of time, either by the court, if there's no dispute, or if there's a dispute, like between the experts, the defense expert says that's not reasonable, then we go and we have the Daubert-Lanigan hearing, and the court adjudicates, is this reasonable or not? It's not something that you just establish by the witness testifying to. So all of this strikes me as bizarre and archaic, and just honestly not really proper. It's it's not bad. It's not good science. Sentient Dreamer, chat reminds me how fun, smart we are collectively. I couldn't agree with that more. I enjoy this chat so much. Really appreciate all the fun and insightful and hilarious things that people have to say. Cogito ergo sum. Hi, Andrea. I saw a post on X today about Welcher being excluded from testifying in a civil case in April 2022. Carol Cavey versus Christopher Simmons. Thanks. So I saw this come up on X as well. I don't have the whole document is looks like it's a little bit long. But I did see that, so I will take a look at that. I have it bookmarked so I can come back and check that out. See what that has to say, because I'm intrigued about that. I do wonder if Alessi's going to be able to bring that up. You couldn't bring up the Maryland case with Jessica Hyde. It wasn't close enough to what was not reliable. Don't know if that's going to be an issue in this case either. D. Pat, has the Commonwealth ever paid someone $350,000 to say something they didn't want them to say? Yeah, Proctor. They paid Proctor a lot more than that to say a lot of shit they wish he hadn't. D. Pat, why do we not have GPS data from Karen's cell phone showing exact times and routes and exactly when and where and when she was at specific locations? Inquiring minds want to know, D. Pat. I would love to know that too. They should have at least some limited data from her phone, right? We already know from the first trial, Tully went and got her CDRs from the phone company to try to retrace some of her location data. Worked at it from the back end, from the tower end, instead of from the phone end. So we know they have at least that, but haven't heard about that, being of use in this trial at all, as far as narrowing routes and times and so forth. Why is there no data from her phone? I don't know. I honestly, it probably came up in the first trial. And I just don't remember. But it seems like, yeah, it should be there. So why is it not? I don't know. I might have to try to dig into this more and see if I can get you an answer. Rotorman Dan, key cycles equals the Commonwealth crux. The key cycles are really what this case live and die on for the Commonwealth. It lives and dies on the key cycle, supporting what they're saying, and the key cycle being the right key cycle. So if it's not the right key cycle, I think they got a problem. Everage, if you see a SUV speeding into you, wouldn't you push your arms out instinctively? And if you turn to get out of the way, wouldn't you land on your face? Yeah, that's kind of what I was thinking too. I was thinking about these movements, the movement patterns and the knock and the turn away. And yeah, just how exactly this is going to happen. Apparently anything is possible, so why limit ourselves to the human frame, the Earth's gravity? Why limit ourselves? It could be anything, guys. Anything could have caused John to end up in that position he was in with the skull fracture and so forth. I mean, I have so many problems with this. It seems like, yes, you would land on your face. You have to do like a full rotation to end up landing on your back. That's going to take time. How much time do we have when you're getting slammed backwards but only clipped, but clipped at a slam? Enough to throw you back, get you out of the way, knock you out of the way. But not so fast that it knocks you straight to the ground. You have time to spin around all the way and then fall back hard enough to crack your skull. And also, did he get knocked out of the shoe or not? I've lost track at this point of what the theory is. Rotorman Dan, you can watch the video of when they load up the SUV. That was the Key Cycle 1162 they claim killed John, was a tow truck driver loading a vehicle in deep snow. We certainly see a 3-point turn on that video, don't we? And I don't know when they started the car versus when they loaded it. I don't know when they turned off the car versus when they loaded it. I don't know how those time frames add up. We don't have the entire time people were handling the car on the video, as far as I know. The video just starts when the car is already backing up. So we don't know when the car was turned on. I don't know if it was 1162 or not. I have no idea when it was. I'm not convinced any of this has really been established. I think it's possible, but I don't see that the burden of proof as to what key cycle is what has been met. Plain Whisperer, John O'Keefe, no hat or coat, blowing wind, very cold wind chill flurries. I'd have my head tucked down back into my chin, shoulders hunched over when I got out of the car in those conditions. Yeah, you would be, I would think you'd be hunched against the cold. Your natural is to like curl in, you keep your internals warm, you keep the wind off your ears or whatever. Maybe I'd have my hoodie up. In fact, I'd almost certainly have my hoodie up if I'm standing outside in the snow, in the wind, blizzard starting to pick up. This makes sense to me. I accept your posture. Makes sense to me. Law and Order, any real grounds for JB to exclude key cycle info? Like I said, she seems to be grounding this in foundation, but it's also not clear what she thinks an adequate foundation is. This is all getting to, for purposes of this cross, we're dealing with his reliance on Trooper Paul's report. And so he differed from Trooper Paul. Not clear to Judge Bev that he paid enough attention to Trooper Paul for that to be significant to ask him questions about. That's the best interpretation I can give you of what's going on. Why Mr. Alessi is not being allowed to ask these particular questions about how his analysis differs from Trooper Paul's analysis. But as we've talked about, there is often more than one way to skin a cat. There are often many routes to get to the same outcome. The problem with Trooper Paul's report is that Trooper Paul's report is hearsay. And so apparently sometimes the expert gets to rely on hearsay and sometimes they don't. And again, the consistency on that standard is not quite clear to me at all. We looked at the rule, I think last week, and the rule seemed to say that the opinion itself isn't supposed to be based on hearsay. And yet they are. And then they talk about it, but then we can't cross them about it. It's very strange how this gets interpreted and applied in this courtroom from my perspective. But there's many ways to get to the same outcome. And the way to get around the hearsay problem is you put Trooper Paul on the stand when it's your case, and then you ask him about what he did when he was in charge of the investigation for 2.5 years. And you don't have to ask Welcher about it. You will simply have demonstrated this is what the Commonwealth's opinion was for 2.5 years. Then this guy came along and he came up with a different theory. And by the way, they paid him a lot of money to come up with that theory. You can tie those pieces together in argument. So you don't have to get this only through Welcher. Just put Trooper Paul on the stand. That'll get it back on the table. Kimberly Wurst, Alessi blocked asking further about the key cycles, at least temporarily. So sounds like they're gonna deal with it tomorrow at some point. See if he gets to ask those questions again based on the voir dire to establish the foundation of Jud Welcher's knowledge, familiarity, reliance on Trooper Paul, whatever the hangup is that Judge Bev seems to have. Robin Hall, discussing the weight of John O'Keefe's head gives me Gavin from Kids in the Hall vibes. If my head was veal, how much would it be worth? Oh man, I haven't thought about Kids in a Hall in 100 billion years. Man. Weight of the head. It is kind of a weird thing to be talking about, but I guess it does matter. Nick TTT, if a crash reconstructionist takes the defendant's statements as part of their analysis, how do they choose what statements are true? She also said she didn't hit him. Case closed? Seems anti-science. You noticed. Indeed, you noticed. Yeah. Yeah. So this is something that there's a decent amount of literature on this like sort of topic, related topic, when it comes to like false accusations, confabulations, people with false memories, recovered memories, all of that type of thing. Because when somebody just says something, there's nothing about the content of what they say, the way in which they remember it, the words that they use to describe it. There's no formula that you can point to be like, oh, this one is fake and this one is real. So there's like, I'm pretty sure it's in like one of the professional guidelines. I don't remember. It's the American Psychological Association. I kind of think it is like some paper, some guideline that they have on evaluating false memories. The only way to know is to objectively verify with extrinsic information. You cannot rely on what people say, even in soft sciences like psychology. You cannot rely on what people say. I would be willing to bet that most psychologists would probably agree that what a person says is simply a piece of information that may tell you little to nothing about objective reality. It tells you nothing more than what that person perceives, what their motives are, what is what they calculate they might gain from saying this. Those are the types of things that words tell you. But words and objective reality don't necessarily have a lot in common with each other. So words are terrible evidence from a scientific standpoint. Words are absolutely terrible evidence because you always need objective information to verify the words. You can't just take words in a vacuum and know if they're true or not. TCP, I think he was trying to say trip as in mileage in trip computer. I don't know if he was or not. He got in that semantic battle about the how the infotainment system and the text stream data, they don't like inherently correspond, because you have to like if we define the trip as the ignition cycle 1162, that ignition cycle, then yes, those are always going to line up. But the point is that if we define the trip as this period of time recorded by the infotainment system, okay, the car was being turned on and operated during this time period, and that's the trip, then that is not always going to correspond with the trigger event. You're going to have to figure out which trigger event lines up with which trip. Seems like a pretty simple point, but he got in this whole semantic argument. Why? Because he's not there to help make it easy for the defense's position to be understood. He's there to fight and make it very difficult. He's there to make it as complicated and confusing as possible when it's the defense's turn. This is all going according to plan for this witness and for the Commonwealth. So yeah, perhaps he was. And that's where, again, simplifying simplifying things so that you can maybe get a little bit of mockery, a little bit of humor, a little bit of, wow, isn't this ridiculous kind of vibe out of his struggling with it. So just define the term. He wants to argue about trip. If we define the trip as the measurement of time recorded by the infotainment system when the car is powered on and then powered off, if we define the trip as that, then the trip doesn't always correspond with the key cycle. No, you have to figure out which trip corresponds with which key cycle. You have to figure that out. Just possible. I'm not saying he wouldn't find a way to argue with that too. Okay, he might. But the simpler you make it with a guy like this, the less opportunity he's going to have to wiggle. And then if he does wiggle, if you can, build your blocks very incrementally, then he looks ridiculous when he wiggles. Edward Kirkpatrick, there is also a huge problem with car growth and changing heights of truck hoods and tailgates. It has gone crazy in the last 20 years. 1979 data is insane. Yeah, the whole big truck phenomenon. They didn't have Hummers in 1979. They didn't have that. It is an issue. The whole like big lifted truck, it means, yeah, you're going to be hitting people more above the center of mass, meaning you're going to knock them down where they will bash their head into the concrete and then, go under the wheels. You're going to have more of those types of injury patterns than the one where you hit them below the center of mass and then they get projected up onto the hood and up over the windshield and they roll and they tumble and so on and so forth. So it's not apples to apples. A lot has changed since 1979. Doesn't necessarily seem all that reasonable to me to be relying on, epidemic style information from almost 50 years ago, guys, almost 50 years ago. I can tell you personally that almost 50 years ago, lots of things were a lot different. Whatever, clever. In recent motor vehicle accident civil case, Welcher and associate used junk science, bad math, etc., and both were excluded. I posted motion on X and tagged you. Thank you so much for that. I did see it. So I'm sure I have your tag in my notifications as well, but I found it and I have it bookmarked so I can come back and look at that. That is intriguing and I am interested in seeing more about that. Riri 911, can HB coach witnesses during breaks? Appreciate you. No. In fact, we had to have a specific motion in limine by the defense that you're not allowed to talk to the witnesses in between the time that they get on the stand and when they finish, because they had that little problem with, was it Brian Albert or Brian Higgins who had a little chat with Lally during one of the breaks in the evidence? And you're not supposed to do that. Once you're on the stand, you belong to the court. You do not belong to the parties. You do not get to be coached anymore. It's go time now. So no, they're not only not allowed, there's a specific order that says that they're not allowed, that the defense had to go and get because the Commonwealth ignored that during the first trial. Greg S., impossible to put auto in reverse whilst moving forward. Yeah, I mean, I buy this. I was thinking through this in my head. I don't know if it just doesn't shift. I don't know if it grinds, I don't know. But yes, it makes sense to me that you can't go instantly from drive into reverse because it's gonna break your transmission. It's gonna grind your gearbox. It's gonna affect, your engine compression is gonna explode. You're going to probably have your motor jump out of the hood onto the pavement. I mean, it's just going to be a very, very bad scene. So yeah, I'd expect there's probably a lot of things in place to prevent you from being able to do that. Doesn't make a lot of sense to me. Luis Ree, 3,600 RPM forward and slam into reverse equals broke it. Yeah, something broke. Something broke doing that. Sandra M., thank you for loving Chile. Oh, well, thank you, Chile, for being so incredibly lovable. Do you think Alessi needs to just get to the facts because this guy is so difficult? I worry the jury is getting annoyed at the defense. Yeah, he is struggling. This has been a struggle today. The guy is too argumentative. He won't accept very simple propositions. He's going to quibble over everything. He's going to bring up stuff that nobody's asking about. He is here to obfuscate. He's here to make it confusing. So you just got to give him as little ammunition as possible. You know, give him as little as possible that you can quibble with that he can make confusing. And then his routine just becomes more clear. If you're asking a very simple question and he wants to talk about, you know, other things, and you can just redirect him to the same simple question over and over. Mr. Welcher, I don't mean to be rude, but do you have a hearing problem? Because I've asked this question now 4 times and you seem to have difficulty answering it. No, you can't actually say that, but I might be tempted. Under the right circumstances, I might be tempted. Yeah, I think there is a risk that it seems like it's the defense's fault that this is going so poorly. It's not yielding really fruitful information because the whole thing is such a struggle. I think, you know, simplification and look for the opportunities to mock this guy. I feel like that's the key. That's the key tweak. If Mr. Alessi is coming back into my corner during this break in the action before we send him back out for the next round, I might be telling him, hey, look for openings on the mockery. He's really open for the mockery when he does this and that. So you just set it up with the simple question, the things that are basic, that no reasonable person that would argue with, and then he's going to argue with it, and then you can laugh at him, dude, and then you've won. I might be telling him something like that in the corner. Karen, isn't pulling out of a space in a parking lot similar to a 3-point turn? Been bothered by key cycles since Trooper Paul. Jud made it clear as mud. Yeah, I would think pulling out of a space in a parking lot would be similar to a 3-point turn. The main difference is that I guess, you know, when I think about it now, okay, a 3-point turn, yeah, because it's always like a 90 degree. It's just where did you start? You know, like the one on Cedar Crest, she's going the opposite direction, you know, so the 3-point turn starts with the nose in, and just in the parking spot, you've already done that part of the maneuver. You've already gotten your nose in, so you're kind of like doing the end of the 3-point turn. Yeah, it's the same motion. It's the same motion. You're backing up until your front wheelbase is, you know, at the end of whatever it is you're trying to back around. Then you turn your wheels, then you back around it, and off you go. It's the same motion for both things. Joshua Frost, impact window applies to something in physics referred to as impulse, which is essentially how quickly force is transferred and affects acceleration. Thank you for this. I love knowing these kinds of details. I had no idea what he was talking about. I think that was the point. He didn't want me to know what he was talking about. He just wanted me to know that he's using, you know, he's got technical ideas and words behind what he says. He doesn't necessarily want me to understand them. He just wants me to know that they're there. So definitely didn't get this from him. But that makes sense to me. That makes sense to me because yeah, how quickly force is transferred. This sounds like this is getting into that example I've been using of making impact with the the room full of styrofoam peanuts versus making impact with the concrete surface. There's going to be a longer impulse because the period that I'm in contact with the styrofoam peanuts is going to be, you know, longer, I guess, than it is when I instantaneously hit the concrete and the concrete has no give and all that. So this kind of helps tie those pieces together. I'm still not visualizing the math problem, but I'm not very good at visualizing math problems when we get into semi-algebraic kinds of things like like Mr. Alessi is telling me we're dealing with. Info nerds, how do you control the urge to want to scream at this guy? What an ass. Lawyers are a special breed. Thank you for your coverage. You keep me sane. I'm just going to tell you right now, it's the same. And this goes back to my little corner talk that I'm having with Mr. Alessi. This applies to pretty much any difficult stimulus that you deal with in your life. You get to choose your response. You get to choose your response. And this is not to say that if like somebody comes and abuses you, that you're like responsible for, you know, behaving perfectly or anything like that. This is not at all the kind of argument that I'm saying. I am simply saying you get to choose your attitude about pretty much everything. Okay. Viktor Frankl wrote a very, very influential book about this very subject. You get to choose your attitude in any circumstance. And so whether you're dealing with an obnoxious guy in a courtroom, whether you're dealing with an internet troll, whether you're dealing with, you know, a mother-in-law who hates you, you get to choose your attitude towards that. And so, yeah, you can choose to get angry and to lean into that. And then you'll want to scream and you'll feel so very frustrated, and it will be tiring, and your breathing patterns will change, and you'll have these kinds of, you know, physiological responses. And it won't be a lot of fun. But you can also find it funny. You can also choose to see the ridiculous side of it, because it often is. You know, internet trolls often just extremely ridiculous. The mother-in-law, like I swear, if my mother-in-law was wonderful, one of the sweetest women you would ever want to meet. But if she had said something like that to me in the hospital, why'd you just leave him there? Because he's a grown-ass adult, ma'am. I don't think I'd be able to help myself but to laugh in that woman's face. Because he's a grown-ass man who wanted to go to a party. That's why I left him there. Duh. There's nothing that a good duh won't make you feel better about. So, I mean, to answer your question for me personally, you know, you don't get mad, find the humor in it, but then you get even. So that's what I'm going to try to do with this particular expert. And that's what my strategy is going to be geared towards. Kurt B, Google heard you by chance and agreed with us. It was polycarbonate lenses, braking force, consistent with being struck by an SUV, making contact with the. Well, glad to know Google had something to say. Don't know where this ends up, but is this getting into Newton's third law, equal and opposite reaction? If the polycarbonate hits me with certain force, I am hitting the polycarbonate with the same force, that kind of thing. Brian Bryson, what hasn't the defense brought up that the Commonwealth theory has John standing looking into an empty street, not turning his head to look at the SUV revving the RPMs and speeding at him? I guess she drives off. I mean, I don't know how he ends up in this position. I really don't. I don't know how he ends up in this position, and he's in this position while she's accelerating towards him for at least several seconds. I will grant alcohol's a factor in here. It slows reaction times and stuff like that. So you're not going to hear and process and register and react nearly as quickly when you're drunk as when you're completely sober. But it also doesn't mean that you're in like a bubble. You know, it doesn't mean that you're completely unable to perform those functions. They're just a little bit slower. So the registering that the car is backing up for several seconds, and then the reacting, you know, to that, seems like that would be well within, you know, your reaction time, even while drunk, would be well within the several seconds that she was backing up. So his posture doesn't necessarily make sense from a common sense standpoint, but then we haven't even established why is he in the road. Okay. We're pretty sure he's in the road because we have no tire tracks, no ruts, nothing like that in the grass. So if he's not in the grass, but he's hit by the car, then he's hitting the road. And we don't have an explanation for why he's even in the road. Why is he even in the road? If you pull up to the curb and you open the passenger door, you get out, aren't you right there on the lawn? Why would you get out and go into the road? It doesn't make sense from a practical standpoint. There's a lot of pieces that when you start and put them together, it doesn't sound like a story of things people do in real life. It just sounds like selected pieces of information that make it fit, but if we have to like make that realistic, it becomes a lot more problematic. Why is he in this posture? All that. Law and Order, he just launched the Commonwealth case into orbit. LOL with the car being launched into orbit. Anything is possible as an engineer, apparently. Even cars, even the Karen's Lexus flying is possible as an engineer. Did you know that? Do you say that with a reasonable degree of engineering certainty? Serena Blossom. How did the tail light end up in the same place as the body? When it smashed, it should have dropped in situ. No. P.S. I hate Bev with my whole being. I still am giving Bev a little bit of credit for her generous holiday schedule. You know, I like to recognize the good things about people when I see them. And so, you know, the fact that Bev is not afraid to take 5 days off so that we can all enjoy our time at the beach or whatever it is that we like to do, you know, it's a redeeming quality. I don't care if it's entirely self-serving on her part. Doesn't matter. It's all right with me. You know, I haven't heard an explanation for this either. I would imagine that there's going to be some sort of momentum at play too, right? The tail light is moving with the car. And so object in motion tends to want to stay in motion. I would think the tail light, if it breaks, is at least going to somewhat want to keep moving in the direction of the car. But if the car is not moving in the direction of the yard, then why is the tail light not over in the street where this collision is happening? If we have to get John like turning and taking steps to end up by the flagpole, the taillight pieces are not going to do that. The taillight pieces are not going to pivot off of the car, roll off of the car, and take a few steps and fall and crack their heads. So I can see some room for momentum is going to carry the taillight particles. They're not going to necessarily just fall where the break happens. But I don't see how that momentum, if you're going down the road and there's a collision and this guy spins off and ends up over here, I don't know how the tail light also ends up over there. I do not have an explanation for that. If it's going anywhere, it should be in the street behind the car. Joan Scott, is Judge Bev keeping too tight a rein on Alessi? There are so many sidebars. It breaks the rhythm of the cross. Bev's comments are insulting to Alessi. Yeah, nothing really new there. To me, she's being, over technical about what the foundation is. He testified on direct. He relied on this report. So he gets to be asked about the report, period. End of. That's enough for me. I don't know what more foundation is required. It was part of the basis of his opinion. If he is allowed to rely on the hearsay at all, which the Massachusetts rule says he's not supposed to be able to rely on it, but you're letting him testify on direct that he did, then he gets to be asked about it. The door has been opened. So yeah, my view is she's got some kind of foundational problem here that is it's incomprehensible. I don't know what the basis is. He didn't rely on it closely enough for her to think he should be able to ask questions about it. I would love to be able to tell you what's in her head, except I guess I don't really want to be in her head that much. I don't want to necessarily have that experience, but that's all I can really tell you about what I can ascertain from what's happening here. He's having to establish foundation through this voir dire to show some familiarity, some reliance on Trooper Paul's report when he already said that in his direct. So, Rhonda, Iowa girl, I hate physics and Alessi is making it sound sexy. F equals MA, baby. Talk to me. Give me some more. Honey kid, I can't wait for ARCA. You're welcome. You're welcome. ARCA is going to be a real breath of fresh air. I'm gonna enjoy that for sure. They were very, very helpful witnesses. Enjoyed them. I think that comment yesterday about calling them first so that we have such a strong counterpoint between those experts and these experts might be looking a little bit better after today. Might even be looking better after today. But does your mom deny it? Ugh, are we going to have to listen to this jackwagon again tomorrow? His "you're welcome" is just like Jen's "I'm sorry." I get "you're welcome." I get "I'll allow it." I get Bev's "I'll allow it." You're welcome. You're welcome. I, in my grace, have chosen to answer the question that I actually have no choice but to answer because I am under subpoena sitting here on the stand. But you're welcome. It is by my grace that I have provided you with the information that you sought. That's the vibe I get from it. Yeah, not only tomorrow, but maybe Friday too. Because we only got a half day tomorrow. So yeah, we might be hearing this guy Friday too. We'll have to see. Sandra, Hank is firing questions at this bozo rapid fire and Welcher is having no problem answering them. Alessi wasn't off his game. He has a difficult witness. Yeah, and that voir dire, when we were absolutely going to cut it off at 10 minutes after, and then at 10 minutes after, Brennan wants to ask some questions. So so that gets allowed. And so he does that rapid fire, and there's no issue whatsoever. Mr. Welcher knows perfectly well how to follow the lead of the party who has hired him to give testimony in a case. And, you know, a lot of that was bullshit anyway. Did you know Trooper Paul took his photos from the CERT report and the CERT report was this? And you know perfectly well he doesn't know that. He's already said that. It's not a good faith question, but that's what Hank does. That was just a chance for Hank to testify. And then, of course, you know, once he's done and Mr. Alessi wants to follow up, one question. If you're going to let Mr. Brennan ask questions, then he gets to redirect. Them's the rules. We didn't make the rules. The witness is very difficult. It's very obvious to us watching. The jury, it's harder to say what they see and what they don't because they're not seeing this voir dire. They're not seeing the distinction, the difference between how he reacts with Alessi and how he reacts with Brennan, like real close in real time, like we got to see it. Maybe they'll see it when he goes back on redirect. Sorry for the slurping there, but oh, my bad. Duncan, Idaho, do you know how long the tail light would have to be in contact with his arm to produce that injury? Well, according to the laws of physics, it would definitely have to be some amount of time. Would it? Would it? Because in physics, anything is possible. And so if, I don't know. I was going to try to take an equation and tweak it, but I couldn't come up with anything off the top of my head. I'm not that don't have a great facility with the physics equation. So it would have to be some amount of time, but would it? Because time is what? Time is what? Can we even define time? You want to get philosophical? I can get philosophical. Weed, probably owe more for my enjoyment of your coverage. Well, thank you so much for that, Weed. I appreciate the kudos and the kind words, and I'm glad that you're here enjoying it with us. And hopefully, you know, it's been frustrating, but maybe tomorrow we'll get some more laughs. I can cry. I can have hope. I can have hope. I'm not assuming or even guessing or even hoping that Mr. Alessi would be coming to my humble little channel here for his corner talk. No. But if by chance he did, I'm telling you, mock the guy. Find a way to mock the guy a little bit, simplify things, and then mock him for arguing. That's what I'm going to be trying to do. TCP, seems like Alessi needs to keep asking if he can't do something. He answers quickly when that happens. What did he ask if he can't do? I think I might have missed that. This takes us back to Rob's comment at the very, very beginning of the show today. Is there any opinion you don't feel comfortable asserting? Is there anything you're not qualified to opine on? Something like that. What can you not do? Yeah, I don't know. If that's going to a specific thing that happened, I think I missed it. But maybe if you just rapid fire things at him like Hank. No, that's not going to fix it. Young Black Economist. Hard to do probability when you don't know the difference between bias and variance. Jud defined variance as difference from true mean, which is actually bias. Yeah, I remembered that from his direct when they asked him about what variance means. And obviously we've talked in this trial so far about the clock variance. It's about the skew in the measurements, for lack of a better way to put it. But he went and defined variance as the difference between like the actual reality and then the result that you get. He's really talking about some kind of error rate or some kind of standard deviation. Like you can only get so accurate. Your answer, is within so many degrees of it. Like that's what he seemed to be describing variance as. But that's not variance. That's just accuracy. And I think, like you're pointing out, there can be bias in here. If you're supposed to get, if you do the math on the 2 + 2, and we know that the answer should be 4, but you're getting 4.5. There might be some reasons for that. Could be that your instruments are bad. You have a bad calculator. It doesn't know how to do that measurement. It could be some type of cognitive bias. If 2 + 2 = 5, it may very well be because Big Brother told you that. It may very well be that Big Brother told you that 2 + 2 = 5, and that's why you get that result. Yeah, he did not explain what variance was in a very satisfying way. Priya Rose, did we learn the max billing range or limit above 325K? We did not. We have not heard the cap. I do hope we get to hear the cap at some point, but I don't think we will because he said, "Oh, that's out of my pay grade. I don't know. I don't review it." I always try to think about, multiple ways to get things in. Sometimes you might have a backup. I wonder if they could get that in through ARCA. Do you happen to know how much these guys have been paid? And is that reasonable? Is that commensurate with the type of work that experts in this field would expect to be paid for something like this? Is the quantity of work they did commensurate with what you'd expect to be done, considering all of the work that Trooper Paul did, etc.? You might be able to squeeze it in a little bit through the back door that way. And if she says you're not allowed to ask those questions, it goes to bias. It goes to bias. You always get to impeach the witnesses for bias. They have a tendency or a incentive. They have an incentive to skew their testimony to favor the side that is paying them for it. That is very well understood and established, and it's the reason why we get to ask questions about what they're paid at all. So I think you get to explore that on cross, because if it looks like they've been overpaid, that means they have an even greater incentive. If it looks like they made up work that didn't really need to be done, that also looks like, wow, they're really just here to get paid as much as possible. So that's one possible alternative route to get there. But as of right now, we do not know the cap. Melinderp. I would think that the owner testifying that their car, the Jeep, was parked out front would take precedence over other testimony. Welcher. You can't rate the testimony. That's the whole thing. Anybody can lie, and anybody can lie under any circumstances. That's why testimony is simply trash evidence. I honestly, sometimes I wonder why we have trials at all. Like, testimony is garbage. It's garbage. And it's unfortunate, but it's just how it is. You know, we're not reliable even when we want to be, and we don't always want to be. So human reports are really pretty terrible evidence. Jenny Thomas, stop distance calculation question. If she hit the brakes on impact, the stop distance was 63 feet after this. Would be a crash into the house, the berm, the driveway, and SUV damage. Noise, why no mention? Brake before impact equals no mens rea equals different charges. Okay, so I see what you're saying here. There's a lot in here to unpack and break down. This is a very good point. Do we have his data? I don't think I screenshotted that part of his data. I just have the first trigger event that I did. I might go back and try to find it so I can look at the second trigger event. But yes, I recall there was no braking. In fact, he said there was still accelerating. The car was still accelerating at the end of this trigger event. So couple of things going on here. Yes, if that means she's accelerating, she cannot come to a sudden stop. If she's not braking during that trigger event, she cannot come to an instantaneous stop. If she's going 24 miles an hour at this point, it's going to take her time and some distance to be able to come to a complete stop. I don't know what that is, but there's going to be math to be able to work that out. So yeah, we've been saying, okay, 51 feet, I think we came up with between the property line and the front of Higgins's Jeep, roughly. And so if her car traveled at the accelerated, rate of 52, then there's going to be a collision. That's just the simple overlap. But the reality is that even if his car was, like 80 feet away, and she hit the brakes the second after this trigger event stops recording, right? So right at the end of this 24 mile an hour reading, she hits the brakes. The car is going to still move. It's going to continue to move because of that stopping distance. So we're being very generous in estimating what the crash would look like, what the vehicle path would look like, with this slight leftward, turn of the wheel. It's all quite convoluted. And then the other point you're making about the hitting the brake versus not hitting the brake affects the mens rea. It could very much. If you don't hit the brake, that could mean one of two things. That could mean you didn't know what was happening. You didn't know anything was behind you. You didn't know there was a need to stop. Or it could mean that you knew exactly what was going on, and that's what you were intending to do. You were not intending to stop before you collided with the thing behind you. So a couple different possibilities for that. But if you hit the brake, that could be indicating a mental state of becoming aware of the situation and trying to resolve it, trying to avoid that from happening, trying to not collide with the person who's behind you. So they are in kind of a, horns of a dilemma sort of problem, a pick your poison problem. She hits the brakes, that goes to her mens rea, shortens the time before there's a collision with the car. But honestly, at this point, I'm not sure that we avoid that anyway. I think the collision with the Jeep is baked in if the Jeep is there, like they've testified to. Or she doesn't hit the brakes, and you have a bigger problem with the collision. So good observation here. I like how you're thinking this through. Sandy B, measured from trees to mailbox, 95 feet on Google Maps. I don't know what the precision is for Google Maps. We've heard quite a bit about, the accuracy, the precision of these types of measurements. So, okay, that might be accurate. I'm not 100% sure that it is, but either way, we've got a problem. We've got a problem. So if the car is 20 feet long, it's the mailbox. Now we're down within 75 feet. What's our stopping distance? Is it longer than 20 feet? I'm going to guess yes. I don't know though. Inquiring mind. General bone fracture, 100 to 200 PSI, pounds per square inch. That's good information because this is incorporating that little detail that he was talking about before, which is the distribution, right? If it's a distributed load versus this is not a binary. This is not it's distributed or it's not, because we don't have, atomic level contacts happening. Every load is going to be distributed on a human body, at least to some degree. So it's how much. The question is the degree, how much. If it's over 1 square inch, it's going to be more focused. If it's over, 36 square inches, it's going to be less focused. But so when you incorporate and when you turn this into a pressure calculation, that incorporates your surface area. It's per square inch. So we know if we have 6 square inches that we're dealing with, we know how many pounds over the total of the 6 square inches we would need to get to 100 to 2,000 PSI. So if we've got a 6 square inch area, then we need approximately 6,000 to 12,000 PSI. See, if we were interested in explaining this to the jury so the jury understood, and we are actually trying to be helpful, and not just clutching desperately to your safety blanket on that laptop that incidentally he did not apparently have to get rid of. He didn't have to after all that anyway. It was still there. But anyway, you could just explain that, but that was not the objective here. Doing that conversion and doing that math was not part of the point. Sandy B, Dr. Welcher, did you read in the reports there was a car repairman at One Meadows on the 30th? Dr. Welcher, if you were to assume that there was a car repairman at One Meadows on the 30th, that would be fun to bring that in. Now, that came out of Jen's testimony, of course, and so he knows nothing about that. He's been told nothing. He knows nothing about the progress of the trial to date, except for those unfortunate emails that he's received from internet trolls. JP, I don't know if Alessi is a drinker or not, but I hope he has a drink or some cake or punches a bag or whatever helps him relax tonight. What a frustrating day. I'll definitely speak up for punching the bag. Punching the bag can be a great way to just, sometimes you just kind of need to wear yourself out, especially if you're real mad, real emotional, something like that, and you just kind of, need to reset. Punching the bag. I will speak for that. Not going to be a big advocate for taking the drink. Not going to be a big advocate for that at this point. It's I understand it's got some psychological kind of value, but it's got some downsides. It's got some downsides of taking the drink. You want to sleep well tonight. You want to be well rested. You want to be at your prime when you wake up tomorrow. You don't want to wake up tomorrow dehydrated. You don't want to wake up tomorrow and you didn't get enough REM sleep. No. I'm gonna lean against the drink on this one personally, but hey, everybody's got their coping mechanisms. So whatever makes it work. Sleepless Sleuth is a YouTube member. Welcome to the channel. Thanks for joining us. Sandy B. Green said Karen's GPS data was deleted in custody. Oh, I forgot about that. How did I forget about that? Okay. You've narrowed that down. So now I am going to go back through the last trial. Green testimony. GPS data deleted. I want to go back to that because that does intrigue me. That seems pretty significant. If that's valid, then I would expect we will hear that again in this trial. So we'll see. Alex, is there any statistical evidence that defiance on cross helps win the jury over? Sure seems counterintuitive. Thanks for entertaining me on a full day of travel. I am not aware of any statistical evidence to this effect. I can tell you that generally speaking, being disagreeable does not win you friends. It does not put people on your wavelength. People generally like to see themselves as being agreeable and being likable, and disagreeable is being unlikable. And so you're just kind of automatically putting yourself at a disconnect with the people if you're being disagreeable. Well, granted, not every single person, but a fair number. A fair number are going to see you as being disagreeable and unlikable. Therefore, not like me. Not like me. I'm very nice. And I do wonder if maybe that's a little bit of what his little "you're welcome," is trying to make up for. Like, you come off as a dick. The "you're welcome" doesn't change it. Doesn't suddenly make you look like somebody that we'd want to go have a beer with. No, I think I'll pass on that. Rob Ensign, the cross so far has been pretty bad. It was very incoherent. It was impossible to discern what he was trying to achieve, maybe for the jury also. We didn't get any big points to come out of it, did we? The biggest points I feel like we've gotten, where we got that sort of display of success from Alessi, when he's like, exactly, yes, exactly, correct, is when he talks about we didn't have enough data to do anything. And that's a good point. It's a good point, and it's one the defense can lean into, and it's one that they can use to their advantage. But it's not clear as we sit here right now how they can or will do that, because it hasn't been drawn together with the Commonwealth's burden of proof and your ability to form hypotheses and test them and rule things out and so on and so forth. So I agree, this has been a struggle, and I think that has been in part the point. Like I said, this witness is doing that purposefully. The harder you can make it to understand the jury, then the less likely that harder you can make it for the jury to understand what the defense is trying to achieve, then the less likely the jury will understand what the defense is trying to achieve. And that means if the defense has a point, they probably won't get it. So I think it's all part of the strategy here. Emotional lemonade. After weeks of precise note-taking and perfect courtroom decorum, I assume, followed by hours-long recap streams during Delphi, my heart sings every time AB sneers and tells Welcher to shut up after each "you're welcome." It's true. I did not get to sit in that courtroom in Delphi and be like, dude, would you just shut the fuck up? Nope, didn't get to do that. Well, thank you, Emotional Lemonade. I'm glad that you're enjoying this little different approach to the trial watching and the trial analysis. I said at the time when I went to Delphi, I'm not a reporter. I'm not a courtroom reporter. It's not the role I'm accustomed to or even necessarily want. I'm a color commentator. Okay. I'm here to call the shots and talk about the game and hopefully make it interesting and maybe even a little entertaining and maybe a little educational. But just to add something to the bare bones of watching the trial and, nothing else. So reporting is not what I wanted to do, but you didn't have any choice in Delphi. You didn't have any choice. If you're going to comment, you're going to need to be the reporter too, because there's no other way to get the information. We already knew the media was not going to give us the level of detail that we needed to be able to make some kind of sense out of that case. So very different context. Yeah. Called for a pretty different approach. Although, I feel like I had my say more than once doing the recaps, letting you know what I thought of all that. So I appreciate you being here. Thank you for that nice comment. I'm glad you're enjoying it. Nigel Brayshaw came upon this trial on Emily Baker channel. She seems so biased. So happy to find you, an impartial commentator. I'm swinging towards Karen Reed is guilty. I appreciate that. I try to be unbiased. You know, I try to see things from the different perspectives of what folks are doing. I want to see what's working and what's not. You're not a very good defense attorney if you don't have a good grasp of reality. If you have ideas about like how the evidence is landing with the jury that doesn't correspond with reality, you're not going to be a very good defense lawyer. So yeah, you advocate for a position, but you're typically going to do that from a perspective of like, do I think I'm going to win this or not? You know, do I think this is going to be persuasive, or is this going to be a Hail Mary? Like you have to be able to weigh those things pretty effectively. So even though my background and the way I look at cases comes from that criminal defense perspective, that's what I know. So of course, that's what I talk about. I've never been a prosecutor. I've never handled a case as a prosecutor, never run cases as a prosecutor. One of the big distinctions between prosecutors and defense attorneys that we talk about all the time, prosecutors have files, defense attorneys have clients. It's a very big difference in what your role is and what your perspective is. So that's what I bring to my commentary, but I'm not trying to like be the defense lawyer on the case. Not trying to look for any kind of justification that supports the defense case. I think the issue is I've watched this trial once already. I saw what the evidence is. And so based on the evidence, yeah, I have some of my own opinions about what that all means. But we're not trying to be an echo chamber here. You know, everybody's entitled to have different opinions, to chat about it freely, albeit respectfully. So glad to have you here. I enjoy Emily D. Baker. I think she does wonderful commentary. So Stacy LeBruno. Brennan says the property photo coming from the CERT report. I thought the jury in the first trial asked for that report and was told there was none. They were told that they can't have a CERT report because there was no CERT report in evidence. Even if there is a CERT report, regardless of whether there is or not, it's not in evidence. Therefore, the jury doesn't get to see it. So I don't think we got an answer to does a CERT report exist from that questioning, because that's not. It doesn't. You're not going to tell the jury if it does or not. All that matters is you don't get to see it. It's not in evidence. So I still, okay, I guess there's a CERT report. I am to take it from this line of questioning from Brennan that there is in fact a CERT report. Because he wouldn't ask a question without a good faith basis, right? He wouldn't ask without a good faith basis. Not our Hank. Z. Welcher says arm injuries fit within damaged taillight extent, but no details on how linear lacerations and punctures were created by which of the 47 pieces. Definitely nothing that granular. I mean, you want to talk about he won't even assign a body position to John to get us, the outcome that we had at 34 Fairview with John in that location, in that position, with those injuries, given this collision, et cetera. He won't even do that. He's going to be like, well, it depends on which toe was bearing his weight. So no, he's definitely not going to get into the level of granularity of which piece did what and how they moved, other than just holding out the opportunity, the possibility that maybe you could get a vertical cut, a vertical laceration from a horizontal movement. If a piece was like poking in a weird direction or something, I'm just going to go ahead and tell you right now, no, you wouldn't. No, you wouldn't. Because if your movement is going like this, your injury is going to also go like that. And it doesn't matter if the thing is poking this way. If the thing is poking this way, then you just maybe don't get an injury at all. But if you get one, maybe you get a different injury. You get like a scrape instead of a laceration. And guess what? It's still going that way because that's the way the motion is going. I can't believe that like there's an expert on the stand testifying to one, what is common sense stuff, but two, It's not common sense at all. The injuries are in the right configuration. Dude, no, they're not. One of them, the arm is bent. One of them, the arm is straight. Hold your arm straight like John O'Keefe's arm was held in that photo, and then back the car into you with your paint, and then see where it ends up. That would be apples to apples. Comparing a straight arm to a bent arm, it's just mind-boggling. They think we're stupid, guys. Has this been the theme of the Commonwealth's case enough yet? They think we're stupid. They think we're stupid. That we can't think for ourselves. Gosh, if a straight arm moves across a blunt surface in a way that creates lacerations, they're going to be parallel with each other in a certain pattern. Whereas if the arm is bent perpendicular, then the part of the arm where those injuries took place, the forearm, when you go and straighten that arm, they are also going to be perpendicular to the wounds you have up top. This is literally common sense and requires no expertise. It just requires a little bit of imagination and thought experiment. That's all it takes. But they think we're stupid. They think we're stupid and we can't figure that out for ourselves. Pretty wild. Z, collab with Defense, ARCA, and possibly Microdots will be fire. I mean, ARCA is definitely going to be fire. I don't know if we're going to see Microdots stuff in this trial. It was Microdots' like visual of 34 Fairview that we saw in the first trial, wasn't it? We had this image that was not a photo, and they had to like qualify a bunch of times. This is not actually a photo; it's just representative. And I'm pretty sure that was Microdots who created that, but I'm not 100% sure about that. He's definitely done a lot of good stuff on his own channel. So if they have demonstratives that he helped with or something like that, that could be pretty cool. Lee Koo, thank you for teaching me not to reply with "you're welcome" ever. You can definitely reply with "you're welcome," but consider the context. Just consider the context. Some context it's appropriate and some it's not. Sometimes when people say thank you, they don't actually mean it. We're just following a script that you use for social niceties. And it is not in your position to absolve them of the obligation. You know, this is the whole, I had a whole thing with my father-in-law recently because remember years ago, he would complain about like if a waitress comes to the table or comes by and you ask for a refill of the coffee and she refills your coffee and you say thank you and she says no problem. He'd hate that. He would it was like a trigger for him, you know. Can't stand when they say no problem. And I was thinking about this when I was down in Chile, because, you know, when you're dealing in Spanish, it's gracias and de nada. De nada, it's nothing. It's nothing. Real similar to like no problem. It's nothing. And so I was thinking about this structurally and like, why do we go through this whole script anyway? Thank you and you're welcome. And you know what I came up with is it's because of the sense of obligation, the sense of mutual obligation that you have when somebody does something for you. You have a instinct or an inclination to do something back. You have a sense that you are indebted to this person, and therefore you may owe them in the future. There's a lot of this complex ambivalence, you know, even if it's like a gift. When I took anthropology in college, we love to talk about the gift giving cultures, right? Because gifts are supposed to be free. Gifts are supposed to be free. They create no obligation, but they never are. They never are. When you throw the potlatch, even if there's not an explicit expectation that next year it's going to be your turn, everybody understands, oh, that rich guy over there, he's going to need to be giving one soon. So even when you like call it a gift, there's still that, you know, there's still that like implicit sense of it creates an obligation when somebody does you a favor or somebody does something for you. So when you say thank you to somebody, you're acknowledging you did something for me. You filled my coffee. You provided the service I was asking for. And then you saying, you're welcome. You're welcome, like doesn't even quite fit. When you say de nada or no problem, really what you're saying is you don't owe me anything. It's cool. Don't worry about it. Yes, I did you this favor, but it's nothing. De nada. It's not a problem. It's not an imposition on me. It's not something you ever need to repay. You don't even really get the full effect of that with you're welcome. You're welcome. What does you're welcome even mean? You're welcome. You're welcome to it. I give it freely. Is that where you're welcome derives from? I guess it is. I don't know. Anyway, I came to really appreciate that direct simplicity of de nada. It's nothing. So because of that, you know, I pushed back on this issue with no problem. In many ways, I think your no problem might actually be better than you're welcome. But imagine this guy up on the stand saying no problem. Oof, douche factor just turned up to 11. D Pat, I love how Alessi says exactly, even if it's not exactly what he wants. Well, he's definitely trying to make the best of a not very good situation. He's trying to get what he can out of it. And even I think if all he can get out of it is that you don't have enough data to know anything, that works for the defense. That works for the defense. No, you can't tell us with any degree of certainty what happened because you don't have enough data for any of it. That works for the defense. How is that proven that there was a collision between Karen's SUV and John that resulted in this scene, these injuries, etc.? Even if that's all he can get out of it, maybe at the end that's all he emphasizes and we get an exactly and then he sits down. I don't know. I don't know. But yeah, I think a little bit of refinement is likely in order, probably on the menu for tonight, reevaluating. And I just hope, punch the bag, take some deep breaths, all that good stuff. But just remember, it's funny. A lot of times it's funny. And the funnier it is, the more you win. So anything you can do to make this funny is going to work. It's going to work for the defense. This is just my gut, my instinct, my advice to Mr. Alessi when he comes back into the corner. See if you can make it funny. What do you guys think? I would love for tomorrow to be funny. That would be a really good time. I think we'd all enjoy that. Well, just a half day tomorrow. I got a couple things I'll look at. I'm going to follow up on that Richard Green's testimony about the GPS data being deleted, because that question has come up more than once. And so, yes, I would like to know as much as I can about that. Where did that come from? What did he rely on? Do we know? I'm not sure. So I want to look. And then also that new filing that came in, as well as the previous decision in Massachusetts where he was found to be unreliable, or his method was found to be unreliable, whatever exactly it was. Let's look into that. So we might have some stuff to talk about right off the bat when we come back in tomorrow. But guys, in the meantime, hey, try to find something funny in all of this. If you found this frustrating, if you found it aggravating, if you're like, God, I just want to tear out my hair. Imagine having to deal with a person like that. Yeah, man. Yeah. It's hilarious that there are people like this out there. Dude, it's like one of the funniest things ever, how people can behave. It really is something to behold. Like the absurdity of the universe and the human species and our place in it. you could really cry about that if you wanted to. Or you can find it hilarious. You can find it hilarious. It is pretty funny. This is why some of my favorite art, some of my favorite literature is that it's taking some of that dark, black, deep rot of the human condition that would just sink you into the depths of despair if you want to, and it makes it funny. It makes it funny. Why Vonnegut's my man. Oh man. Vonnegut took Slaughterhouse-35 and turned it into something funny. He took human evolution and Galapagos, like one of my favorite books ever. God, I love Galapagos so much. It's hilarious. It's hilarious to think about how absurd human evolution and just the way that we behave and the way that we act. You just shift your frame a little bit, which he's so good at doing, does so well in that book. And it's just hilarious. Hilarious how ridiculous we all are. We can't take it. We can't take ourselves all that seriously, guys. We're just, these biological containers doing the things that we need to do, that when you stop and think about those, God, they're pretty ridiculous too, aren't they? Isn't it ridiculous that we have to we have this hole that runs through our whole body, and we have to go out and we have to find other biological material, and we have to put it in this hole, and then we have to keep doing that. It's, I don't know why it's hilarious, but it just is. Imagine coming up with that. Let's put a hole in this thing and let's make it stuff into its hole. What a bizarre way to have life. Oh man. So, try to find the humor in stuff, because, think too deeply about human biology and you get into rotting in the ground and stuff like that, and it can be a little bleak. So just find the humor. Oh man, give me a second. That shouldn't have been so funny. I don't know why that got to me the way it did. Oh man, Catch-22, another brilliant one, taking something just very, very dark and bleak, like World War II and carpet bombing and all that stuff, and just making it, and the army and the structure and the rigidity and the stupidity of the bureaucracy, and just turning it into something hilarious. That's great art. Okay, when you can take that black stuff and transform it into something better, something more insightful, something more beautiful, something funny. That's where magic happens. So I do hope that Mr. Alessi gets in touch with his magician tonight, because you really can. You could transform this case, I think, in an instant, if we figure out how to make it funny, not so frustrating. Let's make it funny. I don't know. We'll see what we get tomorrow. So anyway, guys, it's okay. I'm pretty much okay now, but I don't know why that just really killed me for a second there. It's just funny. Humans are funny. So anyway, another funny thing the humans have to do. They have to go and lay themselves down and become perfectly still and go into strange brain states for 8 hours until they can start moving around and doing things that react with the rest of the world again. So we'll be doing that soon. And once we're done with that, once we've all lied down and gotten really still, and then entered our alternative brain states, and then returned and started to move again, we'll be back tomorrow. So that we can receive the light from these screens, on the photons in our eyes, and get enjoyment out of it. So, hey, appreciate all of you being here. Appreciate you sharing this experience with us. It can be just a great time sometimes, but a lot of it's just in your attitude. We just got to find the way to pick the right attitude. So with that, guys, I've enjoyed all of you. I've enjoyed the chat, enjoyed your comments. Thank you so much for being a part of this experience. It really is a lot of fun for everybody. Thank you for the mods, for keeping everything running so smoothly, for providing me like all these awesome links and things like that. Information as stuff comes up, letting me know when, hey, Andrea, you're not even on the camera. Andrea, you're mute, stuff like that. Just little things that tend to help the stream run a little bit more smoothly. Really count on the mods for help with all that. And very grateful for everything that they do and contribute here. Appreciate all of you. What a day. What a day. Let's just go ahead and put this one in the scorecard, move forward, see what we get tomorrow. Guys, enjoy your still time and your alternate brain state. And once you're all done with that, I hope you'll be back tomorrow. And we'll see what day 23 has, our half day. So with that, everybody, do take care of yourselves. Oh, I think there's one more here in the queue. Melissa Garcia, I feel like they forgot he was drunk. Today sucked. It's just one of the many, 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 specific things that there's just too much to account for. The accident reconstructionist is overwhelmed. He can't possibly account for all of these contingencies. And yet he can't even provide me with a single scenario where all of this works. That's all I ask. Just give me one. Give me one scenario where all of this works. So you don't even have to say it's the one, just a one that works would be enough. But we haven't even established it's a possibility, let alone a probability, even though that's what this guy deals in, according to him. Perhaps we should watch what he does, maybe a little bit more than the words that he chooses to tell us about what he does. The story he's telling about his research, his evaluation is far less interesting, I think, than what we can see unfolding in front of our eyes. So guys, with that, appreciate all of you once again. Take care of yourselves. Keep a good attitude. Find some stuff to laugh at. Get yourselves a good belly laugh. It feels great. And with that, thank you so much. And hopefully we'll see you all back tomorrow. Take care, and we'll see you then.